opportunities to help the public know that we exist. Education, again, it's, how do we let the, public know how to do this work? And it also can extend to any kind of new case law or any changes in the law, or even just, how do we go about telling people how to file go about how to make a request, and if what happens if their request isn't followed through, how to file it. And you can actually bring in our administrator in on that conversation, because she runs the office and usually is the front desk of the task force. So that's, if you're interested in that committee, you feel free to join it. Chris, happy to have you retain that chair's position. Not a problem. Thank you.
So just to be clear, it's not going to be Matthew who will be chairing EOT. It'll be Chris.
Chris, he's currently in that position, so he'll remain.
Right.
And Matt will retain the chair of the ad hoc IT committee. And again, Fiona will be managing complaints and rules. Rules meets on an ad hoc basis. It's not an ad hoc committee, but it meets when it needs to, when we have items to make changes on, whether it's our bylaws or complaint process. Usually the task force will direct the rules committee for items. It could be new policy, that we decide that we need to implement, that kind of thing. And Member LaHood will maintain the chair of the Compliance and Amendments Committee. Compliance and Amendments, compliance, obviously we refer if we want to make sure and kind of monitor compliance of a case when after a determination has been made that things are being followed through. And amendments are reviewing amendments to the Sunshine Ordinance. Okay. And maybe any other law, if there's maybe state law changed, or there's a bill proposal, ballot initiative that might change the California Public Records Act or the Brown Act, or even the Sunshine Ordinance. So there's that. Okay, with that.
I just want to make sure that I know who is participating, not just chairing, but participating on these committees, so I can get my agendas correct. So okay. For CAC, it has been Lila and Fiona and you, Bruce. You have been alternating with Josh.
I'm no longer going to sit on CAC, I think.
Okay.
All right. So then I can remain on CAC. Either Dean or Jennifer, maybe if you want to join the Compliance and Amendments, it's a great place to get your feet wet in our process. What do you think? Dean, I'm going to definitely try to direct you to the Complaint Committee. So, Jennifer, what do you think?
Sure, I'd be happy to sit in on that committee.
Compliance and Amendments?
Yes.
Compliance and Amendments.
Okay, great.
And then the rest will stay the same. That we will have an open seat on the ad hoc IT committee and on the rules committee. We don't have to take that up today since they don't meet that often. But as it comes up, just keep it in mind that there are open seats there. EOTC, there are open seats there, right?
Mm-hmm.
Okay, so there are two open committee seats in EOTC. We're all not going to be able to just sit on one committee, but EOTC right now, they could obviously start up meetings again, and just so everybody knows, all complaints start at the complaint committee. If there's an overflow, they'll spill over into either Compliance and Amendments or to EOTC. They've both been authorized by the task force to take overflow of backlog. So just so you know, it's important that they both be operational.
Okay.
So we have the three operational committees.
Okay, so
Okay.
members of the complaint committee will be Dean, Fiona. Do we have a third?
Oh, we need a third? Okay,
I can do it for now if you need help there.
Okay.
that would be great. All right, then compliance and amendments is Chair LaHood,
And you and Jennifer, right?
Member Wong, and myself,
Okay, and chairing EOT is going to be Chris?
Chris. And also Member Wong will join Chris, and we'll figure out something else, somebody else to sit on there. Okay, let's open it up for public comment. Any public comment?
Yes.
Cheryl, when you're ready.
Yeah, go ahead.
All right. This is just a comment on the membership of the IT committee. I would ask that be clarified. It wasn't clear to me who is the chair or the members, and the reason is the city chief information officer is as of last week planning to coming to that chair and asking them to schedule a hearing for the kind of the way the city is going to implement the metadata orders you made in some of my prior cases. So there does, I hope that when that happens, you do have a full roster so that can be heard by your IT committee. Thank you very much.
Okay, any other public comment? Seeing none, public comment is closed. Currently, Member Yankee is the chair of the IT committee. I sit on the IT committee also, and we can have one more. I was not calling out for a full membership right now until it needs to meet. It's something that members can join freely. They do not have to be assigned or appointed to those committees. Only the chairs need to be assigned. So we'll make sure that there's a full complement for that committee when that happens. And thank you for that notice. Okay. Since there doesn't need to be a vote for this, let's move on to our next item.
Item number 4, public comment. We're a little early for public comment.
Right. So why don't we move why don't we hold public comment until 5 o'clock and move to item number 5 if both parties are here.
Item number 5, file number 19145, complaint filed by Chris Kors against the Police Commission for allegedly violating Administrative Code Section 67.5 and 67.21 by failing to respond to a public records request in a timely and/or complete manner.
Okay. Are both parties here?
I'm here.
Who's this? Mr. Kors?
Chris Kors. Yep.
Okay.
And Sergeant Youngblood from the Police Commission Office.
Okay, great. Are you both prepared to start at this time?
Yes.
Okay.
Okay, so they get 5 minutes.
Okay, please read the byline.
On January 28, 2020, the Compliance and Amendments Committee found jurisdiction. On September 15, the Complaint Committee found the records public and referred the matter to the Sunshine Task Force.
Thank you.
Um,
Okay. All right. So the Complaint Committee Chair, do you have any, or anybody who was on that committee?
I don't think Matthew. I don't think we Matt. I don't think we had a lot on this particular one. I'm having trouble recalling it right now, but I don't think we had a lot. Anything stick out?
Okay. Very good. So let's start the process. just for our new members, and for everybody's edification, our process for the hearing is the petitioner who brings the complaint forward will have 5 minutes. And I will ask for any persons or witnesses to provide any additional information or evidence. Then the respondent will have 5 minutes to speak. I'll ask the same question for any persons or witnesses providing facts or evidence for them. In those, for the additional persons, if they speak up to support either of the parties, they become a party to one or the other side. After that, the task force will go into its discovery phase. It will ask questions and clarifications of the parties. And then after that, the respondent first will have 3 minutes for rebuttal, and then the petitioner will close the process with their 3 minutes of rebuttal. The task force will then go into a debate period where we'll see if determination arises and if there's an action to be taken at that time to create an order of determination. Once the action is taken, then the matter and the file will either remain open, depending upon other issues, or will be closed. Okay, so let's start with our petitioner. And Cheryl, when you're ready.
I'm ready.
Okay.
Go ahead, sir.
Brooks.
On March 6, 2019, I had a hearing before the San Francisco Police Commission. After the hearing, I received both the transcript and audio recording of my hearing. Upon the transcript and audio recording, I noticed dialogue missing from both. Page 3 of the transcript documents that the hearing started at 8:23 p.m. Page 16 of the transcript documents that the hearing concluded at 8:50 p.m. Therefore, the hearing officially lasted 27 minutes. However, there is only 20 minutes of recorded audio, which contains anomalies. An example of an anomaly occurs at 11 minutes and 38 seconds into the recording. You hear my attorney, James Lassart, getting cut off mid-sentence. James says, he is, ... Then there's a pause, then a sound blip, then it awkwardly goes into questioning by a female voice. This occurs on page 10, line 21 of the transcript. Here's the playback.
By the way, he's not on any paid status. He's,
The anomaly is where the dialogue is missing. Another point of concern I have is in the last 15 seconds of the first audio recording. Page 15, line 18 of the transcript is where this occurred. I believe the deliberations were to be on the record and the transcription was required to be contemporaneous. But the deliberations were off the record and the entire transcription may not have been contemporaneous. It's virtually impossible to have a contemporaneous transcription if the court reporter isn't physically present. Either Sergeant Ware or the commission president at the time, Robert Hirsch, shares the same concern. Here's the playback.
You're looking at 3 to 4 years. And just, but even if he
excuse me, we need to have the deliberation on the record.
Okay, so even if he wins the appeal. Oh wait, aren't we on the record? No, we're not.
And that's the end of recording 1. We have no idea when the court reporter actually stepped out or when she returned. However, the transcript never documents the time she left or the time she returned. Due to this break in continuity, this hearing actually had to be broken up into 2 separate audio recordings. However, we believe it should have been 1 continuous recording with no breaks, cuts, or anomalies. We only had the audio recording forensically analyzed, and unless we obtained the digital original audio recording of the hearing and the court reporter's edited and unedited contemporaneous transcription notes, the forensic results will remain inconclusive. We are requesting the SOTF's assistance in obtaining both. We are also asking the SOTF's assistance in finding out when the court reporter actually stepped out and left the hearing. I'm asking the SOTF's assistance in obtaining the reporter's edited and unedited contemporaneous notes before she left in the middle of the hearing. Over the past several months and several emails, I have asked the San Francisco Police Commission to provide me the rules, policies, and procedures that the court reporter Anna C. Greenlee was required to adhere to, but they still have not provided this information. I'm requesting the SOTF's assistance in obtaining this info, as well as the audio recording that the court reporters took of the hearing. On February 5th, I received an email from Sergeant Youngblood saying that there are no chain of custody logs for the jump drives that contain the audio recording of my hearing. On March 2nd, I sent an email to Youngblood asking important questions. Since the chain of custody logs do not exist for the recordings, including the jump drive, who had access to the recordings and jump drives? Are there policies and procedures in place to ensure the integrity of the jump drive without a chain of custody log? The Commission has not provided me answers to these questions. I am asking the SOTF's assistance in getting these questions answered. The dialogue that is missing from the altered transcript and audio recording influenced the Police Commission's decision to terminate me, which simultaneously made me a member of the public. To say I don't have access to the original recording because I'm a member of the public, when that same recording influenced the Commission's decision to make me a member of the public, is absurd. By the time the recording was complete, I was already terminated and a member of the public. Therefore, I could have never requested this recording while still a police officer. But just using plain common sense, to claim that I can't get a copy of a digital original audio recording of my own hearing is crazy, especially when I'm the one requesting it. The San Francisco Police Commission has the discretion to disclose the evidence that we are asking for. I'm requesting that the Commission use their discretion to provide us that evidence and transparency so we can bring closure to this matter. If they don't, we're asking the task force for assistance. Thank you.
Thank you. Just a point of order here. Cheryl, there's a lot of background noise from open telephone lines. Can you mute those, please, and give the instruction on how to unmute when time is right?
You still hear it?
Yes, and there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 lines that are open.
My phone is
Give me one moment. I'll unmute the callers at this time.
Thank you.
And I believe it is *6 to unmute yourself when you are ready to speak. But I will double check that myself with my phone momentarily.
Yeah, my phone is on. It's not. It's.
Okay, no, Victor's doing it. Thank you very much. Okay, let's continue. Are there any persons or witnesses providing facts or evidence on behalf of the petitioner? Okay, hearing none. Respondent, you have 5 minutes.
Hello, you there? Respondent?
Sergeant Youngblood?
I may have muted them if they did call in, but I believe if you dial *6, you can unmute yourself. I'm going to double check that right now.
I just
Sergeant
dialed
Youngblood?
*6. Can you hear me?
There you go.
All right, Sergeant Youngblood.
So Chris Coors requested his audio recording from his termination hearing on September 13th. And on September 13th, he was supplied the recording of his termination hearing because he was a former police officer asking for his personnel records. He was not given this audio recording as a member of the public because it is not a public records request. It is an officer requesting his personnel records with which we have supplied him. And that is it.
Okay, is that the end of your testimony?
Yes.
Okay, thank you. Are there any persons or witnesses providing any evidence on behalf of the respondent? Okay, hearing none. Members, the item is now with you. Any questions for either of the parties this time? Provide any additional evidence or clarifications?
I have a question for the respondent.
Member LaHood?
Yes. If I had requested the same file, how would you have responded?
We would not have been able to supply it to you because it is a police personnel record.
Thank you.
I have a question, Sergeant Youngblood. Under what statute is that record protected by?
832.7.
Of what code?
832.7 of the government code.
Okay, thank you. And you stated, but you stated as your reason for not providing it, not that, but you had stated that that he didn't make a public records request. What constitutes a public records request for the police department?
I'm sorry, you said that I did not give it to him based on, is that what you said?
Yeah, your testimony just now said that at the very end of your testimony, you stated that this was not a public records request. This was a personnel request. What classifies it as not being a public records request?
Prior to releasing this, Mr. Kors called the commission office and I spoke to him personally. He told me what he was looking for, and I told him that we could give it to him based on it being a personnel record of his former employment. During that conversation, that was understood that I knew who he was, I knew what he was asking for, so that's what we released it under. If he had asked for it as a public records request, saying that he was a member of the public, then we would have had to deny that request.
Okay, thank you. Any other questions, members?
This is Member Yankee.
Go ahead.
So I think the issue here is not as much that the complainant didn't receive it, but that he believes he received an incomplete version of it. So I was wondering if Sergeant Youngblood, you could speak to the allegations by the complainant that portions of the audio seem to be missing. Is there another version that would have those portions of audio that are not missing, or is it missing entirely?
There is no other version. He has been given a copy of the original.
Okay, if there isn't any other questions, members, then shall we move to rebuttals? Okay, let's move to rebuttals. Okay, Sergeant Youngblood, you have 3 minutes for rebuttal.
Go ahead, sir.
I have no rebuttal.
Okay, the respondent has no rebuttal. And the petitioner, Mr. Kors, you have 3 minutes for rebuttal.
Go ahead, sir. No, go ahead.
Hello, am I off mute?
No, you're off mute. Yes, we can hear you. Go ahead.
Okay. So I guess what Sergeant Youngblood is stating is that what he has provided us is a digital original. Is that correct, Sergeant Youngblood?
Well, you can't ask him directly.
Okay.
You can pose the question to us, and we'll discuss it in the next part of this process.
Well, what I'm requesting is the digital original of my hearing, the audio recording. And if we have the digital original, we can forensically analyze that to find out exactly what happened to that audio recording. Right now, we don't believe we have the digital original. From the forensic reports that we've generated, that we don't have a digital original, and that's what we're requesting, and that's in the evidence packet as well. To say that I can't obtain a copy of my own hearing because I didn't request it in the proper fashion, or I'm not sure exactly what Sergeant Youngblood is trying to state here, but I guess I have to request it as a former employee instead of a public records request. And I mean, let's just cut to the chase and just give me what we're asking for. Provide us that transparency so we can determine what happened to the transcript and audio. If we could get the recording that the court reporter took of the hearing, that would be great. Getting her unedited notes before she stepped out of the hearing, that would be great. We need that. We need that to move forward. Right now, there's a 7-minute discrepancy, and that needs to be addressed. The deliberations should have also been on the record. That also needs to be addressed. So there's so many things here that need to be addressed, and right now, through laws or that Stacey Youngblood is quoting, you really just got to do the right thing here. And the right thing is just provide the transparency. Just use the moral compass and move on from there. That's all I have.
Okay, thank you. Members, time for us to discuss. And you can feel free to add, if there's anything that pops up for you that you feel you need more clarification on, you can ask either of the parties.
This is Member Yankee. I guess I'll ask the question because it was just brought up. Maybe Sergeant Youngblood could address the fact that it appears that there were some off-the-record deliberations that occurred, and if those were included in the audio, or if you could speak to that to a certain degree, because I believe that is in the transcript that was provided as an attachment, that there was some type of off-the-record discussion, and on the audio recording we heard some voice say that the discussion needs to be on the record. So if you could perhaps speak to that.
So during closed session, when the police commission goes into closed session to discuss whether they're going to terminate somebody, the termination is done in closed session on the record. Once the commissioners are going to deliberate, the court reporter is excused because that is not part of what is on the record. The commissioners discuss what they're going to do, and then they come back, the court reporter, they go back on record, and then that vote is stated in closed session. But the deliberations themselves and what they're talking about, what they say, is not part of what the court reporter takes down.
So is that gap in the transcript that the complainant has brought up, is that a portion of the meeting that was in closed session?
I can talk to the recording that he played a second ago. Is common that the commissioners will go into the deliberations, and then they're kind of anxious to start back up again, and they'll start, and then we have to stop and say, wait, we're not on the record. We have to get the court reporter out before we go. So, I mean, that's common, but it's not that there's anything missing. The court reporter would come out, and when we would start again, if any information was supposed to have been on the record that wasn't in the set, but it's usually stopped within like a second or two, either by the city attorney who is sitting in the room, or the secretary, or the president of the commission.
Okay, I have a questions, Chair Wolf. So you first claimed that this was not public, but this meeting was being held in a officially agendized police commission meeting, and it was closed session thereof. Did the police commission recess to have this meeting, or was it part of the actual police commission agenda?
It's part of the police commission agenda where they go into closed session. We have the termination hearing, and then they go into deliberations, and they talk and they go off record, and then they go back on record after deliberations to give their decision.
Oh, okay. All right. Okay, thank you. All right, members, I have, at first I was thinking to myself after listening to the testimony from the respondent, where he stated that this was part of personnel proceeding and that the information was not public. I had to go back to the, since we don't have a memorandum, we don't have any legal memorandum on this one. But going back and just from my review, there are specific requirements for closed sessions under the Sunshine Ordinance Administrative Code 67.8-1. I'll state that for the record since we don't have it in writing. All closed sessions of any policy body covered by this ordinance shall be either audio recorded or audio and video recorded in their entirety, and all such recordings shall be retained for at least 10 years, or permanently where technologically and economically feasible. Closed sessions recordings shall be made available whenever all rationales for closing the session are no longer applicable. Recordings of closed sessions of a policy body covered by this ordinance, wherein the justification for the closed session is due to, quote, anticipated litigation, unquote, shall be released to the public in accordance with any of the following provisions. 2 years after the meeting, if no litigation is filed, upon expiration of the statute of limitations for the anticipated litigation, if no litigation is filed, and as soon as the controversy leading to the anticipated litigation is settled or concluded. Paragraph B, each agenda item for a policy body governed by this ordinance that involved existing litigation shall identify the court, case number, and date the case was filed on the written agenda. For each agenda item for a group covered by this ordinance that involves anticipated litigation, the city attorney's office or the policy body shall disclose at any time requested and to any member of the public whether such anticipated litigation developed into litigation, and shall identify the court, case number, and date the case was filed. Okay, so I think first we have to, before we dive into the content or the reason for withholding of the information and the classification as the respondent had noted under Government Code 832.7. I think we have to consider first the whether Section 67.8-1 was complied with, considering this was happening in a duly agendized police commission meeting. It was not, say, the meeting had recessed and they were calling for, a separate type of meeting that was not part of the regular agenda, or not. There was an ability not to provide such a recording or what have you. It could have been in like an internal meeting of some sort of the department. So I think we need to consider this section first.
Sorry, Chair Wolf, can you repeat what section that is again? The number?
Yes, section 67.8-1. And the title of it is Additional Requirements for Closed Sessions.
Thank you.
Chair Wolf, I have a question.
Sure, Member LaHood.
So I'm also looking at section 67.12, disclosure of closed session discussions and actions. Is that relevant at this point, or not until we determine whether what the part of the meeting that was discussed was properly in closed session?
Well, I think it's considering the respondent had testified that they felt under Government Code 832.7 this recording was protected. we have to determine whether that has precedent over 6712 as far as disclosure. But I go back a little bit and look at 6710, 67.10, and look for the permitted topics. I think first we need to determine whether to close. First we need to determine the closed session and if it was recorded in its entirety, and then two, under whether the recording was permissive to be released, and then three, I would say 6710 to determine whether the closed session was accurately implemented. If you look at subsection B, which talks about employment, and then we can go to, after we determine all that, or get some clarity on that, then we can move towards the other parts, the disclosure part.
I have a question as well. Were we provided the agenda for this police commission meeting as part of the packet? I don't recall.
I think that was Member Wong. Let me see. I wasn't sure that I saw one either.
I assume, again, this is Member Wong. I assume that if we had that, that would give us at least like the reason for the closed session somewhere in that agenda.
Yeah, would it be? Yeah, that would be. What's important about that is just the reason, because there's a section of the ordinance that speaks to the and the description. Exactly. Requirements of that. I'm just scrolling through here and not necessarily seeing a police commission letterhead yet. If any of the parties know that they submitted a copy of the agenda, please speak up and let us know where it is.
Are you asked? Am I off mute?
You are off mute. Yes.
Okay. I have the agenda right in front of me. Is that in any way helpful?
Well, is it in the pack? Did you submit it for the record?
The agenda?
Yes.
No, I don't believe I submitted the agenda as any evidence.
Okay.
Oh, you're talking about that night of my hearing, or this agenda?
Yes.
Yes.
No, but that night of the hearing.
Oh. No, but I believe we can get it off of SF.gov TV, that site. I can try to pull that up if it's helpful. I don't.
This is Member Yankee. I was able to find the agenda online through the SF.gov Police Commission website, and it's item number 8 for that day on March 6th, I believe it is, 2019. It's an agenda item for closed personnel exemption.
Can you read the description?
Sure. It says there's 2 items under it. Item A says personnel exemption. Pursuant to Government Code 54957B1 and San Francisco Administrative Code 67.10B and Penal Section Code Section 832.7, hearing to sustain or not sustain disciplinary charges filed in case number ALWIAD 2015-0358, discussion and action to decide penalty if necessary, or take other action if necessary, discussion and possible action. And then item B is personnel exemption pursuant to Government Code Section 54957B1 and San Francisco Administrative Code Section 67.10B and Penal Code Section 832.7, status and calendaring pending disciplinary action or disciplinary cases action.
Okay.
That's all that is listed for that closed session.
Okay. It went by a little quickly, but they stated Administrative Code 67.10. So I would urge you, if you have that, please open your Sunshine Ordinance and make sure you are familiarize yourself with that section. I also want to note on page 1010 of our packet, which is in the respondents section, there is a public records request form, and it states public records request. It is produced by the San Francisco Police Department. It's dated January 22nd, 2020, and this was a public records request by Mr. Kors. And Mr. Kors actually, in it, he has an original public records request, and it's in the subject line. It's on dated September 13th, 2019, at 12:17 p.m. And it actually states Stacy Youngblood wrote, colon, and then has the kind of a pasted version of Mr. Kors' request. And in the subject line, it states public records request, colon, P as in Paul, I think it's 009021-091319. And it says, body September 13th, 2019 via ckors@gmail.com, Chris Kors, San Francisco, California, public requests, public records request dated September 13, 2019, and the same reference number. And then there's a message from, it says, Dear Chris Kors, San Francisco Police Commission received your Public Records Act request, dated September 13th. On September 13th, you requested, greetings, Police Commission. I would like a copy of the audio recording of my termination hearing that took place in room 400 in City Hall at 8:23 p.m. on 3/6/2019. Please let me know how and when I can pick it up. Thank you, respectfully, Chris Kors. And then underneath that, it says responsive records are available via San Francisco Records, Public Records Center. Click on the link below to view your request, so on and so on. So this was a communications with Mr. Kors in response to, it looks like Sergeant Youngblood had submitted this. I'm not quite sure how all this is working, but it is pretty clear from Mr. Kors' original request that it's a public records request, as he states it. And then the response here is from Sergeant Jamie Campbell, the officer in charge of the police commission at that time. So I'm kind of thinking that as far as this being claimed a public record, it's public record. The request was made as a public records request, not a personnel request. And just so for everybody's edification, 6710, closed sessions, permitted topics is the title. Under B, to consider the employment, evaluation of performance, or dismissal of a city employee if the policy body has the authority to appoint, employ, or dismiss the employee, to hear complaints or charges brought against the employee by another person or employee, unless the employee complained of requests of a public hearing. The body may exclude from any such public meeting and shall exclude from any such closed meeting, during the comments, a complainant, any or all other complainants in the matter. The term employee is used in this section shall not include any elected official, member, or policy body, or applicant for such a position, or person providing services to the city as an independent contractor, or the employee thereof, including but not limited to the independent attorneys or law firms providing legal services to the city for a fee rather than a salary. Now, I seem to remember, and it may be in the Brown Act. As you may know, the Sunshine Ordinance is somewhat an enhancement of the Brown and the California Public Records Act. All provisions of both of the state laws also apply, and we have the authority to make a determination based upon that too. But I was under the impression that if a employee who is going through such a hearing, a disciplinary or a dismissal hearing, if they so choose to have it be heard publicly, that they could. Now that has to be invoked. And in this case, it doesn't seem like it was, and I can't necessarily find the section in that. So it's not applicable at this time because that wasn't being claimed, but I just thought I'd mention it.
Sure, Wolf, if I could just ask the Sergeant Youngblood a quick question here.
Sure.
Sergeant Youngblood, is the transcript that was released to the complainant, is that the transcript from the closed session?
Yes.
Okay, so he did receive the transcript from the closed session, and that's, I think. So I think
okay.
I think the what the complainant may be saying is that he believes a part of what he received was missing. Not that he didn't receive the closed session, but that for some reason a part of it was of the recording was deleted out. So I'm not sure this is really as much of an issue about the closed session, because it sounds like that what at least what is claimed was in closed session is being released. I think the potential issue from the complainant's side is that there's a part that's missing, even though the respondent is saying that they've turned everything over. Like a deleted part of the tape, make kind of reminiscent of the Watergate tapes, it sounds like.
So Sergeant Youngblood, I just want to get a little more clarification here, and despite whether we've heard the tape itself, and I'm only relating this not in content or context of the tape itself, but I want to ask with regards to in relation to Administrative Code 6710, and that recordings shall be made in closed session in their entirety. Not 6710, 67.8-1. That video recorded in their entirety. Was this? Was there at the closed session? Was it completely recorded? I think you mentioned that there was some sections that were not.
The entire closed session is recorded, except for the deliberation.
Okay, so how do you account for it not complying in 67.8.1? Is there some other section of law, or is there some policy that you folks have on that?
Are you asking? So, are you asking is the audio recorded or the court reporter recording it?
Well, the law states that it shall be either audio recorded or audio and video recorded.
No, I understand that, but right now you're asking about it recorded. Are you asking, was it audio recorded or the court reporter recorded?
I'm
Because the
asking
court
if
reporter was asked to be taken out of the room. So the court reporter leaves the room, so that part is not recorded by the court reporter, the deliberation.
I understand that, but the law does not require a court reporter. The law requires that it be audio recorded at bare minimum. So
And
there is audio recording of the closed session, where it was the entire closed session, including the deliberations, recorded in audio.
I would have to look and see.
Okay, that would be that would help determine what because you're testifying that the deliberations were not recorded, correct? By the court reporter.
Correct.
But what we're asking here is if the deliberations were recorded by audio.
Yeah, I was not there the night that it happened, so I will have to go back and find out.
Okay. Thank you. All right, members. How should we proceed? You can ask more questions, or you can deliberate between us at this time. We're trying to formulate an action.
This is Member Yankee. I think the question you just asked, Chair Wolf, was extremely, on topic here, is because if there is a section that was not audio recorded, which doesn't sound like we have an answer to, that would seem to possibly be a violation, but it doesn't seem like we have confirmation on whether or not there was a section of audio that is or is not missing.
And so, shall we take some action on that?
Well, I mean, I'm not sure if it would, potentially make sense to continue this until we can get confirmation from the, police commission about whether that was or was not part of the audio recording. I don't know if other members have some ideas.
Well, the idea is to come to some conclusion. So if we don't have all the information, then we need to figure out how do we proceed forward.
I'd like to speak to a question that Member Hood asked about the distinction between what would happen if she had gone and made the request as a member of the public. I feel like the sense I'm getting here is that we're basically looking from the perspective of a member of the public as opposed to somebody looking into their own personnel issues. And I think that even if Mr. Coors made a request as a member of the public, he was also making a request as a former employee, and those are two different tracks. And I don't know if it's the job of the Sunshine Commission or the Sunshine Task Force to be pursuing employment records, especially the type of employment records that are not public records. So that's something that strikes me about this case, is that I just don't know if that's a track that is part of this jurisdiction.
Well, I think the part that was Member Schmidt. I think the part here is leaving out the content of what is being recorded, whether it's personnel or otherwise. I think my point around just focusing on 67.8.1, the fact that somebody, whether it is a party that or a member of the public, or even if this was able to be disclosed publicly based upon 67.8.1, there's a whole It's very explicit on how it can be released. The point that there are missing, that we have now heard it, okay? So now it's evidence in this case, and it has been, and then the transcript is in our packet. It's been submitted as part of the record for this case. That there are obviously missing parts. We've also heard testimony from the respondent that the court reporter had left the closed session during deliberations, but that doesn't absolve or allow the policy body here, the police commission, from continuing with the recordings. The deliberations are part of the recording of that closed session. If this was an internal, some sort of, meeting of some sort or review that was not part of a policy body, then we wouldn't be having this conversation, because that was internal type of process. This is now a public process because the police commission has to make this decision publicly. They can have their deliberations and other items of discussion as per the law in closed session, but under the Sunshine Ordinance, there must be this recording of the closed session, and it must be retained as described. Here it says at least 10 years, and that's capitalized in the ordinance, in the law. It's capitalized, the word 10. So to make it very clear on what the retention is for this recording. But it can be, it has to be retained it has to be retained, so nonetheless. So I'm looking at it, I'm trying to kind of split the issue here. One, there's the compliance with the ordinance just for any closed session, okay? And now we have evidence, and the part of the complaint that's being brought to us is the missing parts of that recording. And then the other part is whether the actual item is disclosable or not, because it's a personnel issue based upon what Member Schmidt and Member LaHood are bringing up with regards to those factors. So,
Chair Wolf.
Yes.
So I think these are all very interesting questions. The issue is the task, and whether it's whether they should have kept a complete recording, and whether this is or is not the complete recording are interesting questions. But if in this forum a member, if a member of the public makes a public records request, and if any other member of the public, in not receiving a recording, or if it would have been appropriate to deny the recording request of any other member of the public who is not the person requesting their own personnel information, if that would have been appropriate, I don't know that this is the right forum for us to discuss whether his receiving an incomplete recording is valid. Because if we would determine something else, if someone else had asked the question, to me it seems like this might not be the right place. But I'd like to hear what others think.
So this is a jurisdictional question, then?
Yeah, I think it's a jurisdictional question.
Okay. Member Wong?
Yeah, I have kind of a question around that, in that in our agenda, we're supposed to be addressing a violation of section 67.5 and 67.21. Is it possible for the task force to find violation of a different section during our meetings?
Yes, it is. If we find it apparent based upon the complaint that another section might apply. So here, the complaint, and we heard it through the testimony of the petitioner, that there was missing sections of the recording. And in the requirements for actually recording a closed session, if the audio was not recorded in its entirety, then that would be a violation of that section.
Thanks.
This is member. If I can just kind of piggyback on what member LaHood said, I seem to recall we had a somewhat similar case, not with a closed session, but where someone was requesting personnel files, I believe, in a prior task force meeting. And I think we had a discussion about how those personnel files may be a public record, but not disclosable to all members, but may very well be disclosable to that particular member of the public if they happen to be the party whose personnel file they're requesting. So I'm not sure that maybe this case would be somewhat similar where we still do have a public record, in this case the recording, but it may not necessarily be disclosable to all members of the public, but may very well be disclosable to the one member of the public who was the subject of the disciplinary action in that closed session.
Okay. The respondent had cited for this part Government Code 832.7. Actually, that section is, you cannot find it right in the government code. It is extracted and actually probably noted, it's noted somewhere else.
Excuse me, this is Sergeant Youngblood. I'm afraid I have to leave this call. Yes, I have to leave this call.
Okay.
Okay. Right. I am going to begin the police commission meeting, so I'm afraid.
Okay. Members, what should we do?
Thank you.
If you feel there's more discussion that needs to be made, we're now going on 15 minutes for this item. I would, if there's more questions, then I would suggest that we continue.
All right, this is Member Yankee. I would move to continue and to ask Sergeant Youngblood to confirm for the next time this is heard whether or not there is any audio portion of the closed session and specifically of the deliberation that was not recorded. So I think we need to hear confirmation on whether or not there is any missing audio. So I think it would be helpful for picking this back up.
Is that a motion?
Yes, I'd move to continue with that request to Sergeant Youngblood.
Is there a second?
I'll second, and I wonder if it's appropriate to suggest that we make a request of legal counsel to look into the issue that it's sort of a jurisdictional issue, whether personnel records, which are really only available to them, are something that can be sought in this forum.
Well, the legal counsel is here. Would you like to ask them?
Yes, I'm not sure what the appropriate, if they need a written request, etc. But I think it's the kind of question that we've been told we need to now make a request for guidance.
Okay. Before I allow DCA Price-Wolf to speak, we are having a severe echo.
Yeah, I don't know what to do about it. Victor?
I'm meeting people who are not speaking at the moment, and we'll figure out who's doing it.
Oh, Cheryl, it's you. Nope, it's not. Muted. Testing? Okay, there. Maybe it was Dean. Okay, go ahead, DCA Wolf.
Can you guys hear me?
Yes, we can. Go ahead.
Okay, great. I'm happy to look into that, Member Schmidt. I think what's helpful for me is oftentimes, as we talk about these issues, they morph in our head. So would it be helpful is if you wouldn't mind writing down the exact legal issue. I mean, I can write down what you just said, but just so I could have it on paper and confirm with you after the fact, okay, this is the issue. You know what I mean? You often find when talking about legal issues and you write it down, you can actually refine your thoughts. So I'd be happy to look into that.
Okay, great. Also, I am having a lot of trouble finding this section 832.7.
It's the penal code. He quoted it wrong. It's not the government code. It's the penal code. That's probably why I couldn't find it.
Yeah, okay.
Yeah. It just says personnel records of police officers are confidential.
Oh, okay. Right.
More artfully than that. But.
If it's appropriate, I would be happy to write out a presentation of issue and submit it. Maybe I could circulate it first if anyone else wanted to.
You don't need to. You can just forward it to our communications channels to send it to Cheryl. And then Cheryl, you just put whoever needs to see it, and she'll deliver it. That way we have a paper trail of communications. And then also, Member Schmidt, I would suggest that you have asked DCA Wolf for some analysis of 832.7 with regards to whether a recording in a closed session for a policy body to make a decision about employment is considered publicly disclosable or not. Either way, our job at that point would be to try. We're at the point now whether is this a public document that we can comment on, and two, we also have now some evidence that the implementation was not done correctly, possibly not done correctly, as far as the recording of closed session. And so that's more of a procedural issue rather than a contextual issue of whether the records are supposed to be publicly disclosable or not. So those 2 points. Thank you. All right, let's take public comment.
Can I just chime in for a minute or two to maybe help frame the issue too? Just food for thought, Member Schmidt. You can take it or leave it.
Yeah.
But the way I see this framed is that I think, yes, it's a public record, but there are some significant exemptions in statutes from disclosure. And a very significant one is personnel issues, personnel matters. And then so I feel like the rubber meets the road here where you have the individual who's the subject of the personnel issue also making a request. In other words, the point of having an exemption for personnel records is to maintain the privacy of the employee. But here you have the employee asking for the records. So there's a decent argument that is that really at issue, right? So I guess what I'm trying to say is you were bringing up the point that isn't this sort of like an employment issue that would be on a separate track, maybe in like discovery, it's a document that you would get. So I think that's a valid way of thinking of it too. But I just wanted to take a second and reframe it as, yeah, it's a public record, but really how does the exemption play into this for disclosure?
Great, I like that. That sounds good.
Okay, we can talk. We can exchange email too. Sure. Further refine it. Okay.
Right. Okay. Now let's take some public comment.
Yes.
Okay, Cheryl, when you're ready.
Anonymous?
Hi, this is Dentist Odessa.
Sorry, which one of us do you want to go first? Anonymous or Dentist Odessa?
Go ahead, Anonymous. You spoke up first.
Okay.
All right.
Go ahead, sir.
Let me know when my timer's. All right.
Go ahead. Go ahead.
Thank you. I would agree with your DCA's analysis. This is definitely a public record because it is a writing about the conduct of public business retained by a public agency. And so you absolutely have jurisdiction over the case. And really the question is it disclosable or not to this particular person under Penal Code 832.7A1? However, I would also agree with your chair, because the complainant originally cited, they did not cite 67.5 and 67.21. They did not limit their complaint in that way. I assume the administrator has kind of taken that from the complaint. The complainant originally cited in their complaint merely checking the boxes public records and public meeting violation. So I do believe it is in your purview to eventually address whether there was a 67.8-1 violation of whether or not they actually recorded the entire meeting. And that's it. Thank you very much.
Okay, Mr. Tedessa?
Hang on.
Hello, Ms. Denta.
She's resetting the clock. Hold on.
Yeah, go ahead, sir.
Go ahead, Mr. Tedessa.
Hi, hello, Sunshine Task Force members. My name is Denta Tedessa. This is a similarly eerie complaint, just like mine, back in 2017 and 2018. Unfortunately, as opposed to my hearing regarding the city attorney's office and the disclosure by chief city investigator George Cothran of my 5-year ban from riding the SF cable cars, when he gave that information, which was privileged, which was regarding a closed session, to my housing coordinator, who then released it to the press. It is very clear to me that the ongoing complaints I'm hearing echo exactly what happened to mine. Unfortunately, mine didn't even get the time of day. The January 2nd, 2019 hearing against the sheriff's office, in which the exact same issue happened live. It happened while the hearing was going. They actually called ACC and had my service animal taken away, and I had to interrupt that hearing because of that. I went back to the audio, there's no audio. I went back to the meeting minutes for the record. There's no meeting minutes saying that I had to leave the meeting, the Sunshine Task Force hearing on January 2nd, 2019, because of this. Why? For Mr. Malloy, I wish you good luck, but they will come up with all kinds of excuses of not releasing something as sensitive. Obviously, there's something there that they don't want to release. You're not going to get it. You are not going to get it. They will hem and haw. They will bring on all these privilege exemptions, this and that. And when I ask for the same thing, I can't even get a hearing. I can't even get a honest, fair, balanced hearing on this on the subject. So the city attorney's office, the police department, all that, it's corrupt. It's basically corrupt. And for anybody who's listening, do not file police reports. Do not file police complaints against the police. You know what happens? Because you file a police complaint, that complaint becomes privileged. It becomes an investigation, and it's used to then withhold any kind of information for you, even if you are the complainant.
Mr. Tedessa, your time is up.
That's it.
Thank you.
And thank you for giving me a 30-second warning. Bye-bye.
Thank you. Any other public comment?
Yes, I'd like to make a comment.
Hold on a moment, please. And Mr. Tedessa is correct. Cheryl, you need to notify the speakers in 30 seconds.
Yep.
Please.
Yep. Okay. And is this another anonymous caller?
Yes. Can I go ahead?
Yep. Go ahead.
Okay. I just like to say that while this may be an employee-employer matter, if the complainant filed a public records request and the SFPD gave the records to the complainant without telling the complainant that he had to, submit an employee records request. I think they waived their privilege of, having it being strictly an employment matter when they released the records to him. And so then it's, and under my opinion, it is within the purview of the Sunshine Ordinance Task Force. And I'd also like to note that the Police Commission has a major problem with how they conduct their closed sessions. Because under the Brown Act, after closed sessions end, they're required to, notify the public that they have, completed the closed session. They're sort of supposed to give like a summary of what happened in the closed session, and they don't do that. They consistently do not do that. So, there's something going on in their closed sessions, and it's a problem. Right? I mean, maybe nothing's going on, but still, they're not conducting their closed sessions the way they're supposed to. And they should, even if really nothing's happening. So that's my comment. Thank you.
Next speaker, please. Okay, seeing no other public comment, are we ready for a vote? Was there somebody else there?
Somebody else?
This is the complainant. Can I make one quick comment? Am I allowed to do that?
No, the process is done there. If the task force decides to continue the case, then we may have more discussion next month. Okay, members, are we ready for a vote? Okay, please call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey? Member Hinsey?
Just a moment. Just trying to unmute.
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to continue the matter passes.
Very good. Thank you.
Okay.
Please, let's go back to item number 4, please.
Yes, just a moment. Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay. Public comment. Any speakers for public comment?
Yes, this is Dante Tedesco.
Okay. Cheryl, please reset the clock.
Second. Just a second. Go ahead. Hello? Public commenter?
Yes.
Go ahead.
Cheryl, can you hear me?
Yeah, yes. Is this Dante Tedesco?
No, this was Mr. Malloy. I was trying to make a public comment about
Go right ahead, sir.
Cox's case, but you guys aren't hearing me or something, so I guess it's passed. I'm done.
We are taking public comment at this time. Please proceed with your public comment.
Mr. Malloy, we can restart the clock if you want to speak.
No, I was trying to speak on Lieutenant Cox's case, which was the one I think we just
heard.
Voted on, correct?
Yes.
Yes. So I was trying to unmute, and the system and I were not having success with that. I was just in support of Lieutenant Cox and in agreement with Member Wolf that 67.4 should be added under the Ralph Brown Act, because clearly that is a violation from my standpoint of his case. And in support of him, I just wanted to state that. That was it. Thank you.
Is there any other public comment?
Anonymous number 1.
Go ahead, sir.
Okay.
Hello?
Okay, who is speaking right now?
You are, sir, anonymous.
Okay, all right. So, hi, Anonymous here again. I just wanted to point out, for item number 2, you did approve the minutes, but according to your own belief, you did believe there was an error that I pointed out that should be corrected. So I hope that that's clarified as it's approved with the correction I pointed out. Please do that, or please put that on the record if it's not already on the record. I would also urge you to request that the Supervisor of Records, Dennis Herrera, present his annual report to you. He is required by law to present that to you. Last year they did it in early January. I don't know if they have done it. Maybe we'll hear about it later on in the agenda, but they should present that report of all of the petitions that went through the city attorney route. And I would just remind that under your own rule E1, it does state that violations of public records, of the public records laws, as opposed to say other violations like public meetings, should go to your compliance committee. And I'm just reminding this because I have a few complaints that are kind of hanging. You've found violations, the city has never complied, and I would ask that you do schedule those at the compliance committee at your earliest convenience. Thank you very much.
I'd like to respond to that, Chair Wolf. The referral to committee can be done by the task force, but it's also extended to the chair at the chair's discretion, and I'll look into that. As far as the minutes are concerned, it is including what you had pointed out for correction.
Thank you.
Okay, next speaker.
Yes.
Hang on.
Hold on. Wait for the clock. Hold on.
Go ahead.
Yeah, I'd like to note that in regards to my previous comment on the police commission.
Oh, ma'am, have you already spoken?
I spoke.
Not on item number 4, Bruce.
Okay, I'm sorry. Please
right.
reset the clock. Please reset the clock.
All right.
I apologize for any interruption.
Okay. So can I
Go
talk
ahead.
now?
Go ahead.
Okay. All right. Thank you. So when I was saying that the police commission was not doing their closed sessions properly, this is a problem that is not limited to the police commission. I've noticed that and that there are a number of other committees and commissions also have this problem. I think the Board of Education also does this. They'll have a closed session, and they're supposed to announce that they're having a closed session. They do that, but when they come out of closed session, they're supposed to say the closed session's over, and they're supposed to give a report of what happened in the closed session to the public, and that doesn't happen. The closed session just ends, and if you want to find out what happened, you have to look at the minutes afterwards whenever the minutes get posted. And so this is a problem that extends to a variety of commissions and committees throughout the city, and it's very frustrating, and something should be done about it. So I don't know if there's a way that, I don't know, there could be some sort of education. I know the Sunshine Ordinance Task Force is responsible for that, or who's responsible for that, but yeah, it needs to be fixed. All right. Thank you.
Next speaker, please. Any other public comment for items not on the agenda?
Yes, Mr. Dente Tedessa.
Okay.
Dente Tedessa here.
Yes,
Sure.
Go ahead, sir. Go ahead,
Hi,
sir.
task force members. Yes, thank you. Thank you again, task force members. Regarding some of my past complaints, again, for this particular task force itself, I had addressed an email requesting a reasonable accommodation. This is what I found in the San Francisco Charter, which everybody says the city attorney's office always refers it to the supreme law of the city of San Francisco. Section 2A.22 sets up the Department of Administrative Services office of the Mayor's Office on Disability. it is hereby created within the Department of Administrative Services a Mayor's Office on Disability. The Mayor's Office on Disability shall assist city departments making all programs, services, benefits, activities, and facilities owned and operated or funded by the City and County of San Francisco accessible to all, usable to all individuals with disabilities as may be required by the Americans with Disabilities Act. The Mayor's Office on Disability may issue policies and procedures with respect to compliance with the Americans with Disabilities Act. This is central to my request for a reasonable accommodation. Followed an ordinance 90-10 in the San Francisco City Charter. It says, in accordance to Administrative Code 22A.22.3, to adopt a citywide Americans with Disabilities Act reasonable modification policy that requires city departments to, 1, provide notice to the public for the right to request a reasonable modification, 2, respond promptly to such requests, and 3, provide appropriate auxiliary aids and services to people with disabilities to ensure effective communication, and 4, to train staff to respond to requests from the public for reasonable modification. It further says that. Thank you. It further goes to say that they need to do this within 72 hours. This has never, ever been applied in my case. I even asked the task force for reasonable accommodation. You should have responded in an official way to this within those 72 hours. Again, this has everything to do with all my complaints with the task force. It has to do with all the erasures, the purposeful erasers of my record, my audio. Thank you.
Time is up.
Any other public comment?
Yes, anonymous calling. Yeah, I'm calling referencing file.
Hold on. Wait, hold on. Let me. Let's get the clock ready.
I'm ready, sir.
Go ahead.
Go ahead, sir.
Okay, board members. I'm calling regarding file 19145, Chris Coors. And listening to that hearing today, it seems
Sir, I have to interrupt you because if you're going to make a comment that is pertaining to items on today's agenda, public comment is for items not on today's agenda. So I'll restart the clock for you. And if your comment is more general in nature, please do that. But we do have the law requires us to make sure public comment is for items that are not on today's agenda, but in our jurisdiction. Cheryl, please reset the clock and allow the speaker to start again.
Go ahead, sir.
Well, my comments are relevant to the file 19145. And to me, that was the first item with the petitioner starting the call today. And that's what I wanted to comment on.
Yeah, I'm sorry. I'm sorry, but I have to interrupt you again. Please stop the clock. We cannot allow public comment on items that are on today's agenda. That was reserved for public comment during that case. You can, if you want to specifically speak to that item, then you're probably going to have to wait till next month's meeting when it's not on the agenda. If it's not on the agenda. Yeah, otherwise, you can craft your comment in a general way, so long that it isn't pertaining to any items on our agenda today. Cheryl, please reset the clock and allow the speaker to speak.
Well,
go ahead, sir.
I had attempted to get on almost 4 times, and always someone else started to speak, and then you went off of that particular case. Anyway, I will get on it. There's going to be another hearing on that same thing, I believe, in about the next meeting next month, whenever it is. That's all.
Thank you. Any other speakers? Public comment. Okay. Public comment. Go ahead. Is there a speaker there? No? Okay. Public comment is closed. Let's call the next item.
Item number 6, closed session, meeting with legal counsel and review of documents for file number 19114.
Okay, members. This is a call for a meeting with legal counsel. It involves attorney-client privilege information that advice from our legal counsel, and because of attorney-client privilege, we're going to take this into closed session. So we need a motion to do that.
Mr. Chair,
before a motion is made, I need to make a statement as counsel. I've been just want to let you know that I don't think closed session has been is proper. There's no, my reading of it is there's no statutory basis for the closed session, and I don't think the agenda properly has proper notice for the closed session. And I've conveyed this to the task force. I just wanted to make that clear on the record as well. So if there will be a closed session, I will not be participating.
Victor, go ahead. Go ahead, Victor.
I was going to ask that we take public comment on the closed session prior to making a motion to move to convene in closed session, but with the comments by Mr. Price-Wolf, I don't know how you want to proceed at this time. Okay, well, the proper procedure is public comment comes after a motion is made. We do not make public comment before the motion is being made. And I would have liked DCA Wolf to have waited because the task force can choose not to go into closed session, but they have to do it by a motion. And that's how we run our meetings under Robert's rules. So I would say let's get it on the floor, because we cannot have any discussions outside of the proper process. So we'll start with, is there a motion to go into closed session?
I have a question. Can we discuss it amongst ourselves before we have a motion?
No. That's the purpose of having it on the floor. You got to have the motion on the floor, and then you got to have discussion about the motion.
I also have a question. Is this a closed session with counsel, or is this the closed session with the people involved at the public defender's office?
It's closed session with counsel about legal advice that was provided to the task force.
Okay.
So is there a motion? Okay, going once, going twice. Okay, so there's no motion. This item, it dies, and we will continue on to item number 7. Please call item number 7.
Item number 7, file number 19114, complaint filed by Shane Anderes against Tyler View and the Public Defender's Office for violating Administrative Code Section 6724, 25, 26, 27, and 29 by failing to respond to an immediate disclosure request in a timely and/or complete manner. On September 22nd, 2020, the Compliance and Amendments Committee moved that the respondent provide a privilege log of items requested to the petitioner, and that the committee meet in closed session to review the records in question, to provide the task force information to make a determination on whether the records are public, and that the task force receive written legal advice from Deputy City Attorney.
Okay.
That's the preamble.
Right. So this case is continued. Let's see. This is.
We're going to continue it to next month. We're going to do a motion, or what are we going to do?
No, Cheryl, please. Okay. I may have missed something. Member Hood.
Yes.
Let's get a little brief out of complaints and amendments regarding this case.
Yes. So we have been looking at this case. We actually, the full task force heard some. It went to compliance and amendments. We requested some guidance from our legal counsel, which we did receive. We also requested that the public defender provide some sort of privilege log describing the documents that were not being provided. I don't think we have yet received that. Cheryl, please correct me if I am wrong. We were seeking additional guide. We're trying to determine whether the documents being sought are in fact public records. We can have more discussion on this, and I don't know how you would like to, if we may discuss the legal advice or how we proceed with that.
Well, the task force would have to choose to break attorney-client privilege if we wanted to discuss the legal advice. The purpose of legal advice is to advise you so we can, each of us can be informed and can make a decision, an informed decision regarding the merits of this case. Okay. So with that, let's start our. This is the first time it's being heard by the task force, right? Member Hood?
I thought it had been at the task force before, but maybe I'm confused. Maybe it also has only been at compliance and amendments.
No, I believe it was at the September 2nd task force hearing.
That's what I thought.
Oh, it's continued. Okay.
Yeah.
It was referred to CAC to discuss whether records were public or not.
Right. Okay. Great. So now it's coming out of. That's right. It's coming out of CAC. I've got this confused with another case. It's coming out of CAC, and the question now is, have they complied?
Yes. Would it be appropriate at this point for me to make a motion for, you know what, I'm going to wait until other people say what they have to say.
Yes, it's appropriate for you to make a motion. Absolutely.
I'd like to make a motion that we waive our attorney-client privilege on our memo to have an open discussion. But if others disagree, I would like to have a discussion about whether we should discuss that or not.
You want to have a discussion about the content that's in the legal advice? I mean, we can discuss anything that's surrounded by. If you have any discussion items that you want to speak, you can speak to them. If you want to refer to the legal advice memo, that's something different. But you can just openly speak about whatever you want. The question is whether we want to introduce the legal advice into the record. Okay, so I guess my suggestion here for members is that whatever legal advice that we have received, if that has helped you become more informed about adjudicating this case, then use that advice in your own words to apply it, or to question if you still have a question about it, then we can discuss that particular question. But
Okay,
we don't need
then-
to refer. You don't need to refer to the legal advice that we received.
Okay,
Legal
then my motion
advice.
is not required.
Okay, great. So do you have a question about what the findings from the Compliance and Amendments Committee? What is the recommendation to the task force at this point?
Well, actually, the first thing I would like to know is, are the parties here?
That's a good question. Mr. Andrews? And Mr. Vu, are you here?
Are they waiting in the
Waiting in what? They wouldn't be waiting
the second meeting?
No, they shouldn't have. They don't have the information.
This is Tyler Vu for the Public Defender's Office. Can you hear me?
Yes, we can hear you. Thank you.
Good evening. Yes, I am here for the Public Defender's Office.
Okay, great. And Mr. Andrews, are you here? Okay. Nonetheless, we can continue with this file, whether the parties are here or not, because we're beyond this, pretty much beyond the point of we've heard and gathered all the evidence and heard all the testimony at this point. Unless you have further questions for the parties,
Sorry to interrupt. This is Shane Andrews. I thought was saying present, and I guess I had been muted. So I apologize. Yes, I am here. I wasn't sure if you heard me or not, but sorry about that.
We didn't, but thank you very much. Go ahead, Member LaHood.
Yes, I thank you for both for being here. Mr. Vu, do you have some sort of privilege log or list of the documents that are being withheld?
I do have a list of types of materials that are available in the Public Defender's Office. I think the word privilege log is a legal term that I don't want to use because that's probably not an accurate description of what it is. But we do have prepared a list of types of documents and probably examples that have things redacted out of them that are prepared for the committee.
Chair Wolf, would it be, since we have not received this list, would it be appropriate for us to ask Mr. Vu to read this list, assuming it's not overly long?
It's at your pleasure.
Mr. Vu, could you please read the list that you have compiled?
It's not really a list. It's more of a spreadsheet.
How many lines does it contain?
Give me one moment, please.
Sure.
It contains approximately 20 rows, and it has about 6 columns. So we had prepared it in anticipation of a closed session. And I apologize if I misunderstood the instructions from the last meeting, but we had prepared it in anticipation for the committee going into closed session with its counsel.
Thank you. We need some discussion amongst ourselves first.
So I guess one issue would be you could share it. We could have him email it to Cheryl or to Victor, and then they can share it. The problem is that the public won't have access to that because they don't have access to the video portion of this meeting, which we're trying to correct. So it'd be inappropriate for us to see it without copies of it being available for the public.
Perhaps we should bring up the discussion, the point in the discussion of whether these are public, whether the documents that have been requested are public documents. And I'd like to hear what other members of the task force think about this. You've all received the case and related files, and we'd like your input on this. I think the primary challenge presented is the function of the public defender's office. What is, and the distinction of what is work product, and whether materials gathered for the purpose of defending current and future clients should be considered public records or not. And you'll see this discussion in the primary case file and in additional information we've received about this.
Okay, so it's a good question. You know, I'm still a little on the fence with regards to the references in the Coronado case, because one part is that Coronado revolved around the database. Okay, and you can, you can figure. I guess you can figure. Its specific was to a database. I don't necessarily consider a file cabinet necessarily to be a database per se. It's a container for such things, but I think the thrust of Coronado was even if it was in a database, that whether the materials in the database are publicly disclosable. Now, I think the balancing test here, as we've been discussing for some meetings now, is that whether the material is part of protected information and intelligence that is used by a public defender in their representation of private persons. And the question then becomes, is it a public document at that point? When you look at the request from Mr. Andrews, the points that are being brought out for the items that are being withheld are for reports. His requests were for reports against other persons, including himself, by the public defender's office or any of the staff that are working there, including the attorneys. So, and then the question is whether that kind of document is publicly disclosable by the public defender's office. It may be publicly disclosable by other places, but here the request was made of the public defender's office. So I think that's kind of the crux of where we're at here. One of the things I'm a little concerned about is we're asked to consider a legal case with regards to this, and it involves the areas of jurisdiction that are not in our jurisdiction. with regards to the operations, regulatory or, in statute of the relationship of the public defender to city government. And the question then becomes, which are these documents part of the operation of the public defender that is governed under city government versus the other parts which exempt it and separate it, make it independent of city government, where city government does not have the ability to direct it or make decisions about it. I think that's I hopefully I articulated that well. So I have a little concerns about that, about us trying to figure that part out. And part of it also is that I've not heard from either party, nor from our city attorney as our legal counsel, as to this particular question and where it's cited in law, whether it's our charter or whether it's state law or federal law, because that, I think, would help us figure that out. Now, there are documents, without being able to see the documents themselves, it makes it a little, as we always have problems with when respondents choose to withhold documents, whether they are being held properly or not. Whole documents, whole records can be withheld for certain reasons. And other documents, the information on the record, the record must be disclosable, but some information on the record can be redacted. But we never get to see what those documents are. We're just kind of told that they apply under this or that statute, and we then have to go really digging deep to at least get some hint of the representation by the respondent, of the representation of the context of those records as to whether they're applying it properly or not. And so that's why we would normally, generally request in some sort of in-camera review, but citing, there's lots of times they stand by that citation and we don't have that ability. So then the only suggestion that we could say is you're going to have to go to a higher authority that has the ability to be able to ask for those records, and under a different section of law that may be stronger or different, or there's an actual magistrate that can actually make a judicial decision that is binding of some sort. So I'll stop there.
I would speak to the Coronado case, but I don't want to do that until we've decided on whether to view this spreadsheet, so I could get even a little better sense of what's going on here. My Microsoft went out for a couple minutes. I know we voted, or nobody made a motion to have a closed session with the city attorney. I don't know if there was a discussion while I was blanked out about whether we want to have a closed session to look at that spreadsheet. I may have missed it, but I think the only vote that didn't happen was whether the first as opposed to the second. And it seems like that's something that should be discussed, is whether we want to go into closed session on that issue.
Okay, so then it's really a question for Mr. Vu, because I think the Complaints and Amendments Committee was under the impression that this was didn't need to be seen in camera, that it was going to be actually provided to Mr. Andrews and thus be disclosable. So let's ask Mr. Vu, is the document you created, this spreadsheet, this list, is that available for public disclosure?
I don't think that it is available for public disclosure. I would have to check with my colleagues and before I agree to that. I do know that, at least with regards to my intention, was that when I had agreed to, even to put the document together at all, was that he shared.
Chris, can you mute yourself, please? Thank you. Go ahead, Mr. Verna. Sorry.
That it would be shared in a closed session with the attorney for the task force. It is, and it was really sort of my effort to just try to give the members of the task force a better understanding of the types of documents that exist in the public defender's office, and not so much in direct response to Mr. Andrews' records requests. What I was really trying to do was to give the members just an idea as to what the records, what kinds of records exist, and how they're different from one another. Not really trying to give specific examples that could fall under what Mr. Andrews is asking for.
Okay, I was under the impression, and Member LaHood, please correct me, I was under the impression that you had agreed to provide some sort of document list of the documents that you were referring to. I believe that was our discussion at the Complaints and Amendments Committee meeting. That the purpose of the closed session was to actually have to be able to see the actual documents in camera, so we can get an idea of whether they were applicable or not for public disclosure.
Well, I think there are some documents. I mean, I think in addition to the spreadsheet itself, we do have attachments that help illustrate the types of documents that I think Mr. Andrews may be referring to. So it's not just a spreadsheet. I mean, we had put some effort and time into trying to putting everything together to sort of make a presentation to the board. But our understanding at the time, my understanding at the time, was that presentation would be made in camera.
Okay, I got it. Go ahead, Member Lee.
I was going to say, I think there was perhaps some confusion on both sides. We were under the impression that, and perhaps the term is not right, but that some sort of log of the documents being withheld, I thought that was going to be provided to both parties, and that we were considering the possibility of seeing some of these documents in camera. I think we did not go down that path because I think there were some concerns or some questions about whether we should be doing that and who exactly would be involved. And we appreciate the extra work you did. I'm sorry that there was confusion about the intended destination for the various documents that were requested.
Yes, and also, unfortunately, my main focus at the time was in trying to put together the materials for today's hearing. I haven't begun to approach, to what extent we would provide Mr. Andrews with a log. And maybe perhaps we will provide him with some kind of a spreadsheet of the types of documents, but mainly at this time, I'm not prepared, literally prepared. I'm not prepared to address the issues of what we can share with Mr. Andrews, just so that we're both talking about the same things, so that we have sort of the same points, the same types of documents that we're talking about. But other than that, I don't have much more to say.
Mr. Vu, I just have a question. I mean, you must recall in our Compliance and Amendments Committee that we had discussion about providing, we called it privilege log then, you didn't object to that term then, but that you would provide at least a log, whatever description it is, to the petitioner, to Mr. Andrews. That was our motion. And we made that actually in consensus with you in an open and public session.
Member Wolf, I mean, I think that we may very well later down the line provide some kind of list of types of things that might be available or might not be available. But I do recall agreeing to that, but I think that I was wrong in agreeing to that, and I should not have agreed to that. Okay. I mean, in terms of today, I was mainly focused on preparing for the in-camera review of the types of documents that may be available, and then after that part was done, then consolidating and figuring out to what extent we can provide Mr. Andrews with a list or type of documents that may exist in the Public Defender's Office. The reason why I think I am reluctant to call it a privilege log is that that word implies certain legal obligations that may or may not exist in this particular scenario.
Okay, fair enough. Fair enough.
And Member Wolf, again, you're right. I did agree to that. I did agree to provide a privilege log, and looking back on it now, I was wrong. I should not have made that agreement because that was likely outside my authority at that time.
Okay, so let's not call it a privilege log then. We're looking for a list of records instead. Then you don't have to worry about being charged with a legal requirement. But if you find that the documents themselves, have a legal requirement, that's a different story than the actual creation of a quote-unquote privilege log or log of that type. Nonetheless, I think I want to. Go ahead.
Maybe.
Was that Member LaHood? I'm sorry.
I'm sorry.
Go ahead, Member LaHood, and then Mr.
Yeah. So I think I think what is in front of us now is making a decision about, or making a determination about whether these are public records, because that is going to determine anything else we did. If they are not public records, end of discussion. If they are public records, then the conversation needs to continue. And I think at our last Compliance and Amendments Committee meeting, that seemed to be the thing that we were struggling with. I believe we have some more information now. We also have some new people involved in the discussion, including an attorney who may want to weigh in on this, as to whether the documents gathered, the documents created through the course of work by the Public Defender's Office, and in their words, that the documents that have been requested have been gathered in the course of defending current and possible future clients, and whether that alone means that they are, based on that, are they public documents? Are they public documents? If they are public documents, are they protected as work product? we have to answer those questions before we can do anything else.
Yeah.
Oh, wait a second. Hold on. Member Schmidt.
Oh, I'm sorry. Go ahead.
I want to let Mr. Vu have his. Go ahead, Mr. Vu.
Sure. If you tell me that you would like me to explore the possibility of coming back and providing a list, let's call it an educational list, the types of documents that may be at hand, and that list would be made public at the hearing and as well as provided to Mr. Andrews, I could investigate whether or not I have authority to do that, and then proceed to make that educational list available. But at this time, I don't have that authority.
Okay. Member Schmidt.
Yeah. Member LaHood, I think I tend to agree with her that we're really trying to figure out whether these public documents before we decide they're public documents in a way. One thing that I want to ask Mr. Vu, and it's really a quick question, which is, I haven't really been involved in the proceedings on this before, but could you tell me, there's a list of maybe 10 people who the records are asked about these 10 people. Are they all employees of the district attorney's office? Is that who they are?
They are half employees of the district attorney's office. Actually, let me correct that. Let me look it up. I don't want to misspeak.
Sure. And while you're looking that up, I'll just clarify that I do think that this case probably does come down to what side of the Coronado case is the decisive side. And I think it depends on the circumstances of what's being sought here. And so if I can get a sense of what exactly what Mr. Andrews is looking for, then we can see how Coronado applies.
Sure. I'm sorry. Which member is this?
Schmidt. Yes.
Member Schmidt. So, I believe of the approximate 10 names that are listed, all 10 names are public defender names. However, half of those approximately 10 names, what's being asked for are the accusations of misconduct done by DAs that are made by 5 of those public defenders, approximately 5. The other 5 public defenders are basically misconduct made by those 5 public defenders themselves. Did I answer your question? So even though the names are public defenders, half of it is essentially those public defenders, how many, which DAs did they make accusations of misconduct about? The other half are which of those public defenders were they accused of making misconduct?
Oh, I see. Okay, now I understand. Some of the questions were confusing. There was a clause that I didn't quite understand the way they were phrased. Okay, so these are all public defender personnel. Okay, yeah. That makes. Oh boy. Yeah, okay.
And the accusations are against both public defenders and DA personnel.
Yeah. Okay. I'm gonna, if I may, I'd like to switch to Mr. Andrews for a question, which is, Mr. Andrews, when you ask about these individuals at the public defender's office, what type of information do you think is contained in those records?
Sure. And this is Member Schmidt, you said?
Yes, Dean Schmidt.
Okay. Yeah, so thank you. I actually appreciate that you're new to this case. I think it helps out because the other members are probably tired of me saying the same thing over and over again, which is Coronado has nothing to do with this case. I mean, the recent back and forth about the people identified in the request, I think, are super helpful, because this isn't lawyers or a group of people trying to get the public defender's database of police officers they're investigating, because of course, yeah, that's work product they use to defend their public clientele. That is not this case. This case is about Mr. Ostley, who was a former district attorney, who was being threatened by various public defenders with accusations of misconduct if he, whenever he tried to take a case to trial instead of settling it. And he was accusing the public defender's office of engaging in similar conduct toward other district attorneys, which is unethical, borderline illegal. And so eventually the public defender's office carried through on its threat. It filed a state bar complaint against Mr. Ostley. Mr. Ostley was required to respond. I submitted a public records request identifying the public defenders who Mr. Ostley believes made or contributed to the allegations made in that bar complaint and other threats, as well as requested any documentation that would refer to any similar accusations made against them individually. So none of this has to do with Coronado, because none of this has to do with the public defender's representation of their clients. This whole exercise has morphed into that because the public defender's office just keeps citing the case, and then we go off on a tangent about all sorts of questions and issues that are interesting but not pertinent to my request for records. So what kind of information? This is, as I've said before, this is simply a matter of public employees behaving badly toward other public employees. It's precisely the type of information that the Joe taxpayer is entitled and deserves to know under the ordinance, and if not through the ordinance, if we have to litigate it, fine. But the last session was clear. There was no confusion. And I appreciate at least Mr. Vu was candid at the end by simply pointing out, yeah, I agreed to something and now I'm not. Because the agreement was he was going to provide documents to the committee in camera with council present so they could review them to decide if they were public documents. Then it became, well, maybe a privilege log instead. But a privilege log identifies those specific documents. I already heard last time that he wanted to offer me hypothetical documents and hypothetical issues. That is not what I'm requesting. And he's saying it again. He's mentioned doing a presentation for you, some sort of educational slideshow. I'm not here for that. You're not here for that. I asked for specific documents. He should have provided them already so that you could have reviewed them and made a decision if they were public or not under the ordinance. That's what you instructed him to do. That is what he agreed to do. He has now changed his mind. If he wants to provide a list, fine, but it cannot be a list of hypothetical documents. It should be a list of documents that are responsive that he will not produce because he believes they are not public or because they are asserting some sort of a privilege. It's not complicated. It's simply a refusal to engage in good faith and do what they're supposed to do, period. So either they're going to do it or they're not, but we don't need 4 more committee hearings for him to keep showing up and beating the same drum and refusing to comply. And the ordinance, the ordinance, I just want to make sure everybody understands. The ordinance says that they are supposed to either redact or identify what they're claiming is public. There's not a sweeping statement that just says, hey, whatever you're asking for is public. You don't get it. No, that's not what's happening here. So, Mr. Schmidt, I know that's a long-winded answer, but thank you for asking it, because hopefully you are now up to speed on what exactly has been happening in the past year.
Okay. Well, it does seem like that raises some real question for me as to how much Coronado applies here. It sounds like your position would be that this has to do with the administration within Public Defender's Office as opposed to the representation of clients. So, yeah, I agree also that a privilege log sure would be helpful for everyone, probably, if we could get one generated here.
But the request for a privilege log makes the assumption that these are public records. Yes? Because if they're not public records, we wouldn't be asking for a privilege log.
Well, I would say that a privilege log, and you know, we can define it narrowly or define it more broadly as something that's, you know, maybe a little more categories, et cetera. But to me, it's a tool to get to the question of, is a document going to be found to be privileged or not, found to be private or public? Because in this situation, that you've got the Coronado case says that the public defender's office is acting as a private counsel, therefore some of their records are not public records. But what we're looking at here is we're trying to figure out, well, is this within their private counsel realm versus other parts of what their record keeping would be, which are public records. But we can't tell yet, as far as I know, which we're at. And so that's why I think that the privilege log, which wouldn't give us necessarily every single fact about the documents, but it would just give us some sense of what it is that they really have. It can help. It can help. And I mean, my experience is they can often resolve most of the issues just putting things down.
Well, I think the introduction of a quote unquote privilege log was introduced by us. Okay, so if the privilege log is the concept or the actual object of a privilege log is, it may not be appropriate. And if a privilege log is public, we can't then say that the documents that they're assuming to withhold are part of any privilege log. I mean, I think that sounds kind of like our invention. That we're trying to create a privilege log for the respondent to comply with. If we're looking for a privilege log, then the question is, does one already exist and provide a privilege log? I think what we originally were asking for was a list of the records that, and then for them to provide Mr. Andrews, and then to provide us with actual records that we could see in camera. That is the way the discussion went at the Compliance and Amendments Committee. Okay, so either way, it looks like, you know, we're again at some sort of an impasse. I think I will comment on one thing that Mr. Andrews did bring up and has brought up before, and we bring up all the time, that whether it's a redaction or withholding of records, there has to be some listing for each one of those records, a statute that would apply and give the legal authority for those either that information in the public record to be redacted, but means that the record would have to be disclosed, or full exemption. Now, again, Mr. Vu keeps saying that those records are part of attorney work doctrine, legal doctrine, attorney doctrine for work product, and that that information all applies to their general work with the general public, and it's not part of the work of that office that would be governed by the Sunshine Ordinance. And so it then goes back to, I see that being the first part. The second part is if that information is being used on the private side, then is it then a public document that's disclosable? Okay, and much in kind of the same way as if it was a nonprofit organization and they had, documents pertaining to the work that they do. The question is it work that they do for this as part of their contract with the city, or is it work that they do privately for the other activities that they do that's not applicable to the contract with the city? So it's similar to that kind of question. I'm just bringing up that example as a similar type of question. So I think I'm still a little bit of an impasse, because I've asked several times what provisions apply to the Public Defender's Office that it claims that the work that it does with the general public and providing them legal services is independent and private and not part of government activities. And I've yet to have that information. It's just been said anecdotally. But what gives the Public Defender's Office that authority? If it has that authority and these documents are created as part of that private activity, then the question becomes, does it actually touch the parts of the Public Defender's Office that they are required to comply with? Including the Sunshine Ordinance at that point. So, for instance, like if we're talking about the Public Defender's budget, will they get funded by the city? Well, that's got to be a public document, because we're dealing with public, that part of that's where it touches the public part of the government. But the case file that the public defender creates as they're going into court, that's part of their defense, that is wholly confidential by the public defender on behalf of their client. And so the question is are the records that Mr. Andrews is requesting on behalf of Mr. Ostley, part of that kind of work? Is it part of a library of intelligence that whether that intelligence includes public records or not is of no consequence, but is it part of intelligence and work product that the public defender uses in order to perform their functions on behalf of their client? And then is that protected because they have a shield, the shield of doing that work privately and not as part of a government function? I'll stop there.
Yeah, I think Mr. Vu's position might be helped if he can convince his people to supply something, a privilege log or something similar, because to me, this involves people within the Public Defender's Office, so this doesn't seem like it has to do with their cases. And so it looks like these might be public records. And so if he wants to show us that they're within that private attorney provision of Coronado, I think it would behoove him to demonstrate that to us. Otherwise, we find that they're public records.
Well, the respondent used Coronado as their defense for protecting these records, and I think I'm still kind of at that point of I can't, without having knowledge of the actual authority and shield that allows the public defender to be that protect those records. It makes it hard. I mean, it may be obvious, and maybe I'm naive in some way, that this is some like automatically, just knowledge of the way that part of the legal system works. But for the purposes of giving the case its due diligence, I think that must be prominent. That if that function, legal function, is in fact a private function and not part of a government function or a government activity, then I think it needs to be shown to us first that it is it's siloed, it is completely independent and separate from government at that point, so that we know that what part of attorney work doctrine applies to that part, and then what part of everything else, what all other documents apply to that are publicly disclosable. Member LaHood.
Yeah, actually, I wanted to comment because it looks like Member Highland has a hand raised and has had for a while, but I don't know if it's intentional or not. And then I'll let him respond to that first, and then one of.
Go ahead.
That's okay. What I was going to say has already been covered, so carry on.
Would it be appropriate at this point? I believe DCA Price Wolf is still on the call here. Would it be appropriate for us to ask him to provide some advice in response to specific questions that we have?
Sure. Go ahead.
So DCA Price Wolf, we know what specific documents have been requested, and the district attorney's office is saying this is protected because it is part of the case files. Do you see these complaints about or by members of the public defender's office as possibly being considered part of case files, if they exist?
Yeah, I think they could be. I mean, I think the way I read Coronado is that, I think of these complaints, first of all, I'm concerned, well, the short answer is yes, because I think that these complaints can be used either for current or existing defense of clients, in that in the same way when you're preparing as an attorney, you're preparing your case and figuring out the facts and the strengths and weaknesses of your case. You also are probably looking at your opponent attorney and looking at weaknesses they have, complaints against them, and how that you might bring that up in pretrial motions or strategy when you're litigating a case. So I do see how it's reasonable to assert that these documents could be used for current or future cases that the public defender's office has.
And a follow-up on that, the way you talked about it, it sounds like this is a common practice and would not be, is it something that would be considered common practice or unethical?
So those are two kind of questions. So is it common practice, to keep case files keep opposition files? I have no idea what's common in the public defender's office or amongst public defender's offices, unfortunately. I don't think it's necessarily unethical, but I don't know. Yeah, I would think what's common is, if you want to keep a track record of times that opposing counsel had misconduct in the same way that you want to know if you're going to go up against someone, whether they're prone to certain allegations. You could bring that up and use it against them in litigating a case. I would want to keep all that information, about a list of my opposing counsel if I had it, but I just don't know about how common something like that is.
Anybody else? So I'm again, I'm on the fence about this. I don't feel confident enough to know what documents are privileged and exempt from public disclosure at this point. Because even if I looked at Coronado, there's an assumption that is being made, and it's being made based upon a certain set of documents. But I can't tell whether the documents here that are being asked for are applicable in the same kind of way. That is just the defense that the respondent is using. So it's hard to say about that. I just don't know. And for that matter, I think I'm just going to be spinning my wheels here in order to try and come up with some sort of determination about how to proceed with this at this point. And I'm leaning more towards that it should be a court that looks at this, because ultimately our decision is somewhat administrative. It's not the ability. We can compel the custodian to produce the documents, but there's no necessarily legal enforcement of that. We don't have that ability. We'd have to, find another department that actually that's authorized to provide enforcement, which includes the judicial system. So, I'm really on the fence with this. If there's any motion that comes up that wants to make a determination on this, I'm probably going to vote no.
So this is Shane Andrews. May I make a statement just in response to the recent committee comments?
It's okay with the rest of the members, yes? Okay, go ahead.
Okay, a few things. One, could the documents be part of client files? That was asked of counsel. He said yes, and I absolutely agree. But I think the more important question is, can there also be documents that are responsive that are not part of those files? And I believe he would have to necessarily answer yes. Just like half of those documents that have to do with complaints filed by public defenders, sure, those might be in client files as part of opposition files, maybe. But what about the half that are questions about misconduct against public defenders? That cannot possibly fit in any of those categories, and therefore, by definition, cannot be protected under any sort of privilege under Coronado or whatever other kind of argument the public defender's office wants to make. The other thing is I keep hearing reference to those documents. This is the problem. I thought today we would actually be talking about specific documents. That was the purpose of the last conference, to provide a log and camera, whatever. But therein lies the problem, and I appreciate this committee's difficulty. We are talking about nothing. It's a hypothetical. We are talking about academic arguments at this point because you have not been given any indication of what those documents are that we are even talking about. I don't know how you could possibly make a decision. However, I do know that if the decision is simply to kick the bucket after over a year's worth of hearings, then any agency that just wants to throw up a legal objection and drag out the process far beyond the 10 days I'm supposed to get documents into over a year and a half to end up with nothing, I mean, that's a real problem. I'm just going to put that on the record. I think that is absolutely contrary to the whole purpose of the ordinance and to you all spending your time into the wee hours listening to people like me and hearing out these arguments. And at the very least, if you're going to tell me, okay, now pick it up later and go to court, fine, I will. But put something on the record. Order them to do it so that I can go to the court and say, yeah, we talked about this for almost 2 years. And they made promises they reneged on. They made objections based on fanciful arguments about hypothetical documents with cases that don't apply, so that I can have a judge now who knows privilege logs, who knows what the law is, who can give me what I need. But
Okay.
to let this all go to waste and simply say I can't make a decision because they stonewalled is only inviting further stonewalling from them and every other agency that's in front of you. So I'm done.
Okay, Mr. Andrus, I take a little aside to us in that way. I'm trying to ascertain exactly what authority the Public Defender's Office has for any documents, which is not really part of their defense. So I take a little aside to that. Also, I am of the belief, and I think it's generally fact, that records that are collected by attorneys for the purposes of use in their cases, can be held as part of work doctrine, and whether it is part of a case today or not. The question that I have, though, is for the documents that you are requesting, whether they are, whichever ones they are, I want to know which ones those are, which ones are protected under that doctrine, and which ones are actually public. And that's what I'm trying to ascertain here. Now, as long as, first of all, also, the task force under the SIP order, the shelter-in-place order, was unable to meet for 6 months. So let's dispel with the length of time. This probably would have been heard a lot sooner had the pandemic not come our way. But by the same token, I'm not convinced that way. If you're interested in us just getting to some conclusion so that you can go to court and state that you've exercised the local process, fine. It doesn't matter what our decision is. You would have done that and satisfied the court's question. I'll take a response. Hold on. I'll take a response from you, Mr. Andrus, and I want to give Mr. Vu a chance to rebut.
Yeah, I'm not sure I have a response. If I understood correctly, I mean, you could take all the offense at me that you would like, which would be surprising, only because what I'm saying is exactly what I think you're saying, which is what I'm a little bit confused about, because you're not able to make a decision because you're not getting information, and the delay is not attributed to the Sunshine Ordinance Committee or to COVID. It is to the Public Defender's Office. So these weren't lengthy or difficult requests, and that's what I'm referring to, that this was requested long, long ago, and it's their responses that are basically obstructive. I mean, okay, so let me just, this is what I meant, and then I'm done. Here we go. And this is just while I'm sitting here listening to all of this. All right, I requested documents regarding any allegations of misconduct against Silamon, I'm probably mispronouncing the name, sorry, Nawabi, right? So I've got a public document. I've got a public transcript of a case between Mr. Ostley and Mr. Nawabi, and it's the judge accusing Mr. Nawabi of misconduct and a finding. And so the public defender is coming here telling me that it has no document of that. I mean, it couldn't be more specifically responsive, but they have nothing. And I'm to presume, and everybody is supposed to take in good faith, that a judge who accuses one of its officers of misconduct in open court on a transcript, that there's no internal communication about that whatsoever. So there you go. That's my problem, is that you can't make a decision, and I'm seeing a document that's responsive that they have not identified, that by definition is neither private nor protected by any privilege. It should have been identified and produced, and all you had to do was put in the words Nawabi and misconduct into an electronic record search, whether it be email, text, Word documents, and they don't do that. They'd rather make a spreadsheet of hypothetical nonsense and have another hearing until eventually I go away, which I won't. And so, again, no offense to this committee. It's exactly the opposite. I think you all should be offended that you're sitting here wasting your time when it's a simple task to respond to requests. And if he doesn't want to, fine, but he should come in here and say, we're not going to do it, instead of leading us on again and again about what they will do or won't do. So.
All right, Mr. Andrews, let me just ask you a question. So, you gave an example. Is that exactly what you're looking for? You're looking for the same information that was presented in the court, but you want to receive it?
No, that's an example of a responsive document. That's the problem. That is what a public request for information is. We are trying to find out what we do not know. And that is the danger of allowing someone who is the only custodian of that information to simply walk in and cite some case and get everybody freaked out about public policy and attorney-client privilege, which has absolutely nothing to do with what I'm asking. And like I said, Member Schmidt, when he asked the question, it couldn't have come at a better time, because no wonder someone walks in not knowing what we're talking about, because we're having conversations about one thing and then talking about my requests for documents that are an entirely another thing. And in between, it's getting lost and you don't have anything to make a decision on. I get that. Whose fault is that? That is the public defender's fault. That is their fault for not complying with the ordinance. This is not a legal issue outside of your jurisdiction. It doesn't require special terms like privilege or in camera. It requires a government agency who's not going to produce something to the public to simply say why. And you've already said it numerous times. If you're saying it's not a public document, cite the provision. If you're saying somehow it applies to a private function of the public defender's office, then fine, tell us. You're all sitting here waiting to be informed, and you're not getting it. You're not getting it from Mr. Vu, the public defender's office. I don't know what's happening in the, closed sessions with the lawyers, but I wouldn't be surprised if they're just as confused, because if the information they have to work off of is hypotheticals and Coronado, and nobody's paying attention to the request that I'm making about public defenders engaging in unethical conduct, which would include emails, text messages. What about the last time?
Yeah, but Mr. Anderson,
why not just ask people to tell us whether there's responsive text messages?
Mr. Andrews, I'm not going to let you just go on and on. Okay, we are unable to determine that. Okay, and that is the problem. You're right. Okay, even if the question is what if all of it is protected under attorney work doctrine, as you had noted in the hearings of the Compliance and Amendments Committee. If it's all protected under attorney work doctrine, then our work is done here.
Right, but all what? That's the problem. We don't know what we're talking about. So it's all what? Is every file in their office protected? That's what we're working with, because we don't have a list of what's responsive to my requests. If there's nothing responsive to my request, that should have been the response. We don't have anything. That's not what they responded. They said, what is responsive is either not public or is privileged. So then what is the next step? Okay, fine, we got that. Let's talk about it. So what are these categories? That's the whole point of a privilege log, is you don't disclose, you don't waive any privilege, you don't give up private information, because all you're giving is a list that says date of document, to who, from who, subject line. There's nothing privileged about it, but that allows someone to decide, oh yeah, this is likely covered. Okay, we can now make an informed decision. We don't have that. You've asked for it multiple times, you haven't gotten it. And now you're going to throw up your hands and say that it's somehow, because of, I don't know what, but it's certainly not because of my requests, what the ordinance requires, or your jobs. It's because you're not getting compliance. So if you believe you can't do anything about it, I understand.
Okay, Mr. Andrews, I need to move this along. We're already 45 minutes into this. We've not gotten any closer to a determination. We're going to give Mr. Vu some time to respond, and then I believe Member Schmidt wanted to chime in here too. Mr. Vu, do you have anything to say?
Well, I think what I just heard from Mr. Andres is that he does have a specific example of what he had in mind when he asked for a very, broad, all documents pertaining to alleged misconduct. And with Mr. Andrews' example, I'm more than happy to argue the specifics of that example as to why we concluded the way we did. But, with regards to the privilege log, I think that it's a position of my office that as Member LaHood had mentioned earlier in the evening, that the privilege log really only comes into play if the document is public. And there are other reasons like privilege to not disclose it. But using Mr. Andrews' the example that he raised as sort of my case in point, which is that I think there are reasons why counsel for the board here may say that that kind of material that Mr. Andrews is asking for is in fact not public. The other thing that I don't. The other one.
Mr. Vu, I just have to say, that's what we're trying to discover here. You're just saying that, just anecdotally saying that it's not public is not enough. And the question with regards to Coronado is it doesn't allow us to know whether that any of those documents fall into the categories that Coronado is trying to address. So it's just the same as if there was a redaction of a public document and then no footnote as to what it is that is being protected and why, and under some specific citation.
But remember,
so, go ahead.
I mean, what we're trying to say is that in the example raised by Mr. Andrews, is that that's not a public record.
Why?
Because it was in context of a case. It was in context of an attorney representing a client.
It's a public transcript. By definition, it's public. Sorry, I just want to stop the nonsense.
Mr. Andrews, there is specific wording in Coronado that says that just because something is publicly available doesn't make it a public record.
Okay. I don't know what that means. I don't know what that means, but we've heard it so many times. Let's just move on. I know that
I can cite to it in Coronado. I can cite to it.
It's the only thing we've looked at for a year. I know you can cite to it. That's all you.
Okay. You know what? We're not going to have a debate. This is not a forum for you guys to have a debate. You can do that privately over the phone. Okay.
I don't want to. It's just a public document that I referenced by definition. That's all. I was just trying to cut to the chase. This is nonsense.
Okay. It isn't.
See, Mr. Vu, the trouble with us is by your arguing anecdotally that it just isn't, and you're saying you're citing Coronado. The question is what in Coronado is making that decision, and if that is specifically to that piece and kind of document, it's not just blanket all documents. Now, yes, some documents can be a newspaper clipping. Is a public document or publicly available, but it could be part of a case and that is sealed, from public view. I get that. Okay. The problem here is Mr. Andrews is citing certain kinds of documents that he believes are already public, and so if a member of the public is claiming that, then it's really up to you to prove to us that it is not. And it's like I can't read necessarily a body of law that is applicable to it. I am getting case law. Case law is important. We do have to follow that. Okay, Member Schmidt, you wanted to say something. Go ahead.
Yeah, I think that at this point, the only way I think this can move forward is we decide whether we can order the public defender's office to give us a privilege log. Because, I mean, we may not have the power. I don't know. But nothing's gonna change. And so it's sort of it seems like it's a put up or shut up moment for us. Do we want to try to compel them to do it, or do we just move this, and just see the same thing over again?
Well, okay, go ahead.
That's
it?
That's
okay.
all. I mean, I don't think there's anything unless, well, if we ask them or order them to compel to produce a privilege log, which would give us information. It doesn't. They can list all the privileges they want to assert, and they can also tell us we think they're all within our private aspect of our business, which is what Coronado talks about.
The problem with that,
if they don't want to give us a privilege log, then maybe we get to the point where we make a ruling against them in favor of Mr. Andrus, because they've made that decision not to give us the privilege log. That's all I'm saying is either we get more information or we make a ruling. And so if we order him to get more information, he's got a choice. They have a choice whether they're going to do it or not.
I would rather try to come to a decision and allow the process to move forward, because it won't end with us. One way or another, one of the other parties is going to have to do something that's beyond us, that's in a little more a venue of a little more authority than what we have. I don't know that the privilege log, first you have to determine whether the privilege log actually is public or not. That's why I'm not trying to refer to it too much as a privilege log, but as a log or a list of items that they are not willing to disclose, and citing actual statute as to that, as the ordinance requires. Okay, so that's kind of what I'm leaning to. I think if at this point, if they're not willing to produce anything, then sure, we can make a decision with regards to that. Member LaHood.
Are you saying that the ordinance would require a listing of documents and explaining why they are not public documents and are thus being withheld?
I'm saying that anything that's being withheld, whether it's through a redaction or through being completely withheld or even exempt, okay?
As not a public document, or not a public record.
If they are claiming that it is either not disclosable or that it is exempt from the California Public Records Act, or if there's any other law that would take precedent, and most of those laws will say, notwithstanding the California Public Records Act, or it'll be some action word to the California Public Records Act. It will state that. It's all over state law for when they're talking about disclosure of information. So it would have to say, they would have to at least say that. And there's a requirement under the ordinance for a respondent to provide either by footnote or list by footnote, or a list of whatever documents were being requested that they can't be disclosed. It doesn't matter what the record is: email, text message, phone logs, calendars. It doesn't matter what it is. And and that's why I asked at the beginning if there is this kind of bright line that, and I have not been able to see it, and it shouldn't be. I shouldn't have to go and find it. It's a responsibility of the parties to be able to provide that there is one or the other or both to tell us where that bright line is for this particular office. If it was a private law firm, it's very easy. We can't. we can't get access to a private law firm's information. A court would have to compel them by subpoena to do that. And if they refuse, then that goes down a whole nother judicial process. But for us, the rub is this is publicly funded office, and part of it has public function. And the other part of it is, I'm not sure what the other part of it is, because I don't have a statute that describes it. Nobody's provided it. So I don't know whether some or part or all of the public defender's office in its work with the general public, I don't know what part of that is private or not. And so yes, it may sound naive, but this is how the general public would think in hearing this case as they're hearing it. Lawyers who know things, and it may be like common knowledge in the legal profession, well, that's because they know that stuff. It's not helping the general public understand that. The layperson here who is trying to bring as much gravity and interest to the public as possible. Member Schmidt.
Couple things. One is that a case law has the same weight as statutes. There's no right. It doesn't. In this situation, that case is very important for deciding what we're working with here. Okay. The second thing, I guess, is that a privilege log it's just a tool. It's not an official document, and it can be done in a lot of different ways. And we're just trying to figure out, can we, we would say if we want to, try to compel it, or because they don't want to give us one. So if they don't want to give us one, then we can ask and compel it, say, give us a privilege log. And in your privilege log, state where, you think the documents come within court auto or not. And then you move on and you go attorney-client privilege, work product, whatever other kind of privileges you might assert on a certain document or a category of documents. And so I think that we can go different ways here. But the last point I wanted to make is, I don't know if we should be necessarily throwing the parties to litigation here. I think that this is something where they come here to see if we can give them a resolution. And I think we can. I think we can connect the law and the facts to this situation. But we're not necessarily at the point where, and I think we all agree with this, we're not really at the point where we can make the factual conclusion quite yet. That's where we're trying to get to. Okay. And then we can apply that law and figure out what should happen.
What do you, so if I'm hearing you're formulating an action, in which we should do next?
Well, I'm a little reticent to make a specific motion, but it's either we order a privilege log or we make the decision, well, they're not going to give us a privilege log, we're not going to order a privilege log, and then we just decide this thing based on what we have, because we probably wouldn't get anything more. And then we talk it out. We say, okay, we're done. We're done here. Let's just make a ruling. But one or the other, I think, is the next step from what I can see. Unless someone else has, I'm open to other suggestions. I don't want to act as if I'm the only one with. Ms. LaHood okay. Looks like she's.
Go ahead.
Yeah, this is a tough situation because I'm a journalist and I want to err on the side of everything is a public record. But I have to say, in this situation, I am I am persuaded by the work product doctrine, and we might think it's not fair that one of the tactics that they use is gathering opposition research, and is that really, about the defense of a client, current or future clients? But if this is information that they actually gather and use for that purpose, for defending current and future clients, then I think it's protected. I don't know. We may think, it's not really fair. Are they kind of hiding practices that they use to get under the skin of the attorneys that they're working against? It kind of sounds like that's what they're doing. But if the ultimate goal is defending clients, I think they're allowed to do that. Am I wrong?
But that's my question, is under what statute are they allowed to do that?
Filing bar complaints doesn't defend clients. I just needed to make sure we're staying on track again. I appreciate the point, but once again, I'm just trying to keep us on point. They filed a bar complaint against Mr. Ostley. It had nothing to do with a particular case or a particular client or a particular future client. So as long as we're all talking about the same thing, we don't have documents, but we should at least stay on topic.
If that connection can be made between the misconduct allegation and a specific, specific prosecution, yeah, I'm with you. I'm with you on that. Although I'm not quite sure yet if these kinds of misconduct allegations really do have to do with a particular case, another particular case, etc. Just not knowing them well enough yet.
That's fair.
Member Wong, did you have something? I'm not compelling you to say anything. It's just looked like you may have something to say. No?
No, nothing specific other than I do definitely feel like we need more information, which we're not being provided.
Okay. Can we decide on what that information is? Make it I mean, I'm a little compelled by Mr. Andrus's notion that based upon the type of information that was in Coronado, that these complaints are not necessarily, part of that. But at the same time, I'm also compelled by the attorney work doctrine that if these complaints are part of intelligence that would use to used in cases, then that is something that is I do agree with. But at the same time, if these are public out before that even happens, these are public documents that could be disclosed, then the question is are they disclosable by the by that? One of the things that the public defender has been bringing out is that they didn't disagree that they didn't have responsive records. They disclosed that they had responsive records, just that they were not public. And they cited Coronado to state that those responsive records are not public. And then further, that they were based on attorney work product doctrine. I don't agree around the attorney-client privilege because they've not cited any cases that around attorney-client privilege, and they may not even be able to. But that's part of privilege. So I'm not going to even go down that road. What applies in front of us is that. Member Yankee.
I was just going to note that I think that in your prior committee meeting that you had asked for this log, and obviously here we are and we don't have it, and we're now 2 hours into this case, and so I think to a certain extent we owe both parties some finality in this, and so it sounds like in your last compliance and amendments committee hearing you asked for this. Here we are, we don't have it. I would be hesitant to ask for it again and then to see this just us invest hours and hours and hours more time into this. And so we've already heard this at the task force, went back to compliance amendments, here we are again. And after all that work, I don't think we're any closer really to be able to make a determination. So I think we kind of owe it to ourselves, the other one, people who have been patiently waiting, and for Mr. Andrews and Mr. Vu to kind of give it some finality at this point. I'm not sure necessarily.
Okay. So I asked before, is there a motion? Okay, it's the only way we're going to move this forward.
Right, so I'm thinking of a way to potentially, I don't know, if there's a way to move that we just are at like an impasse, that we just, because we can't see these documents or even a list of these documents, we can't make the decision. And it sounds like no one wants to give us this list. So I don't know if there's a way that we could, dismiss the case without prejudice or something. But I just don't see us getting closer to a resolution by investing more time into this.
Right. So I suggest that at the very beginning of this that I was not comfortable because of the lack of information that,
right. And that gets
we
back
may not be able to make a decision. Member Wong.
I'm kind of curious, like with the information we do have presented before us, like can we make a ruling specifically on the request to like respond in a timely manner? I think that one is maybe unrelated to the records themselves.
Well, yeah, certainly. I mean, if somebody makes a motion on something like that, and then we could debate that, or whether the motion is appropriate or not. I would do that. If you're feeling like you're coming to some conclusion that leads to us to take some action, then let's do that. Otherwise, I would go with what Member Yankee is saying, is that we're kind of feel like we're somewhat at an impasse. We don't have enough information. If the public defender is not willing to provide any, that they're standing on their defense, then we just take it at that. Yes, we've commented in past, we cannot make a decision, and that we're going to close the file. And then Mr. Andrews or Mr. Vu can go the next step, because the local process would have been completed and complied with.
All right, I'll start then. I'll make a motion to close the file without prejudice.
Okay. Is there a second? I'll second it. Okay, discussion on the motion. Close the file. And to close the file only, without prejudice.
Right.
Member Highland, something? Anybody? Member LaHood, go ahead.
Do we think there was enough justification for the withholding of information? Are we satisfied with the justification?
I mean, I would argue I'm not sure we can be, because we still haven't been able to see it. So.
But we make decisions on lots of cases where we don't see the actual documents.
Right. What we do is we find a violation because they don't provide them. They stand behind some statute, don't provide us with the actual document, so we can tell that they're applying it properly. Are they implementing that exemption properly or not? That's what I'm trying to get at here. I mean, if we're gonna make a decision on a case like this, it's precedent for us too, okay? Which means it's precedent for the entire city, if not for the state, because we also make decisions on the CPRA. So, that's important. And if we find that we can't make it, for me, I can't make a decision because I don't know what is applicable to the public defender's office on the public or private side, or if it has authority to operate privately. I'm sure it does, but I haven't heard, where that is. Okay. And nobody's pointed it out to me. And if it's buried in some narrative somewhere and it's not explicit, then, I'm waiting for it. Member Highland. No? Okay. All right. Should we go to public comment? Okay. Any public comment?
Before we do, I don't understand what closing the file without prejudice means.
That means, go ahead, Member Yankee.
I was just going to say that I'm essentially proposing that we've reached an impasse. We're going to close your file. You've now fulfilled your administrative steps, and that you could take it to the next venue that may be able to give you that in-camera review or whatever other relief you seek. But I don't think that, like I said, at this point, we're going to be able to place, without being able to see those files, we can't place them or make a determination of whether they're in the public function of the public defender's office or in that private section of it. And so I don't want to continue to waste your time in this forum, meeting to meeting to meeting. And so basically this would close your file out and allow you to continue in another realm.
I appreciate that and agree, but isn't that by definition a violation of the ordinance? I understand that they won't comply, but what was the purpose then if the file's just closed? What I'm hearing is that you can't make a decision because they're not providing you the information, which I understand to be a violation of the ordinance. So why isn't that the finding instead of closing the file with no prejudice? That's a non-decision.
Yeah, but you're assuming that they are a public office that can disclose information. That's what we're asking for, and we're not getting that information.
Wait. So you're saying that it boils down to not knowing whether or not they're even covered by the ordinance?
Well, no.
Right.
Whoa.
Exactly.
I mean, this is, I don't know. This is news to me. So because I thought that was already understood.
Here's I think what I'm proposing, at least, is that they can't show us, not that them as an entity isn't necessarily covered, but the particular work products may not be covered by the ordinance. But if they were to show those to us, now it's part of the public record, and they've already gone beyond what they can't show it to us, because once they show it to us, now it is a public record. And so that exposes something that they say they can't expose. And so we keep going in this round and round thing.
Yeah. Well, now I'm concerned we're going on a different route, because now it's saying that they, somehow because we don't. So now your average public person has to come in and prove that someone is subject to the ordinance. I mean, that's the default position. They're a public agency. If it's anybody's burden to establish that they're not covered by the ordinance for whatever reason, that's theirs. And they've not done that. That hasn't even been brought up. And so to say we're just going to close the file then and not find that to be a violation of the ordinance is, I mean, I appreciate you're not wanting to waste your time or my time, but that absolutely just makes this entire process a waste of everybody's time. So nothing has been done. Zero. They produced nothing. We learned nothing. We've resolved nothing, and the file will be closed. And then I'm told I have to go start over in court. So they win, basically. And if this is the precedent that this committee is going to set with that decision, I would urge it to reconsider strongly, because now the precedent is agencies just come on in and throw out an objection and, say that,
Well, no, that's not
stalling.
actually. It's not accurate, Mr. Andrews, because most public agencies cannot define themselves independent of public government function. This is one of the few, if any, the only department that has this particular designation.
But it doesn't. You're asking if it does. They haven't provided you any authority that it does. That's my point. It is that simple, and it's their burden.
I agree with that question. I absolutely agree.
But then why is that not a violation? That's their burden. The burden is on the agency. Why is this being pushed back on me requesting documents? Which is what it is.
Okay, thank you. Okay. Is there public comment?
Yes.
Go ahead. Cheryl, do you have the clock ready?
You can go.
Go ahead.
All right. I empathize with the petitioner in this case. I think, I've had cases that go through a lot of hearings. At least in my case, at the end, I do have a ruling. But I would urge you to consider what Member LaHood said earlier. Oh, sorry, it was not Member LaHood. It was Member Wong. I apologize. About whether you believe it was alleged in the complaint, whether or not 6726 and 6727 were complied with, even if you cannot determine that these are public records that need to be disclosed. And in order to comply with 6726 and 6727, every single withholding of any information must be justified. And 6727 goes beyond the CPRA. they are unfortunately right that under the CPRA, courts have held you cannot demand a privilege log. But under the Sunshine Ordinance, it is not withholding of public records must be justified. Withholdings of any information must be justified with a citation. So unless in writing, the respondent has provided for each of requests 1 through 18 on page numbers 1,398 and 1,399, a justification that all of the records are not public records, or some are public records and they are exempt under this specific statutes or case law, you should, in fact, find a violation of 6726 or 6727 instead of just closing the file. And at least then, when they go to court, they can demand these written justifications if they're not going to provide it here. And I know you need 6 to 7 of you to pass a motion. And if any of you do not believe that you should just close it, I would urge you to vote no on this motion and offer an alternative motion for violation of either 6727 for not giving written justification for each and every one of these requests. Thank you very much.
Next speaker.
President Tedessa?
Shirley, ready?
President Tedessa?
Go ahead.
Go ahead, Mr. Tedessa.
Hi, Sunshine Task Force members. I am alarmed, very, very much alarmed, that the fact that you even would consider a closed session. I remember specifically in the past where the Chair Wolf has said that you are the only body within city government that waives the privilege, that specifically waives privilege in all your cases. I believe this is getting, you are becoming more and more opaque. You're not being clear with the public. You certainly have done that with my case, and I'm not targeting anyone in specific, but just as a whole, my experience has been the delays, the changing of rules midway has not been productive. Not only has it not been productive, it's harmed me. The fact that you are going to be considering a closed session of the Sunshine Task Force is antithetical to what we know about the Sunshine Task Force. It's sunshine for everything. That's why I believe now that the memos that you get from the city attorney's office were ended. This is why. This is a very, very, very sad development. The fact that you even consider going into a closed session is wrong. And it really harms the public, and it goes against what the Sunshine Task Force Ordinance was all set up for. Thank you.
I just want to clarify, the motion on the floor is not to go into closed session. The motion on the floor is to close the file.
Yes, but
which means that, I just want to state that.
Before that,
but that's not part of this,
particular.
But it's not pertinent. It's not pertinent to this motion. We're not discussing closed session, and
okay.
You know, the comments regarding a closed session are applicable to the motion on the floor. It sounds more like a general public comment about what we are to do or not. I'd like to continue with public comment on the motion on the floor itself, which is to close the file without prejudice.
I don't agree with that at all. You should not close the file. You should not have spent all this time with the complainant just to close it. That's not what the public is. When the public comes to you, there must be an extraordinary reason. And you should really, and I believe that you actually have said that, and I believe that you do generally side with the public. You side with the public who are perhaps a little bit naive, as I was in the beginning. Now I'm beginning to learn how these things work, and to make things to just close it, like I've had other cases of mine just closed without any explanation, without any finality. The task force has always said that they want some sort of tangible kind of final closure for the public. This is not it. That's it. Thank you very much.
Thank you. Thank you. Next speaker.
Yes, this is, how much time do we have, Mr. Wolf? This is Stephen Lloyd.
3 minutes. 3 minutes.
Okay.
And you'll get a 30-second interruption.
All right. whenever Cheryl lets me know.
Go ahead. Go.
Thank you. I wanted to say I agree with Mr. Andrews and support him. I do not feel that you should close his file, close his record. It feels to me like what you're doing is moving outside of your jurisdiction to make attempts to try and handle that attorney-client privilege question, which is not your job. Your job is to determine if it's a public record, how does it get released, and if it should be released. That's fine. Stay within your jurisdiction. He's correct. He brought you that request, and out of that request should come that answer, yay or nay. But that has to be asked of any public agency, whether it's the DA's office or it's the Department of Public Health. It doesn't matter. They'll do their job, but please stay in your lane. I would encourage you to do your job, which is to ask that question. That's the purpose of his complaint. Also, under 6724, public information has to be disclosed, even if it's litigation material. And there are specific exemptions where they're supposed to cite as the city attorney or the DA that a record was previously received or created in the ordinary course of business, or it wasn't, or whether it was attorney-client privileged. They're supposed to demonstrate advice on compliance, analysis, and opinion under 6724. They have work to do. That's what Mr. Andrews asked you for. The question of attorney-client privilege in case law, that's for the injunctive component of the court, and the court will decide that. That's all I have to say in support of Mr. Andrews. Thank you.
Thank you. Next speaker.
Yes.
Go ahead.
So, yeah, I have concerns about the implications of this. You know, if the public defender's office can claim that they can't, provide a document because of attorney-client privilege without, explaining what the documents are, how broadly can they use this? Does this mean that people can't ask about the finances of the public defender's office? How is the public defender's office just totally immune from public records requests? I understand that certainly with regards to specific cases, there's attorney-client privilege, but if the public defender's office has failed to show that there is a specific attorney-client privilege, then why would you just throw up your hands and say, fine, we're just dismissing the case? I think it's a failure on the part of the public defender's office to show that there are documents that they can't provide. I don't know. Is there some sort of mechanism by which the public defender's office could say, I don't know, provide it to your counsel that wouldn't make it public to everyone, and your counsel could review it or something like that. But yeah, just dismissing the case. If this, I feel, I think it's just very concerning. And yeah, I've sort of lost my train of thought. And I'm probably running out of time. So yeah, I'm strongly opposed to simply dismissing the case. But yeah, if the public defender's office refuses to produce documents, then shouldn't the case be found in favor of the complainant? All right. Yeah, I think I'll end there. All right. Thanks.
Next speaker. Okay, public comment is closed. The item is back with us. Any further discussion or debate? Go ahead, Member LaHood.
Can we have further discussion of what Member Wong brought up with 6727?
Well, the question is before us. The question. So, let's finish a debate around the question that's on the floor. If you, you can make a substitute motion. You can request it to be, pulled back. You want to, you can amend it. But let's keep within our process.
I'll just quickly address that if everyone looks at their PDF package on our page 1475 and 1476, it's the letter that Tyler Vu wrote back to Mr. Andrews and cites the Coronado exemption for everything for items 3 through 16. So I think that exemption was claimed. I mean, I'm not saying it's a good exemption, but I just don't know how we can figure out if it is or is not a good exemption without seeing these records, and it doesn't seem like we can see these records. But I'm not sure, but I'm open to rescinding if someone can point me elsewhere. But it does look like they timely invoke that as their exemption, Coronado. So.
Yeah, but they're claiming all documents. And it's not specific to, that's a question to me. I mean, they did provide, records that are redacted that I see, but there are communications between them. But the question is it's not whether it's just all documents. It's the question of documents related to misconduct. Are those part of, as a public speaker had noted, 6724, what must be disclosed as part of litigation material. Okay, litigation material is material that's already in litigation and being prepared or being, used as reference. That's the way I'm reading that. I'm kind of leaning towards what some other folks have said, is that the based upon 67. 25, 26, and 24, did, and what Member Wong had brought out, whether they fulfilled their duties under the Sunshine Ordinance. And I think that's something that we can make a determination on.
Sure. I'll rescind my motion. I think you seconded.
I'll go with that too. So the maker and the second has rescinded the motion. So we're back on the floor. Is there another motion? Member LaHood.
I mean, just so we're going through the documents and what has been presented, just to make sure that everyone has seen, and I know we've discussed this before in previous points. So starting on page 1446. There's, what is known as the Rusi memo.
Yep.
That does give a slightly more detailed response for the withholding. And I just want to make sure that we look at this and say, is this adequate or was this not adequate? Because it grouped together all of, these whole listings and said, these are all exempt because.
But the Rusi document is a response from the city attorney, not the public defender.
No, concerning your public record request to the San Francisco Public Defender's Office.
Yeah, but was that a request of the city attorney as the supervisor of records?
Yes,
it's a petition to. It is. It's a petition to supervisor of records. Okay. It's a petition to supervise the record. So here, Mr. Andrus has brought it to the task force because he wasn't satisfied with the response from the supervisor of records, which is applicable under the ordinance. That's a, you know, actually the best way to kind of go about it. You know, but I think what you brought up before, Member LaHood, around the actual, and along with Member Wong, around the actual implementation of the ordinance with regards to responding to Mr. Andrus, I think that there's value and merit there. And as we have heard from public commenters just earlier. Anything? All right.
I'm sorry, Chairman. Let me tell you what's bothering me, which has me just hesitant. It's just that I want to figure out what the nature of the misconduct is that's alleged here, or, you know, whether it happened or not, et cetera. Because to me, if it's misconduct which is brought up, addressed in the context of a litigation, if it's misconduct where one of the attorneys, for example, goes to the judge and says, I want this, my opponent cited, then to me that seems like it's Coronado. But if there's some kind of a sort of a group of public defenders who are having some kind of a collective decision-making process about some prosecutor who they think is, you know, out of control or something like that. And I just don't, I don't quite know yet where we're at, but that seems like it might be not really connected with any case or any series of cases, and that would be not Coronado. And so it seems to me that either we, you know, since we don't know, we might have to give up at some point, or we, if we fashion an order, we say, unless it's connected to a case, whatever you haven't produced, we order a determination, you violated the sunshine requirements. That's my sort of ambiguity in this case.
Well, I'm kind of, what you're saying, I'm floating in and out of it, because on the one hand, you're asking for what's the intent of getting the information. That's not our purview, is to make any judgment on that. But I get what you're saying about knowing what's the content of the record is in order to determine whether it's an actual public record or not. I get that. I really wish that we could go down that road, but now you're going to ask one of the other parties to try to produce something that's not going to happen. And I think what Member Wong is trying to put forward is that is some sort of non-compliance with the ordinance, and we can adjudicate based on that. It's just like we do when people refuse to provide documents. You know, we can find them in willful failure. I'm not saying that there's necessarily willful failure here, because they were prepared to provide something and some documents, but just not publicly. Okay, and in that way. I am compelled by 6724 on public information that must be disclosed. That's 6724B with regards to litigation material. Very short. It's in sub 1, notwithstanding any exemptions otherwise provided by law, which is what we're struggling with. The following are public records subject to disclosure under this ordinance. Pre-litigation claim against the city is sub small I, sub double I, a record previously received or created by a department in the ordinary course of business that was not attorney-client privileged when it was previously received or created. So if the document was not in attorney-client privilege when it was originally created, then it's a public document. And the third one really doesn't apply. Advice on compliance with or analysis of an opinion concerning liability under or any communication otherwise concerning the CPRA.
There is a little bit of a detail in that Sunshine Ordinance is going to have to be subservient to Coronado because Coronado's state law.
That's right, but we're trying to decide whether those records are applicable to Coronado. If you agree with that, that's your opinion. I think some of us are not quite sure. And I think I would go more towards what Member Long was bringing forward and echoing some of the other comments that were made was that we have asked for certain documents to be delivered to the petitioner. There was agreement to provide at least a listing as required. And the question then becomes based upon what the response was, that in items, whatever is 3 through 15, whatever it was, that they were applicable to Coronado. I don't know that that's enough. I don't think that has convinced us enough. It's like, okay, so what about those documents are part of that Coronado protects? So I think it's the question before us.
Sounds like the idea here is to find a violation because they haven't really satisfied their burden. Is that what?
I think that's exactly right.
Okay, well that makes sense. It's reasonable.
I mean, we're not making a decision on the documents or whether the documents are public or not. I don't think the way we look at things, I don't think we can. There may be somebody else who can look at it in a different way that is within their jurisdiction to look at it. But I think in our jurisdiction, I'm not finding a way to be able to do that without seeing the documents. Our legal counsel said he refuses to be part of in-camera review, so that's not going to happen. He doesn't believe that the task force can do it, which would bring possible action against the task force. I'm willing to do it in order to try to satisfy the ordinance so we can come to some conclusion, because that's what I'm in service for here is for the ordinance and who the ordinance serves. I don't know that that's going to come to fruition.
Yeah, if I felt like I knew what the heck I'm doing here, but it's just my first meeting, I'd probably make a motion to order a privilege log and see what the public defender's office says. But
we've already done that. Right? That's what the committee this was referred to committee in order to follow and monitor some compliance. So the agreement for compliance to get the ball rolling was to provide a privilege log.
No, I'm saying.
Whoops. You lost it.
Is it possible to make a motion to find a violation of compliance in that sense?
Yeah, that's exactly what you were asking for before. So it's like keeping withholding to a minimum, justifying the withholding. Now, I'll get back to you in a second, Member Schmidt. The question was, can we find them in violation of just being whether they're in compliance of the ordinance or not, just as a matter of function. So go ahead, Member Schmidt. You were in the middle of your.
I'm sorry, my Microsoft.
Yes, it went
second
dead.
time. But at the compliance hearing, there was some kind of a let's all agree that we're going to do it a certain way. And what I'm saying is no more of that, but say, okay, we're going to order you to do it. And if they say no, they say no, and they might say, well, you don't have the authority to do that, and they can refuse. But at least then we've made the order, because I'm not sure, unless you guys may tell me, what are you talking about? We can't do that. But I'm not quite sure if they could refuse an order that, give us a privilege log and list what you think comes within Coronado and what you think doesn't. That's what I'm talking about.
Well, we already did that.
No,
and
you didn't order it. You didn't order it. You asked for it, and apparently they didn't say they were going to give it, or they're not sure.
The action was moved by Member Josh Wolf, seconded by Member Highland, to affirm that the respondent has agreed to provide a privilege log to the petitioner on the items requested. Are you saying that the task force should compel them to do it?
Well, affirm that they have agreed. Yeah, I'm saying that's not an order. That's okay. That's I don't know what that is.
Okay, then I would say if we want to continue the case, then make a motion for that. But let's make a motion and move on, because yes, there are other cases. We already knew this was going to be a long meeting, and this was going to be a stickler.
I'll make a motion. This is Member Wong. I'll make a motion to find a violation of compliance.
Okay, but we need a section of ordinance.
Of the code.
I'll say section is 6724.
So 6724. Do you have a subsection? Because there's a lot of stuff.
Yeah, subsection B.
Okay. Is there a second?
I'm in a second.
Okay. Moved by Member Wong, second by Member LaHood. Discussion. This is on the motion and only on the motion of finding violation of 6724B.
Yeah, I have a question too. So it looks like that's litigation materials. Is this in regards to a privilege log? Does a privilege log be something that we asked them or compelled them to create, not pre-existing litigation materials? I'm not sure that would necessarily apply to a privilege log, because right now a privilege log doesn't exist. So it's not litigation materials, because they may not be making one for us, but I'm not sure to currently exists and they're just not turning it over.
Go ahead, Member Wong.
Yeah, so I think my motion would be specifically in compliance of like the records that are being requested. I feel like it either needs to be they're not providing it due to Coronado, or it needs to be because of attorney-client privilege. And I feel like you can't, it seems like they're not providing both reasonings for all of these records. And like this one specifically, this particular section of this ordinance specifically refers to attorney-client privilege, not the state law, as far as I understand it. And then in terms of the privilege log, I would make a motion if we have a section of the ordinance related to that, because I feel like that's also non-compliance.
Well, that would be section 6726, withholding kept to a minimum.
Is that a separate motion or taken together?
Member Wong, do you want to amend your motion to include that?
Yeah, I'll amend my motion to include that.
And will the second agree?
Yes, now I'm looking at this and I'm wondering, so if 6727, which is what we were originally talking about, now I lost my page. I mean, we had justification of withholding, but I think the issue was we felt as though it wasn't detailed enough. It was just sort of broadly, you know, we're not going to give 13 through 15 because of Coronado. Are they required to tell us we're not giving you these specific documents that that fall under this category for this reason? Do they need to provide more detailed explanation of what they are not giving?
Well, that's the point. I think the justification part, if you look at 6727B, withholding, they must provide any withholding of information shall be justified in writing as follows. A withholding on the basis that disclosure is prohibited by law shall cite the specific statutory authority in the Public Records Act or elsewhere. So the specific statutory authority is Coronado. So they've satisfied that part, but 6726 states information that is exempt from disclosure shall be masked, deleted, or otherwise segregated in order that the non-exempt portion of a requested record may be released and keyed by footnote or other clear reference to the appropriate justification for withholding required by this section of this article, 6727. That's the kind of the thrust of that. Now, the respondent's argument to that is they're not public. Well, okay, then they're going to go back and cite Coronado for each of those documents. Okay. Now the question is have they satisfied that or not? As the motion on the floor is trying to do. Are we satisfied that that has been done?
I'll speak for me personally. I think we're back to where we were at the beginning. I mean, maybe Coronado, maybe not, but we can't tell because they won't show us. They won't even give us the list. And they won't give us a list because they say they can't tell us those document types because that would already be too revealing. And that even revealing what those documents are, anything more than just hypothetical, would be protected by Coronado. So I think that's kind of where we're in this situation where we don't have enough information to appropriately judge it. I would love to have a court case and say, no, they need to give us a privilege log, and then we can compel them to do so, or to make it.
So you're saying 67? If you're talking about that, then the question is on withholding kept to a minimum. Is this below the minimum?
Well, I'm just saying I'm not sure what if it's true, and we can't tell if it's true because they won't show us, but if, let's say, Coronado were to be true and all these were to actually be protected by Coronado, then yes, I think they did everything they needed to do. They said in writing, document, for items 3 through 16, Coronado applies to all of them, and it very well may, but it might not. But we can't tell because we can't see. So I would feel uncomfortable saying that they violated it. I'm not saying that they didn't violate it either, but I don't think we can affirmatively say they did violate it because we can't see what those documents are.
Okay.
So perhaps we don't have that, just have it separate motions, or just stick with the original.
I mean, I'm not sure about 6727 because both in testimony and in some of the passages in writing, that somewhat, to me, was enough, I think, justified some withholding. I think the question is whether we got enough information in order to be able to make a determination of that. I think it's like an A and B part. They did A but not B, and so that's. I'm not quite willing to include 6727. I mean, they did state that a withholding on the basis that disclosure would incur civil or criminal liability. They shall cite any specific statutory or case law or any other public agency's litigation experience supporting this position. That's pretty compelling, as far as a justification with withholding. They did. They made that in that justification in writing. Question is whether we think it's the justification is proper or not. And then the other part is whether for their purpose, Coronado provides them with specific permissive exemption. I don't know about that. Maybe. I mean that would be better answered by a lawyer. Maybe I'll ask DCA Price Wolf. Does Coronado provide specific permissive exemptions?
Do you mind reframing what you mean by permissive exemption?
I'm reading it word for word under 6727 under justification of withholding. It says any withholding of information shall be justified in writing as follows. A withholding under a specific permissive exemption in the California Public Records Act or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. And the question is Coronado that authority? We're just looking to see if they complied with the ordinance or not. We're not trying to adjudicate.
I don't think you need an exemption if it's not a public record anyway, and so you don't need to get to that level in the process of elimination.
I agree. Yeah, that's exactly what I was going to say. It's before even talking about whether an exemption applies. If it's not a public record, there is no need for an exemption to apply.
Right. So the question is we're back to, do we have enough information to be able to determine if it's a public record or not? And the responses from task force members is we haven't been able to see the documents to be able to make that determination. Okay, and so now we're finding, we have a motion on the floor to find the violation of 6724 and 67, I think 6726, or maybe not. Yes, yeah. I got a nod from Member Wong. 6724 and 6726. 6724 because it allows under B, under litigation material, record mostly in B1 small double I, a record previously received or created by a department in the ordinary course of its business that was not attorney-client privileged when it was previously received or created. Okay, there's that part. Okay. That goes back to whether it's also a public record or not. Okay. That only applies to public records. And then the withholding under 6727 because we don't have enough information. We don't think we have enough information. So here we are.
Is it 24 or 26?
It's 24 and 26.
I'm sorry, you said 27. I meant to say is it 26 or 27? You said 27.
Yeah, no, there was a question that was brought up about 27, right. And we were just discussing whether that could apply also. I personally am not compelled by that.
Can I ask one more question?
Sure, of course.
So looking at 6724 B1 two small i's.
Right.
This could make sense or it could not because we don't know. And that's the problem. Like it could apply. It might apply and it might not. And we just don't know. So I'm looking at this again. I don't know that we can, I'm going back to where we were before. I don't know that we can find a violation because we don't know. We don't know if this is included among the documents.
Yeah, I think I'm in full agreement with Member LaHood. Without being able to see the documents, without being able to do some type of in-camera review, I don't think we can make that determination. And I don't think we have necessarily that ability to do in-camera review. So
okay, so everybody, so you're stating that you cannot make a determination whether these documents are public or not.
That's kind of where I'm at. That's kind of like my understanding of where Member LaHood is.
Okay, so would you still agree?
Sorry. Yeah, I feel stuck.
Stuck. That's where I'm at.
Would you still agree with 6726 then?
I don't think so because there might be a likelihood that all these are not even public records. That if an in-camera review would say they're all Coronado subject, therefore they're not public records. If that were to be the case, and we don't know because we can't look, but if that were to be the case, then I don't think there is a violation of 6726.
Well, 6726 does not specify public records. It specifies any record that could be applied to California Public Records Act to be determined whether it is exempt or not, public or not.
Well, which part of 6726 would apply if they're not public records? Would they be in violation of? Potentially.
Well, the point is if we are going to assume that all records are public records until proven otherwise, and we are not able to make that proving because they've not provided us with enough information, then I would say 6726 applies.
I don't think we can make that determination without an in-camera review of the documents. I think it's within the realm of possibility that they're not public records if Coronado truly applies. Now, I'm not saying it does.
But all 6726 is asking for is that each of the records that are being requested are keyed by a footnote or other clear reference to appropriate justification. So that's the activity. That's the function of 6726.
Right, but I'm not even sure they can give us the list of those records to key them. I mean, they've been clear in writing that any responsive records for 3 through 16 are protected by Coronado. So I'm not even sure that they could give us a list of the titles of those documents to make that key, because that would already be potentially violating Coronado.
But the petitioner is saying that it has no application at all because it happened outside of any work that they would be doing on the private side of things.
Well, that might be true, but I don't think we know enough to know if it's true, because I haven't personally seen any of the records, so I can't say that the petitioner's right by saying that, or I can't say that the respondent's right by saying that Coronado, because we haven't seen any of them.
Well, then the question is, have they complied with the ordinance at this point? Then
maybe not.
I could make one clarification, which is if someone just describes in some way, like in a privilege log or in one of these other documents, describes other documents, that's not going to waive any of their privileges over those other documents, unless they substantially included substantial amount of what's in those other documents. But privilege logs do not. They don't eliminate any of the protections that documents would have.
Okay, so does that change what we're doing? Does it add to it?
So Member Schmidt, are you saying that they could give us a list of descriptions of these documents that would not violate Coronado, but would still give us more insight into what those documents potentially contain?
Absolutely, yes. They can give some identifying information about the documents, but that's not going to waive. It's not going to turn them from private to public. It wouldn't waive attorney-client. It wouldn't waive work product. That's why these things work, is because they can, give us enough so that we can rule in their favor and say, oh, you're right. That is privilege, or that is part of your private function. Good, fine. So that's why these things are used fairly often.
Well, if that's the case, then I would be actually inclined to say that they should have provided more information and would be supportive of the motion. Because they didn't.
Well, the other thing is if we don't agree with the justification, that's a violation.
Well, yeah.
I mean, the question is, if you don't agree that they apply, that's what I kind of, the repeating theme for me is, have they complied have they applied the correct citation in order to exempt or withhold these records?
Yeah, certainly they can object, and then they put it into a.
Lost the signal again. There. All right. Well, while we're waiting for him to come back, I'm not inclined to have any more discussion on this. Sorry, go ahead. Here he is. We're losing you. We didn't hear any of that, but you said your signal was cutting out. All right. So what I'm thinking of doing at this point, if we have a motion on the floor. We can vote it up or down. Okay, I can't suspend the meeting and move. What I'm going to suggest is that we suspend the meeting at this particular case and move it to a later part of the agenda, so we can hear the other cases that people have been waiting patiently around for. Because we've taken up a more than enough time to try to come to some conclusion. I know that both parties think that they have the answers and what we should do, but obviously we're still somewhat missing some parts in order to be able to come to that conclusion. So The only way it can do that is to remove the current motion on the floor for it to be rescinded.
Rescind the motion that was moved by Wong and second by Lila.
Yeah, if that gets rescinded, then by the maker and the second, then what I'm going to suggest is that we table this item to the end of the meeting, near to the end of the list of all the current cases that we have yet to hear, and then we come back to it and make a decision on what we want to do. And we're just really spinning our wheels here, and then partially going down a rabbit hole and coming back up. And
all right, is this a
I'm not making Cheryl. I'm not making a motion.
Okay.
I'm giving some direction.
I will rescind my second.
I will rescind the motion.
Okay. Then I'm going to move that we table this item to the end of the case list. But before, let's see, I move it to agenda here.
Before item 12?
Before item 12. But we must come back to it because I tabled it. If the meeting ends and it's not continued, it will die under Robert's rules. Okay, I'm sorry, parties. I'm sorry, members of the public, and that this has been so onerous. But we're trying to do some due diligence here, and I think we're just not willing to take things for granted at this point. So I made that motion to table this item to just before item number 12 on our agenda.
Is there a second?
Is there a second?
I'll second.
Who was that?
Highland.
Okay. Highland. Okay. Any discussion on the motion? Seeing none. Any public comment on the motion to table?
Yes, please, Anonymous.
Hang on.
May I begin?
Okay.
For sure.
You can start now.
Go ahead.
All right. I would urge you either to not table it or to, when you table it, do this. Because I'd urge you not to table it because if you look at pages 1,472, which is page 78 of the item 7 PDF, and 1,473, which is page 79 of this PDF, the 6726 violation is very clear. He asked for documents about this Heather Knight article. They gave them the documents, and there are no footnotes or other clear references. Your chair is absolutely right. There's a clear 6726 violation. Instead of tabling it, I urge you to move for a 6726 violation and then send it to compliance. And if they don't provide a footnote or other clear reference for each and every portion or full document withheld, then bring it back for a motion for willful violation by the public defender of willfully not complying with 6726. And that is what I would urge the task force to do. Thank you very much.
Any next speaker? Okay.
Yes, Mr. Malloy, real quick.
Hang on.
Go ahead.
Go ahead, sir.
Sure.
Thank you. In agreement with Anonymous and in support of Mr. Andrews, I agree with that. The ordinance is clear. The citizens of San Francisco solved the debate that I feel that you're having. And the public defender and the city attorney and the DA's office agreed with that ordinance and to submit to the ordinance. So the requirement is clear. Identify the footnote. And if there's other items, as you cited in 6724, they're to identify those for you. That's their job to do that. And just because you don't have the record doesn't mean you should close the file. You should ask them that question, and then their job is to answer you. And it is that answer that then gets solved by the court if necessary. But their responsibility under the law is to give you that answer, and they have violated 6726. Clearly, they didn't do the footnote. Now they get to go back and come to you with that answer from Mr. Vandries, which is what is and what is not underneath attorney-client privilege. Thank you.
Next speaker.
And so I would suggest that you decide that now versus tabling it as well.
Next speaker. Okay, seeing no other public comment. Members? Great. Go ahead, Member Yankee.
Speak briefly. I think Anonymous, I think we were so wrapped up in the items 3 through 16 that he did point out a, I think, fairly obvious violation of redaction without any justification. I think we could, based on that alone, find a violation of 6726, and then to the extent of what it applies or not applies to 3 through 16, they could, move on and litigate that, but I think that would at least give them some closure from us, because I think that violation's pretty apparent that there is no footnoting of that redaction. So I would maybe request to amend the motion to find a violation of 6726 based on
you can do a substitute motion to override.
Yes, okay.
It.
So I would move to substitute that motion, finding a violation of 6726 for not footnoting or giving a clear reference to appropriate justification for withholding, as required by 6727.
Is there a second?
And could I second that, even though I seconded the original motion?
Sure.
I second that.
Okay. Moved by Member Yankee, second by Member Highland. Discussion. Seeing no discussion, public comment.
Yeah, I'd like to make public comment. My name's Win Shapilier.
Okay. Cheryl?
Hang on.
Okay.
Go ahead, Mr. Hillier.
Thank you. Mr. Chair, you mentioned Robert's rules that the motion would die if it's not handled tonight. I've got a copy of the 12th edition of Robert's rules, came out last month, paragraph 21:7A and B deals with when adjournment does not close the session, and when adjournment closes the session in an assembly having its next regular business session within a quarterly time interval, and having no members of whose terms of membership expire before the next session. Both of those paragraphs say that if any question was pending at the time of adjournment, it is taken up as the first item under unfinished business. Back to you, Mr. Chair.
Thank you. Thank you for
reminding me of that section. Oh, sorry.
Next. Who's next?
Anonymous.
Okay. Cheryl?
Hang on.
It'll be 10 seconds.
No, seriously,
Okay.
Anonymous, hang on. Go ahead.
All right. Obviously, I urge you to vote in favor of this motion, and it should be watched by your compliance committee, because I don't know if they will comply and tell you why each and every one of these lines in these documents is exempt under a specific clear reference or footnote. Thank you very much.
Next speaker. Okay. No more public comment. I'll make that, if you can make it part of the motion. The chair refers this item to Compliance and Amendments Committee if it is approved. Okay, you ready for a vote? Okay, please call the roll.
Hang on. All right. Just so I have it clear, Member Yankee made the motion. Is
Mm-hmm.
that right?
That's correct.
And Chris seconded it.
Yes.
Yes.
Member Yankee?
Aye.
Member Yankee, aye. Member Highland?
Aye.
Member Highland, aye. Member Schmidt? Member Schmidt?
He's thinking.
You're on mute.
He's on
Aye.
mute. All right.
Aye, sorry. Mute.
All right. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion passes.
Okay.
So we are on to item 8 now.
On to item 8. Now, I'm going to ask, is the, let me ask, is in item number 8, is the police department SFPD here? Probably not. Probably still in there.
Probably still on their emergency.
I'm here.
Say, I know anonymous.
We know that.
Let's do. I think we all kind of need a 5-minute bathroom break. I wanted to ask, maybe we could go through number 8 since only one party is here, and determine how we want to move forward with that. I don't think that will take too long at this point. Is that okay with everyone? Okay. So,
am I permitted
Cheryl,
to speak or no? Okay, sorry.
well, let's bring number 8 to the floor first, and then we're going to have that discussion. So, Cheryl, just for the record, please call item number 8.
Item number 8, file number 19098, complaint filed by anonymous against police department for allegedly violating Administrative Code Section 6721, 26, and 27 by failing to respond to a public records request in a timely and or complete manner.
Okay. So
this was heard on September 15th by the complaint committee. They found the records public and they referred the matter to the task force.
Okay. So okay. So the question here is, we only have one party here. It is in the interest of the petitioner, as part of our rules, whether it should be continued or not.
I just want to say one thing, Bruce, and that was that in the email, I just want to remind you that the police department, that Officer Andrea Check asked if this case could be continued, because he didn't think he'd be able to make it due to this emergency.
I understand that. Our rules allow some weight to be given to the petitioner. So we shall do that. And so, so let's open the floor to anonymous. I'm just going to give you a few minutes to state your case, and then that way we can make a decision.
Okay. So I believe, according to rules, I'm only supposed to argue why you should actually.
Hang on, timer.
Oh, sorry. I
Timer,
apologize.
Yes. You get 5 minutes.
I'm sorry. Am I
sir.
presenting my case or arguing why you should proceed?
No, wait,
I need to know which one you want me to do.
Cheryl, he's not presenting his case. I'm just giving him ample time to discuss whether we're going to continue this or not.
All right.
Because he has some privilege under our rules.
Okay.
Go ahead, anonymous.
Thank you. So yes, I do, and I believe if it's not within 5 business days, it's my right, at least, to suggest whether you should continue or proceed. I would like to remind you, I've been waiting 4.5 hours for this. I was not told or emailed by anyone that this wouldn't occur today. And also, they have done this in the past. I believe there's like one excused absence you give. Sergeant Drachek in the past for this hearing, not other hearings, this hearing did the same thing. He said, well, I have an emergency, I can't do it. That delays all of my complaints by 1 month because of the 2-complaint rule. And if you don't hear today, all of my complaints will be pushed off by, I guess, half a month. It's 1 out of 2 complaints. So I would urge you to let me state my case. There are people from your committee who can kind of inform you, because they actually asked them to do certain things during the committee hearing. And I don't think it's fair for them to now get a second continuance. Under the law, the respondent is the police department, and I actually named not only the police department, but the police chief and various command staff. They are required by law under 6721E to send a representative. If Sergeant Andrzejczyk cannot make it, Lieutenant Cox is an employee of the police department, someone else can do it, but it's not fair, and in the past you have agreed with me, it's not fair that they just don't send anyone. So I would ask you to let me proceed with my case today. Thank you very much.
Okay. And just so everybody knows, we have adjudicated cases with the lack of one or both parties, as is our privilege to do. Okay, so if I don't hear a motion for continuance, so I suppose that we'll proceed. Okay. I will state that after this item, we will take a 5-minute break really fast so we can continue with the rest of the items on the agenda. And so I apologize to both all the parties for how long this has gone, but I think it's appropriate. Okay, so let's start the process for file number 19098. Petitioner Anonymous has 5 minutes to start. Cheryl, whenever you're ready.
Go ahead, sir.
Thank you very much. Thank you, Chair and Madam Clerk. We'll begin on page 15 of the PDF for item number 8, part 1. So please open that up. This is a case versus both the police department and various named members of the police command staff. Last July, I made a request for emails, chat, and text messages of various senior leadership. They gave a rolling response according to this timeline for quite some time. I filed a complaint on September 13th of last year for 12 alleged violations. On September 15th of this year, your committee asked them to produce, not ordered, because just a committee, asked them to produce various records that they hadn't. Next page. The first issue brought up by this case, and your committee members can explain, is I do not believe the police department complied with City of San Jose versus Superior Court 2017. Any public record does not lose its status as a public record merely because it is on where its location on a personal property. And in this case, SFPD unlawfully told its employees, quote, if you do not use your personal email and or mobile phone for work purposes, you don't have any responsive documents. As I discussed at committee, that's false. If you receive emails, for example, you're a commander and you never use your email for personal email. If you receive like one of your subordinates saying, hey, there's this misconduct happening, that record was not searched for and must be provided. Your committee, I believe, asked for that broader search. Second, as you see in the second slide, these are not, quote, copies, end quote, of the original records. As Chair Wolf discussed, I believe in the very first complaint I bought, you can't print and scan electronic records. You're destroying attachments, color, hyperlinks, all sorts of things. This is not even about metadata. It's just about you can't just print out electronic records. Next page. They did not key their redactions by footnote or clear reference to justifications. I believe they accepted that. They have now, because of all my complaints, started doing that. As you know, it's about what the complainant did or the respondent did at the time of my complaint. Their new practice is to provide footnotes or clear references, but they did not do so when I filed this complaint. And then the final page is about metadata. As for the new folks, I'm sure the other members can explain. You have held that email metadata is a public record. They did not give me any email metadata in this case. However, they did give me text message metadata. They did not claim metadata is not exempt, but they did not give me the from and to. Who is sending these text messages to whom? And if you don't know that, you don't know a fundamental part of how to understand these public records. There are numerous types of violations I'll ask you to find. I'm happy to take any questions. They're on the final page here. And I'm happy to answer any of these questions. I believe they've actually accepted some of these. They just haven't finished complying. And you can talk to your committee members for more information. Thank you very much.
Okay, any persons or witnesses providing facts or evidence on behalf of the petitioner? Seeing none, respondent, are you present? Okay, respondent is not present. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Seeing none. Okay.
Chair, I'm sorry.
Yes. Who is this?
Chairman, it's Lieutenant Cox. I just wanted to state for the record that the emergency that Sergeant Andrzejczyk went to was the untimely death of a San Francisco firefighter. So that was in the minutes.
Yes. Thank you. Okay. Okay, members, the item is with you.
Could someone from the complaint committee give us an overview of what the response was at that meeting?
Oh, yeah, that's a good idea. Thank you.
Cheryl, was this at the 15th meeting?
I didn't hear you. I'm sorry, what?
Was this at the 5th? Was this an army? Was this at the 15th?
Complaint meeting? Yeah, I believe it
Complaint,
was.
yeah.
September 15th.
September 15th.
I'm struggling to remember what this one was because we had the police commit, or not the police commit, the police department a couple times. Matthew, do you happen to remember?
You're on mute, Matt.
Can you hear me now?
Yeah.
Yes, we can.
Sorry about that. Okay, so I think the two main issues that we talked about in preparation for this was the City of San Jose search, that they said they would specifically ask those people to check their personal accounts for any relevant communications. And then we also kind of did a quick education with them on the metadata and why they need to turn over the metadata for I believe it's the emails as well.
Mm-hmm.
So that was kind of the preparatory talk that I recall for this meeting, and obviously, here we are.
Right, and we had asked them if they could do that, produce those before this meeting. That was kind of the homework.
Right. They would come here, being able to say, yes, now we've asked everyone to do the search, and here's the metadata, and obviously they're not here.
Yeah, they're not here, so yeah. So I guess live on that raises probably more questions than answers for you, but that's correct.
Cheryl, this is Chris. I'm not able to open the link for this, so I'm just wondering, did the respondent provide any material in response to that?
I believe he did, yeah. I mean, I believe there was a letter.
Member Highland, for numbers 8 and 9, you have to look below, and because the files are so large, there are multiple attachments, and you have to click on each of those.
All right, I'll try that. Thank you.
In the agenda.
In the agenda, Chris.
In the agenda.
All right, thank you.
Yeah, the actual one. Yeah. So,
can you ask me if I've received it?
Yeah, sure. Go ahead. Have you received it?
No, I haven't. That's the problem. There are responses like way back when, but I haven't gotten anything from what the committee asked them to do, because I would love that, but I haven't gotten anything. So.
Okay.
Yeah, I think this one was pretty clear from our committee standpoint that there were the violations that that Anonymous pointed out, and so if he hasn't, received anything, by now I'd be concerned about that.
Yeah.
Yeah, they were, according to my the minutes, that it was Lieutenant Andrzejczyk. Andrzejczyk. Okay. Stated that they were still processing some of the records, and due to COVID, they everything was moving at a snail's pace, and that he also was unaware of any rulings regarding metadata, and that he would ask officers to check their personal email accounts and will provide that information. So since then, since September 15th, Anonymous has testified now he's received nothing. And we don't have a response, I don't think, from the police department on, it's not noted on the cover page. I don't remember the
Can I amend my correction? I want to amend my testimony so you guys make the right decision. If I may.
Okay, slow down.
Members, is that all right?
Oh, sorry.
Hold on. I just want to get a nod from folks if folks think that's okay. Yes? Okay. Go ahead.
On September 15th, they have sent me not what you asked them to send me. I don't know if that's before or after. I can't see the time. It's just a date. On September 15th, they sent me the records of, like, they were still processing from ages ago. What they didn't do is what you asked for. Like, they were just sending other command stack. There's been no response from them on either the metadata issue, text message, or email, and there's been no response regarding the city of San Jose. I wanted to make sure they did respond. That was just a continued rolling response of other stuff that they hadn't provided. Yeah.
Okay. Okay. Any other questions or information you need to get? Cheryl, are you aware of any response since September 15th from SFPD?
Since I didn't get anything. When I put the records together, I carefully reviewed my emails and put, the relevant emails that were related to the matters in the case. Everybody had a chance to get records to me by last Wednesday, a week ago today, because I was putting the records together on Thursday and uploading on Friday, and if I didn't get it by Thursday, I was certainly looking for stuff, then I didn't get it.
Okay. So there's been no response from the respondent. Okay, thank you. If there's no other questions or needs, then we can move to rebuttals.
All right.
Okay, hang on. Okay. Whenever we're ready.
I would. Oh, sorry.
Go ahead.
All right. I believe I have 3 minutes. So I would just ask you to look at page 19 of item 8, part 1. That lists the violations. And I would like to remind you, they have the opportunity within 60 days of you issuing this order. If you think I've lied or they think I've lied or something, they can file for a rehearing if I am somehow testifying falsely. They have that right. And yes. There are 5 violations I would ask you to find on page 19. There it is, 6721B, because they did not, quote, provide a copy of electronic records by printing and scanning them instead. 6721K, which requires complying with the CPRA. City of San Jose versus Superior Court is an interpretation of the CPRA, and it is binding on you and them for failing to search for all personally held public records within the scope of City of San Jose versus Superior Court 2017. 6726, by withholding the to and from of the text messages without any justification, and by withholding all of the email metadata, namely the email headers. And then another 6726 violation for not keying by footnote or other clear reference the redactions at the time of the complaint. Again, they have changed, but I believe you have held it's what their practice was at the time of the complaint that matters, not a year later. And finally, 6727 for not justifying the withholding of information writing. I think we can just ignore that one. Let's just go with the first 4. And I would ask you, as I have in the past, to 1, refer to compliance so they can tell you what they're doing here. And also, use very precise wording in your motions to create that precedent that your DCAs can analyze in the future. So I've given you some, I've offered you some wording if you would like to use it in the first 4 of the bullets here. Let's just ignore 6727. Thank you very much.
Thank you. And we'll also note for the record that the respondent was not here for rebuttal. Okay, members, now's the time to take action or to have some debate on the discussion on the merits.
I just want to say that when I was reading through the packet, one of the first things I noticed was how difficult it was to parse the text information. And also one of the things I specifically noticed was the lack of the to and from in those text messages, which I found really surprising. It seemed like a definite and absolute like non-compliance with the ordinance when I saw that.
Yeah, one thing I'll say about Smith versus City of San Jose, that it is up to the custodian, the person who has the device or the online account, to determine what would be releasable or not. That could be disproven if there was, let's say, a thread of emails that could be shown, and there was like a missing email, that was obviously missing that the custodian would have. That would be a kind of an example of a not being unresponsive record, non-responsive record. The metadata also, I think one of the issues that the city is having with that is they have no clear instruction or software to be able to assure that public records can be copied or forwarded or be viewed, like through a shared, like in this instance, like the shared screen, be viewed to a member of the public or a requester. I'm not sure that they have any standardized or uniform process in order to be able to do that. So the question becomes is, are they taking a very long time? And is that a question that for us is that appropriate? Should the city already have something in place? Smith versus San Jose is now, what, 3 years old, going on 4 years old? You're on mute, Chris. Oh, okay. Looks like you were trying to say something. Okay, is there a motion? You've been provided on page 19 some suggestions from the petitioner.
Well, I was going to say, I think even if the respondent was here, this looks pretty black and white to me. Thank you for the petitioner for providing this detail. I'd like to enter exactly those 4 points as my motion and get it in the record. And, this will go a long way towards us fleshing out our motions, for future precedents, I think. So I'll read it into the record. My motion for violations of 6721B, 21K, 6726, and Cheryl, please, include the detail that you see here. I'm not going to read out the whole thing.
Well, I think it needs to be read out because you have people on the phone that may not have the document in front of them.
Okay.
It's not that long. Go ahead and read it, please.
So the motion is SFPD violations of 6721B for failing to provide copies of electronic records by printing and scanning them instead. 6721K by failing to search for all personally held public records within the scope of City of San Jose versus Superior Court, brackets 2017. 6726 on 2 counts by withholding partially text message records, namely the to and from of each message, and also by withholding all email metadata, namely email headers, and also 6726 by failing to key each redaction with a footnote or other clear reference to justification.
It was 6727.
No, that's it.
No.
Partially withhold by text records by withholding email metadata and you said something.
Namely email headers.
Namely email headers, and then 6726 again by failing to key each redaction with a footnote or other clear reference to a justification. Period.
Okay, is there a second?
I'll second.
Okay, moved by Member Highland, seconded by Member LaHood. Okay, discussion? No, now public comment. Okay, seeing no public comment, are we ready for a vote? Okay, please call the roll.
Member Highland?
Aye.
Member Highland, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Hinsey? Tiana?
She's on mute. Hold on.
My apologies. Aye.
Okay. Thank you. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes. I'm going to go back into the tape, Chris, just to make sure that I've got this. I've written down the spacing on the timing. So I want to make sure that I have this absolutely accurate.
Okay. And the chair refers this to CAC. Okay. Let's take a 5-minute recess. It's 9:05. Let's say come back at 9:10. Okay. And we appreciate Mr. Malloy and Lieutenant Cox for hanging out. Thank you.
Thank you.
What else are we missing here? Edit. 2, 3, 4, 5, 6. There we go. Okay. All right. Cheryl, are you there? Yes? No? Cheryl?
While we're waiting for Cheryl, I just noticed that the invitation for this Teams meeting only goes till 10. I don't know if we get cut out at 10. But I just want to bring that up, so it's not a surprise.
I don't know. Cheryl?
We should have a motion to continue ready to go right before 10, just in case we do.
Well, is this the last? I think this is the last case, isn't it?
No, there's 2 more.
2 more. Okay. Oh.
I wish I could tell the new folk, don't worry, it's not always like this, but I can't really say that. Don't want to scare you.
I'll tell you, for our online meeting, this is the first time we've had this extended. I mean, I really try to keep them at 2 hours, because I've been sitting in front of my computer since 7:30 this morning, having my animals try to get me up and moving around as they should be. Cheryl, are you there?
Just don't tell me it gets any worse than this.
No. Victor, are you still there? Waiting for a clerk here. Cheryl or Victor? I can't hear you, Cheryl. Let's see. Let me open the chat. Looks like something's there.
I'm a member of the public, but are you able to hear anyone, or are you not able to hear anybody?
No, we're just waiting to hear Cheryl
I'm
or
here.
Victor.
Can anybody hear me?
Okay. Yes, we can hear you now. Thank you.
Yeah, for some reason my system died, and
okay.
So.
All right, we got you. Okay, so we're ready to go back on the record. I call the meeting back to order at 9:15 on the money. Let's call the next item.
Hang on a second.
And we lost Lila. Oh, no, she's
I'm here. I just needed to eat something, and I don't want you to watch me chew.
Okay.
Okay, we ready? Are we all here?
Yes, we're all here. 9:15.
Where are we
Resume the
missing?
meeting.
We're missing
No,
something.
everybody's here.
Everybody's here. Okay.
Yeah.
All right.
No,
Ready?
Lila's here. She's just.
There you are,
spoken.
Lila. I see you now.
Okay.
Okay, we're ready for item 9?
Yes, please go ahead.
All right. Item 9, file number 19112, complaint filed by Anonymous against Chief William Scott and Lieutenant R. Andrew Cox and the Police Department for allegedly violating Administrative Code Section 6725, 26, 27 by failing to respond to an immediate disclosure request in a timely and or complete manner, failing to justify withholding of records, and failing to maintain a Prop G calendar. On September 22nd, the Compliance and Amendments Committee heard the matter and moved to report to the task force that the committee is not satisfied with the lack of compliance by the police department.
Okay. So compliance and amendments, Lila, do you have any report that you want to add?
Yes, give me 1 second. Yes, this was the case where we had found a violation, and the respondent had agreed to provide information, and we received a letter saying that the department had a new position and that they would not be providing Prop G calendars going forward. And that was we think that's in violation of the ordinance, and that's why we sent it back to the committee.
Okay, great. So I just want to give the, before we start, just for the new folks, what actions we're taking during this, for this one. The complaint committee heard it in December 17th, 2019. And they found that the task force has jurisdiction and the record. Oh.
Was that a dog?
It was very odd. I wonder if we got like Zoom bombed there. Oh, there we are.
Well, I was weird.
Like a Microsoft. Maybe it was a Microsoft moment. Okay. Then on September 2nd, the task force heard this item and found that the police department violated 6725 for failing to provide the records in a complete and timely manner, 6726 for withholding all future calendars instead of providing them with minimal redactions, and 6727 for incorrectly citing 67.29-5 for withholding non-Prop G calendars. Then it was referred to compliance and amendments, and so on September 22nd, there was a motion to report that the committee was not satisfied that the police department complied with the order, and referring the item back to the task force, which is what we're where we're at here. That was that last one was after it was reported by the petitioner that there was a refusal, and we received a notification thereafter from the respondent. Okay, so this is this isn't from scratch. This is after we've made a determination. It's gone to compliance and amendments, and it's been referred back based upon the refusal to receive them. So I think at this time we want to hear from the respondent if there's any further update about this, or whether they're continuing to on their stance. So I believe Lieutenant Cox, you're here.
Yeah, I'm still here.
Okay, great. Thank you for hanging in there with us tonight. I know it's
problem.
late. Okay, appreciate it. So let's, why don't you give us a brief response to where we're at now? Go ahead.
Oh, sure.
You see time for 3 minutes? Hang on, just Mr. Cox. This is just a description?
Yeah, let me just let it, for now, let it go. We're just, trying to get through this. We're not part of a regular
I promise
process.
I'll be brief.
Yeah, go ahead.
I'll be brief for everybody. So I will say that nothing has changed. SFPD still declines to release Chief Scott's future, future calendars under the exemptions that we have already stated. And just for the record, it's going to be under CalGov's Section 6254F, CalGov 6254K, California Evidence Code 1040, and the Times Mirror Company versus Superior Court. And that's actually submitted. No further brevity.
Thank you. Okay. Okay, folks. That's where we're at. Is there Lila, is there any further recommendation from CAC on any action or recommendations for action?
I mean, our recommendation was to refer it back because we were not satisfied that they complying with you.
Okay.
May I be allowed to respond to those citations or no?
If there's no objection to members, you'll allow them some time to speak. Okay, go ahead. Anonymous.
Thank you very much. So there's a full description for each citation on page 24 of part 1 of item 9 of this agenda. You'll see on page 25 the written refusal from Lieutenant Cox, SFPD, and I'm going to disprove each of those citations. Please stop me if you don't want me to talk. At the bottom of that page, at the bottom of page 25, is an example of what Scott's calendar records look like, because we know we've got these in other cases. And the question to you is a single word on this page not exempt. Is any of this not a quote, security procedures of the SFPD? Is it official information privilege? And is it a violation of law if they were to disclose it? Those are the citations they have told you. So would you agree that the fact that someone had a policy group meeting on Microsoft Teams, somebody is echoing, could not possibly, those words, giving me those words, couldn't endanger the physical safety of Chief Scott, which is what their essential argument is. If you look at the next page, it's actually much more detailed. This is a calendar meeting entry that has a lot of paragraphs of information. And it's not exempt as threatening the physical security of Chief Scott for me to know this paragraph here about heat triggers and extreme heat events and who else was participating in a virtual meeting. Especially with COVID, with virtual meetings, we don't even get to know what the location of Chief Scott is, so there's no danger to Chief Scott. If you are so inclined, I have shown you 5 different questions you could ask to see whether they have truly complied with 6726 which requires them to go to each and every record and look at any part of it being exempt. And if you agree with me that they have not complied, then I would ask that if you go back to page 24, I have written some draft motions, if you're so inclined, that you find Lieutenant Cox, Chief Scott, and the SFPD willfully fail to discharge their duties under SF Administrative Code 67.26 by withholding in entirety Chief Scott's future calendars instead of providing minimal redactions. Because Lieutenant Cox is a, quote, managerial city employee under section 67.34, you should find that he engaged in official misconduct by not complying with SOTF Order 19112. Because Chief Scott is a department head, he's treated differently. You would have to refer him to the Ethics Commission under SF Administrative Code 67.34 for willfully failing to comply. I would, however, ask you, don't just do the personnel actions that you can. You, as you said, you have the order, the ability to compel, and you have some various options there. Please do state on the record that you're ordering them to provide the future calendars with minimal redactions, and then refer the fact that I'm not getting my records to the district attorney and/or attorney general as allowed to you under law. Thank you very much.
Okay, members. Any questions, discussion, or an action? This is not something new for the task force in general. We have found future calendars to be publicly disclosable, and they can be fully redacted as needed and as applied. If you think there is a violation.
I think it's fairly clear that there is a violation and non-compliance with a previously issued order.
Okay. Is there some action that we should take?
What is that noise?
No idea. Cheryl, if you click on the participants, you can see which ones are unmuted. It looks like it's Victor.
Victor?
Yeah, it looks like it's active. You can mute him.
Oh, yeah.
Victor?
You can mute my computer. I'm participating via phone right now.
Oh,
Looks like he's on a scooter or motorcycle.
Is there an open window somewhere?
I don't know, but can you, Cheryl, can you click on the little people icon at the bottom of the screen here? And that'll open up the participants, and then hover over his name. You'll see 3 dots. Click on the dots, and you should be able to mute him.
That one's not me. I'm not near any motorcycle.
Me neither. My windows are closed. Yeah. It sounds like street traffic.
Not anonymous.
Yeah, but it is definitely coming from Victor's thing. Can you try to mute him, please, Cheryl? All right. Anyway, let's continue. Okay, so is there some action, some emotion?
Well, seeing as the department has said that they don't intend to provide these in the future, I mean, it seems that there's a willful violation, and I think we should refer it to ethics as the first step.
Is there a motion? I hear your suggestion.
And say, I motion. I'd like to motion that we find a willful violation and refer this to ethics.
Okay.
I'll second that.
So it's moved by Member LaHood, second by Member Wong. You can't just refer but you can't just refer this, whatever, you have to name what this is.
Okay, give me 1 second.
Because 6734 pertains to people, not things.
For willfully failing to comply with the Sunshine Ordinance Task Force order.
But who?
Hang on.
It's either an elected official, a department head, or other managerial city employee that are able to discharge the duties imposed by the Sunshine Ordinance.
I mean, we've been interacting with Lieutenant Cox. He's the one who has been delivering this information, but clearly this is coming from Chief Scott as the department head, unless I'm not understanding things correctly. Should we name them both? I'd like to know how others feel about this.
Okay, so we're holding the motion open. Folks, the question is who this is directed to.
Typically, in these cases, I think we would name a department head, and I think technically, if we refer to ethics, I think we kind of have to, right? Because their finding would be against, ultimately, I think, the department head, right?
I think that's right.
Yeah, I agree with Member Hinsey, too.
Okay, so please restate the motion.
Motion of Chief William Scott willfully failing to comply with the Sunshine Ordinance, order of determination, and to refer to ethics.
Maker
That sound
of the
right?
motion?
Yes.
For LaHood?
Yes, for under 6734 for willfully failing to comply with our order.
Well, it's actually willfully failing to comply with the Sunshine Ordinance, the CPRA, and or the Brown Act.
All right.
So it's like
to...
it's the you just got to go back to the original motion.
Isn't that the order of determination? That would be at the beginning of the document.
That's right. It's the order. It's the failing to comply with the order of determination. So just refer to that.
Order of Determination, CPRA, and the Brown Act, and refer to ethics.
No, it's order. It's failing to comply with the Order of Determination. Yes. As per the Sunshine Ordinance, CPRA, right.
Refer the matter to ethics. Second, Jennifer Wong. So do we want to take a vote on that? Are we ready for the, or we want public comment?
We have to do, yeah, public comment on the motion. Hearing no public comment. Are we ready for a vote? Any more discussion? No. Saying no, it's ready. Okay, so please call the roll.
Member LaHood.
Aye.
Member LaHood, aye. Member Wong.
Aye.
Member Wong, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Yankee.
Aye.
Member Yankee, aye. Member Hinsey. Fiona.
Hold on.
Fiona.
Want to skip to me?
My computer wouldn't unmute. Aye.
All right. Okay, Member Hinsey. Member Highland.
Aye.
Member Highland, aye. Chair Wolf.
Aye.
Chair Wolf, aye. The motion passes. All right, we are at item number 10 now.
Yes, let's do it. And thank you, parties.
Thank you.
All right. Item number 10, file number 19138, complaint filed by Stephen Malloy against the University of California Regents of the University of California for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. This matter was heard before the Compliance and Amendments Committee back on February 25th of this year and determined there is jurisdiction, records are public, and referred the matter to the SOTF, and also moved that the University of California is a contractor with the city and that based on the contract presented by the petitioner and applicable laws that apply to it.
Okay. Anything else from, I think it was compliance and amendments.
Yeah, the other thing that we would note is that the University of California was not present for the hearing. And I don't know, are they present? Are they here today?
They did submit a letter, which I've included in the packet.
Was that letter delivered on time?
Yes, it was. It was timely.
Is it indexed on the first page?
It should be immediately following the cover page for respondents' records.
I think it's somewhere around page 45 or so, 47, somewhere in there.
It'd be nice to index these things, Carol, if at all possible.
No, I know, but time is limited.
Here, I'll tell you. She put it on page 16. So page 16 of 274 in the file is Greta Schnetzler's letter from the UC. She's the lead counsel for the university. 16 through 18. With a courtesy copy to Dennis Herrera.
So they're contesting jurisdiction.
Yes, they've done that since the beginning of the case.
Okay, are we ready? Okay, so let's start with our process here. Mr. Malloy, you have 5 minutes. Cheryl, you ready?
Yeah, I'm ready.
Okay, great.
Mr. Malloy?
Yep, right here. Can you hear me?
Yep.
Yes, we can, perfectly.
Okay, thank you
Go right
all.
ahead. Let's start at the clock.
Thank everybody. What an exercise tonight, huh?
Oh yeah.
On page, just for the committee members who may not have seen it, on page 117, which is labeled page P80, you will see clause 40 in my work contract between the City and Department of Public Health and the UC Regent, citing the Sunshine Ordinance is a law that is to be complied with. I'll also draw your attention to page 119 or page P82, which also shows you clause 53, which is that the city and the state both agree to comply with all laws under my work contract. And then I will further direct you to page 52. There's no little P designation, but on page 52, for the purposes of today's meeting, I also included the affiliation contract, which any employee of the state, like myself at UCSF, and the city also enter into so that we can work as an affiliated team, which is what I did at the Sobering Center. Of note, the Regents violated not just the Sunshine Ordinance provision, they also violated the compliance with all laws provision because they've not complied, but they also violated the affiliation agreement, which cites on page 53 a non-discrimination clause where I am to be treated equally and provided all of my benefits and privileges, even in termination. And then if you go to page 54, what's key about that is the City Human Rights Commission is given authority to represent me in situations like this, and the regents and the city attorney colluded, and just like they obstructed the records, they obstructed City Human Rights Director Cheryl Davis from investigating my complaint. That is illegal under the affiliation contract. On page 58, you will see where Dennis Herrera, signed for by Jonathan Rolnick, and on page 60, the UC Regents, signed for by Norman Hamill, who is the managing counsel for the Regents, again worked together illegally to not provide my records. Both entities are knowledgeable of the contract. Both entities have chosen not to adhere to the contract, which is what brings us here today. So we've kind of revisited this issue before. I don't kind of need to go over it again. Jurisdiction is established, it's well known. What I did want to speak to in the remaining, let me take a look at my little thing here. couple minutes that I have is simply this. What we've been talking about today that I've heard you all debating about, for me, is really the essence of the Sunshine Ordinance, which is that the city of San Francisco and its citizens empowered you to protect us. And that when these opportunities come up where city agencies, it doesn't matter whether they're the DA or the DPH group, breach the standards of enhancement, as Chair Wolf said, the Sunshine Ordinance is an enhanced ordinance of the CPRA and of the Ralph Brown Act. And every agency in the city signed on, trained on, and is knowledgeable of it. And so when I said stay in your lane, I say that to you because that's what the federal investigator from the Department of Labor, who is overseeing my case because I'm a protected veteran, taught me. He said, Mr. Malloy, we have to stay in our lane in each jurisdiction, and we don't conflate the two. And so all of us, I think, today have given you this energy where we want you to stay in that lane of enforcing, not enforcing, that's not your job. The three judges who are working on my case, the federal judge, the California Superior Court judge, and the PERB judge that are working on my case, hopefully will give me injunctive release and force the release of the records. I don't need you to do that. But what each judge has done is taken your reports of willful noncompliance, and it demonstrated to them that the administrative ripening of my case has taken place with you, that you asked the right questions, and that the respondent did not respond. Each and every one of us is doing that with you today. And any complainant, I feel, is doing that with you. And so I urge you, as all of us have been kind of pushing on, is to stick to that standard of did they do, thank you, did they do what they were supposed to? And they didn't. Thank you.
Thank you. Are any persons or witnesses providing facts or evidence on behalf of the petitioner, complainant? Hearing none. Respondent, are you present? Hearing no response from the respondent is absent. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Okay, hearing none, members, the case is with us. I just want to note that the Compliance and Amendments Committee. Hello? Compliance and Amendments Committee of August 25th, the records clerk from DPH was present, and I did ask a series of questions. You can find it on PDF page 62. There's no stamp number on the page. At the top, it starts for October 2nd, 2020 hearing complaint. There's some excerpts there that the petitioner has provided. And what was addressed was the revelation that from the clerk, the records clerk, that they were given a directive by the city attorney not to release any records. We have a provision in the ordinance that prohibits that by the city attorney. They would have to provide like a legal opinion in why the records shouldn't be released. And then it would be up to the custodian to make a decision as to whether to follow that opinion and guidance or not. But here she admitted, and it's on the record, that she was given a directive from the city attorney to stop releasing the records. So there's that issue. The UCSF claims, if you look in their letter, they quote me quite prominently, and this was a response that I gave to Mr. Malloy, because on the before we received any of the other documents, including the contract, it was just to notify him that there might be a possibility the task force might not find this in jurisdiction because it's UC. And I think the implication there was that that unless there was a direct contract with the city, then that would probably be the case. Mr. Beloy did due diligence in providing us with the contract, and as you saw in his presentation. Again, this is not the first time task force has had to deal with certain records that belong to the person themselves. And I don't recall, let me check my other notes here. What page was that on? Oops. The response from the response from UCSF does not cite. It only cites that they only cite that they're not connected to this at all. And I don't think it doesn't look like they even admit that there was a contract with the city.
Can I ask a question?
Yeah, go ahead, Member Wong.
So, yeah, this is Member Wong. I wanted to know, I was under the understanding that the Compliance and Amendments Committee found jurisdiction, so that means that we find that the UC regions are under the jurisdiction of the task force then for us to make a ruling. Is that correct?
Correct. And that the yes, that's what we found. So now it's up to us to determine whether all or some or part of the documents are disclosable or none. Yeah, the committee found that the task force's jurisdictions that the requested records are public. So we just need to determine whether they have fulfilled their duty, and if they're withholding records, their reason is appropriate.
I assume that doesn't foreclose a contrary vote on that issue in terms of jurisdiction. Is that correct? Does anyone think that that issue's decided now at the committee level?
Yeah, generally the way we work is that the task force gives authority to the complaint committee or the committee that is hearing the complaint to determine if it's first of all, we have to do the 45-day rule to determine if the documents are public and disclosable. The second is whether it's just for us, whether it's in our jurisdiction or not. You can overturn it. The task force can overturn that jurisdiction question because it's a recommendation from the committee, more or less, but is given the authority to make that determination. If we find here that in fact that was incorrect, then we make the correction. That's all.
Okay, thank you.
I don't think we were intending to say that they are. We were intending to say that they are subject to some aspects of the Sunshine Ordinance, not that UC in its entirety is subject to the Sunshine Ordinance.
Yeah, it's only pertaining to the contract because they
exactly.
They are a official contractor of the city. So they and as Mr. Malloy had pointed out in the actual contract that their sunshine is applicable. On page on the PDF page 58 out of 274, there's a letter from dated September 24th, 2019 from the city attorney, basically just saying that UC, it's their responsibility to hold the city harmless in whatever liabilities that they create. It doesn't necessarily, it basically affirms that they have a contractual agreement and they have a contractual, a responsibility for contractual indemnity. So that to me is first off an admission by the city that there is a contract that exists between UC and the city to provide the sobering center. Okay, then if you go to the next letter, on page 60, that's from UCSF Office of General Counsel. Is only a response to really only a response to the city attorney's claim around indemnification. It says, given this background of Mr. Malloy's activity and the unclear nature of Mr. Malloy's current claim with the city, UC will agree to accept the city's tender of this claim and to defend and indemnify the city, subject to reservation, because it's not entirely clear to us what Mr. Malloy's claim is all about. So basically, UC is taking responsibility for Mr. Malloy's claims, and they basically then say, we appreciate the city's offer to fully cooperate in UC's defense of this claim. I didn't necessarily see that in their letter. Here, you may be assured that the city's full cooperation after the regents accept this tender and agrees to defend and indemnify and hold the city harmless. Okay, so the question is there now a city attorney, the city attorney here to defend them with regards to Mr. Malloy's claims? Okay, so that's essentially their MOU, their memorandum of understanding, basically.
I don't quite see the linkage between indemnification and defense and jurisdiction over sunshine claims. I just don't see any correlation there. That's part of my thought.
Oh, okay. Go ahead. I'm sorry.
The only thing that I can imagine myself at this point, I'm always open-minded, that UC would ever be involved in this kind of situation is possibly under the Sunshine Ordinance, the public could see documents which were the creation documents where the city created the contract with UC. I mean, there's no question here that there's a contract, there's a huge contractual relationship with the University of California and the city. So, you know, we could get public access to those contractual documents, but we get them from the city. We wouldn't get them from the UC. So that's kind of my impression here in terms of the legal issues.
The contracts are in your package.
Yeah, I looked at them.
Oh, you did? Okay.
Yeah. If they sign a contract, they sign a contract. But I didn't see anything in the contract that would cause the UC to be a city agency or where it submits itself to the jurisdiction of the Sunshine Task Force. It's just not there. It would be strange if it was.
It is. It's in all contracts with the city if they're being contracted to provide services. And Mr. Malloy pointed out, I think it was section 40 of the contract. Yes, section 40 of the contract. It's on page P80, which is printed at the bottom of the page, or PDF page 117 out of 274. It states Sunshine Ordinance. In accordance with the San Francisco Administrative Code 6724E, contracts, contractors' bids, responses to solicitations, and all other records of communications between the city and persons or firms seeking contracts shall be open to inspection immediately after a contract has been awarded. Nothing in this provision requires the disclosure of a private person or organization's net worth or other proprietary financial data submitted for qualification or a contract or other benefit until and unless that person's organization is awarded the contract. Information provided, which is covered by this paragraph, will be made available to the public. So this is just with regards to the compliance with the ordinance, letting them know that they're what's applicable there. And then in the next section, which was 40, no, was it 52? Oh, number 53 on page 82 says compliance with laws. The party shall comply with all applicable laws in the performance of this agreement. Now, there should be, can I do that? Oh, great. Oops.
Sorry, I lost Microsoft, but I'm back. Okay. It's like the fourth time today. Bruce, are you still speaking, or are we?
No.
Okay. Well, the clause that you're referring to is certainly it would in terms of bids, contractors' bids, anything having to do with the establishment of the contract. Sure, but you know, does that mean that the University of California subjects itself to San Francisco jurisdiction on all of their records anywhere within the University of California system? It did, you know, like records up at UCSF. No, it has to do with the contractors, sure, the contracting parties, but it seems to me it's pretty clear that that would not include the kind of things that we're talking about here.
May I explain something for him, Mr. Wolf?
Sure, go ahead, Mr. Malloy.
You can speak.
Yes, thank you, sir. What was your name, member? I'm sorry, I didn't catch it.
Yeah, Dean Schmidt.
Yes, member Schmidt. The relationship that the city has with UCSF is such that I work at a DPH site every day. I was embedded with your city workers. So I communicated and I work exclusively with every agency in the city to help the homeless population. That's why the affiliation agreement holds, and that's why this contract, which is unique to the Department of Public Health and UCSF, holds, is because we are working as independent contractors with city employees, and so the rights that you're talking about extend to us, even within a DPH site. That's why the contract is written this way, and that clause is not struck. Furthermore, if you go to page 205, it cites that both the city and the state agree to federal oversight of all clauses in the contract. The reason that that's important is I'm a federally disabled and protected veteran. The reason the indemnification is a key issue is that the city participated in my wrongful termination, and they are barred from doing that in the contracts. And once they did that, they violated the tort contract clause as well. That's why Norman Hamill, he's not the UCSF attorney, neither is Greta Schnetzler. They are President Napolitano, before the change of command, attorneys. My case sits all the way at the Regents because the mayor and the city attorney walked into your clerk's office at DPH and told her, don't give him those records. She already had released to me 9 emails. In those 9 emails, your city officials, cited very clearly in my report for you on page 62, communicated and worked illegally against the contract to terminate me. That's why at the highest level, both at mayor and city attorney, and at UC Regents, Norman Hamill, Greta Schnetzler, President Napolitano, because of the federal component, which was also violated. That's why I have a case in federal court now, passed through the magistrate system. That's why I have a case in California Superior Court. And this contract, as it clearly is stated on page 52 and 54, Cheryl Davis of the Human Rights Commission holds contract authority in San Francisco. She is ordered under the ordinance to actually investigate. When the city attorney shut down your clerk, as I showed you in the documents, Cheryl Davis responded to me on page 49, Mr. Malloy, the city attorney has shut me down. He's not allowing me to exercise my jurisdiction, which is to do your complaint. So that's why this is so sensitive. Not for me, but for the city, because that's negligence, as you know, sir, willful negligence. And that's why every other department has gone silent, does not communicate, because this is in court. And there is a federal judge and a state judge and the PERB judge under the collective bargaining agreement who are now going to probably give me that injunctive relief when we get to those case management conference points.
Okay, Mr. Malloy, let me ask you a question. You're stating that you already have active cases with regards to this contract in court?
Now I do. because now that maturity process with the pandemic has graduated, and the city knows this, the city attorney knows this, the DA knows this, the mayor knows this.
So I have a question. Are you going to be asking the same questions about this information in court?
I don't know what the judges will need. That's up to the judge. Again, that injunctive process will be up to the judge if they decide that they do or don't want to do anything. I have no idea.
But your complaint isn't your complaint about the documents?
Yes, absolutely. Under the Sunshine Ordinance, that as a worker, I am entitled to. And the city attorney is not releasing those emails. He released 9 of them by mistake. That's why she said, and you have that on the recording, trouble. And then she corrected herself. And you said, well, who told you to do that? And she said, the city attorney.
Yeah,
and he's been coaching her not to do, right?
Yes, but Mr. Malloy, our process is not to be in conflict with, an existing court case.
Your process is not in conflict with that. This was a request that was made to the Regents before the pandemic. This is a request that stands. That relationship goes back to when I was working and first asked for these records in 2018. We're now 2 years forward in the process because they're not complying with the ordinance that is cited specifically in the contract and that grants that unique right.
I
if you notice
that.
In the contract, they block out anything that they don't agree with. They agree to that.
Yes, Mr. Malloy, but this is really more of a process question for me. No matter when somebody invokes the judicial process, it is generally the practice of the task force not to interfere with that, because that is the ordinance allows for sunshine issues to be taken up in court without coming to the task force. And so if that's already happening, we're not likely to want to interfere with that.
Well, you're not interfering with that. The whistleblower task force has been investigating this. The Ethics Commission was already investigating this before you all started. As you know, Mr. Wolf, the DA was involved and continues to be involved in this. There are multiple agencies in their lanes associated with their unique jurisdictions who are addressing the case. That has nothing to do with you. The DA is doing his thing. The city attorney is doing his thing. The whistleblower compliance people are doing their thing. The Ethics Commission was on this before you even gave them the other ones because I already knew that information. You're just focused on, are they supposed to give those records? Yes. Are they refusing to? Yes. That is wrong.
Yeah, but Mr. Malloy, you're going to be asked, Mr. Malloy, these questions, if you're going to, or if you already have a case filed, these questions are going to come up for you in court. So I think it would be, no matter what we do, those questions are going to be re-adjudicated in court. And I don't know why we would interfere with that.
You're not interfering with that, sir. You're focused on that relationship that I had as a city contractor. And that relationship is guaranteed to me under the city's relationship, clearly stated. And it's a simple question, both for the city and for the Regents, both served in their capacities. That is nothing to do with anybody else. That's the question. And the answer to that is I am owed that under the law. And so I'm asking for that, and you're the administrative piece that handles that. Nobody else handles that.
Yes, the court of law, Mr. Malloy, a court of law can handle that. Or the Ethics Commission.
A court of law can handle the injunctive process if we come up, just like you discussed before, in attorney-client privilege. Those are all hypothetical.
No.
This is the issue at hand. You can't talk about what the whistleblower compliance group is doing right now. That's not in your arena.
I didn't say that, Mr.
It
Malloy.
doesn't matter.
I didn't say, Mr. Malloy, you're going to have to let me speak, not speak over me. I'll allow you to speak at length here, but I will tell you, I'm not concerned about the DA or the city attorney or the whistleblower group. That's not what I'm referring to. You said that you have a case going up in court in the judicial system. Is that correct?
Let me refer you. Go to page 65. Page 65 of this attachment. Are you there?
I am there.
Okay.
So yes.
Page 65 of this attachment is the collective bargaining, which is a court. It's the state process for the court. That decision of granting me access and demonstrating a prima facie case was because of the 9 emails that Veronica Vane released by mistake. Once the court saw that information going all the way back, you see that's dated in January of this year, they immediately said that's a violation of his contract. And where are those emails? So your work, the administrative work, which you're focused on, is the sole reason I'm here. And any complainant is, hey, you know, there's other people, sure, that's going to help them or not help them. But the point is that it's clear, for the same reasons the Compliance and Amendments Committee, we already went through that. It's clear. It's the same question for each of us. Are they supposed to? Yes or no. Are they willfully doing it? Yes, they are.
Okay.
Are they allowed to do that in secret? Nope.
Okay, so
are they supposed to release the people's records? Yet?
Mr. Malloy, so my question is, do you currently have a case filed in court?
You're looking at it right on page 65.
But is that an order? Is that a court order?
Yeah.
Okay.
The Public Employment Relations Board
is it
the
still
state entity that handles all collective bargaining.
Is it still active?
Yes, it's been active. That's why you have it in your document. You've had it all along. I've provided you everything that I've had as we have moved forward in the process. That's what I said. The Ethics Commission talked to me two years ago about this very question.
I guess what I don't understand is if a court provided an order for the production of records and the respondent is refusing to do that, your complaint should be back with the court that ordered it. That is far more power and authority than we could ever issue.
But that is something that all complainants have access to, Mr. Wolf, and that doesn't dismiss your responsibility as a task force to address for any citizen their specific rights, right? And you're part of the administrative process that allows the court to get there. The court only got to that point, and as you know, this has been a 2-year process because of the violation of the indemnification, which is so critical to the record. And once that happened, that's why Dennis Herrera and Mayor London Breed said, don't give him those emails, because they already demonstrated when Veronica Vane did that, she blew the case open. Do you know why I have the contract? Hold on. Do you know why you were looking at that contract? You're looking at that contract because investigator Matthew Oglander of the Human Rights Commission gave me the contract. He gave me the contract because they clearly had discriminated against me. Once I got the contract, that got me to you. Everybody plays a part. Everybody is part of the process. But the only reason any part of the process moves forward is because the administrative component has to ripen. And that has not happened with any court yet, right? Because that process is ongoing and takes years, as you know. So I appreciate your sentiment around that, but the job that is before you, as it has existed in every jurisdiction, is the same. Did they or didn't they follow the law? No, they did not. And you're key to that for any of us as complaining. Jeff Pierce is using that information to say, whoop, he's right. He told us 2 years ago that they did that. Now we have the Sunshine Ordinance Task Force showing us that, yes, they did, in fact, willfully non-comply. That's why the Ethics Commission is involved. That's why the whistleblower, you have attorneys at the whistleblower office under the city controller's office, Mr. Wolf, balking now because you issued that finding. When you issued that finding, it verified that I'm not a crazy complainant just up here talking some smack. No, I did work for the city and I had that right.
Okay, Mr. Malloy, I'm not
multiple jurisdictions.
Mr. Malloy, I'm banging the gavel because you're going on and on now, okay? If we want to get to the end of this, we need to determine what our purpose here is, because if you already have a sunshine case with the Ethics Commission, we are not going to duplicate that. We're not going to duplicate that action. That was not revealed to us.
I don't have a sunshine case with the Ethics Commission, sir.
You just said you spoke to Jeffrey Pierce, and that's what, and he's going to use the sunshine case.
And he didn't take my case. He didn't take my case. Now he's taken the case because you have put it before him, and therefore the evidence now exists.
Because of the previous case. Because of the previous case.
Yeah, because you sent it to him. So now when I had talked to him on the phone and he was like, well, I can't cover you on that or whatever, right? Now he has it before him because you confirmed that that contract existed, that they were supposed to give me those records, and that they did not do that. And it's the same thing with the regions. It's no different. You and I are talking because we're in a contractual relationship, independent city contractor, UCSF, with you, Department of Public Health.
I just wanted
and
to
that's
point
why
out
we're going.
Okay, Mr. Malloy, I'm going to have to let our other members have a chance here. I think it was Member Schmidt had a question first, and then Member Wong.
I forgot what my question was.
Okay, Member Wong.
Just as a statement of comment, I do believe I agree with Member Schmidt in his assessment of 6724E in that the contract bids and proposals, I think, specifically refers to information related to those things. And I'm not sure if I agree that it's under our purview or our jurisdiction.
Hold on. There is provisions, and I don't know whether it's in the CPRA. Let me see if we're in the ordinance. There are provisions with regards to contracts. Lots of times it's under 12L, which is for nonprofits. It's sunshine for nonprofits. But there's a difference between, that's usually with regards to receiving grants and whatnot. But there are other contracts, like when the city contracts for like street repair, those kinds of things. Those contracts are subject to sunshine. Everything that happens within the confines of that contract. I just want to see if maybe our legal counsel had put that in here.
If you're talking about a separate statutory framework for sunshine for nonprofits, I don't think that would apply to UCSF.
Well, it's not just nonprofits. It's I'll get it for you. 12L. Yeah, it's specifically for nonprofit organizations. And you think UC that's not applicable for UC?
I don't know the final answer to that. I just don't see how that's brought in here. That just seems like it's a little bit of a separate issue than this case. I don't think that's how the complainant is seeking to bring this in, is through the nonprofits sunshine statutory scheme. He's saying there's a contract, and because there's a contract, somehow UC's got to show up at sunshine hearings whenever there's anything having to do with UC record. Well, I just can't see that.
Well, this has happened many times before the task force, where there are contractors that are required to comply with sunshine, and it's in their contracts. It's not the same language as what I see in this contract. I have to go back. Actually, it would probably be the contract.
I think this contract specifically refers to section 6724E.
I think just 6724E just describes how the contract came to be and why it is public. I mean, it's really 6724E is just its process for the most part. But there usually would be a specific clause that would be stated in the contract that the contractor is specifically that their sunshine ordinance is applicable, and it describes how.
Yeah, this is Member Yankee. Like, I know we've dealt with one fairly recently with the zoo, and it had that particular type of clause that you were speaking of, Chair Wolf, but I'm not seeing a similar thing where UCSF is agreeing to full jurisdiction of the sunshine ordinance. So I'm kind of in the same place that Member Schmidt and Member Wong are.
Legal counsel memo also reflects that.
Yeah, I can't imagine that private companies are showing up in front of the task force because of these type of contractual provisions. I mean, they might say we will open certain things up in our processes and use the standards of the sunshine ordinance, but that doesn't mean that they're saying, well, and then you can haul us in, to City Hall. I doubt if any of those kind of companies are showing up in task force proceedings.
Well, not usually, and I wouldn't say that. Well, I would say yes. We have brought in contractors many times. Most of it has been under 12L because they were nonprofits. But a contract is pretty much unlimited for any kind of contractual agreement between the city and a private entity. And that when you look at their contracts, there's a very specific section around what their compliance is under sunshine. So that is definitely there. the question is I personally, I'd have to do some additional research to find where in the ordinance it states that, or in the CPRA. I thought maybe it would come out in the legal memo, but it didn't. Now, Mr. Malloy states in the contract number 53, with regards to compliance with laws, it says the party shall comply with all applicable laws in the performance of this agreement. The question is whether Sunshine Ordinance is applicable. And lots of times well, at least in the 12L cases, we have to make those, if we want to compel records, we have to make it to the contracting agency. And the contracting agency then orders the contractor to produce. Yeah, the section that he pointed out regarding Sunshine Ordinance does not is not necessarily applicable to the release of public records. And the question is whether, just by virtue of there's a contract, whether the certain information or what information
Yeah, I think about how many companies have contracts with the city, and I think about all the different clauses that are in those contracts. They're not all agreeing to be subject to public disclosure laws.
Yeah, they are for the purpose of disclosure. Absolutely for the purposes of the contract. One example is we had a lot of gas leaks during construction here in where I live on H Street, and merchants who had to close because of shelter in place every other day had requested records from the contractor, and they had to provide it on what they were doing because their contract specified that they were specific to that job, that contract, that the information was public.
But it's not a public record. It's just that they're compelled to produce it under a certain
under Sunshine. No, it's considered a public record.
Okay.
Under Sunshine. Now, there's no complaints. Nobody brought a complaint, but I knew that was happening because it was in my neighborhood. So I'm not. I need to find that section that talks about policy boundary. It's passive meetings. Yeah, I'm not. Yeah, I can't give you an answer on that right now. So, either we continue this item until that can be found, or something else. Okay. Let's go to rebuttals, and then we'll decide what to do from there. Is the respondent here? Did they show up? No? Okay. Mr. Malloy, you have 3 minutes for rebuttals.
Go ahead, Mr. Malloy.
Yes, thank you. As I'm looking online at the 6724E, and to your point, Member Wolf, including in the contract in Section 40, all other records of communications between the department, which in my case is DPH, and persons and or firms seeking contract shall be open to inspection. You have to remember that your logic in trying to say that I don't have access to my public records, which are my communications that I did on a daily basis at work, would have to have had to apply to DPH. DPH and the fire department and every other city agency that has released the records to me has done so because of this contract. And that contract, because I'm an independent contractor with UCSF, just within DPH. They're not talking about all of UCSF system-wide, sir. We're just talking about my work with the city. Those communications, whether they were with fire or DPH or Health and Human Services or the DA or the city attorney or whoever else I was dealing with on a daily basis for the 6 months that I was in the position, are my records. And I'm allowed to have access to them, which is why DPH gave them to me initially before the release of the records demonstrated a violation of another clause in the contract, which was indemnification. So I believe my communications, as stated in my records, based upon the authorization given in the contract of the Sunshine Ordinance, are available to me as they have already been provided to me by fire, as they have already been provided to me by DPH. I am just asking for the full. Go ahead.
In that section of the Sunshine Ordinance, it only talks about what part of a contract after an RFP, a bid, becomes public. That's all it means. It just means that the contract can be publicized and the conditions of it. It doesn't. 6724E does not specifically bind the contract to the Sunshine Ordinance. That's what I was looking for. There's another section that binds it, and I might be thinking of 12L because that's where that exists, and I know that because I work with a nonprofit that has contracts with the city, and I know that Sunshine Clause exists in those contracts. The question is as you just said, that the information that you're asking for is available to you because of this contract. I really think that then that information should be gotten from probably from those city departments, as you mentioned, that these communications are with. I'm not sure that without finding that clause in the law that it's really just a contractual relationship and not applicable under Sunshine. It may be applicable under some other law, but I don't know whether that's what I'm trying to determine, whether it was in CPRA or in the Sunshine Ordinance. But in the contract, even though that information is available to you, it's contractually available to you, which I think should be challenged in court, not here.
But the record component, which has nothing to do with that, to your point, I'd have to study more because I haven't looked through the whole thing, but I'm looking at like section I under it. It says neither the city nor any office, employee, or agent thereof may assert an exemption for withholding for any document or information based on a finding or showing that the public interest in withholding the information outweighs the disclosure. So to your point, maybe there's some more research on that, but for the same reason that I'm talking about, it's under sunshine because that's the only way I can access, which is why it was included in this contract under the affiliation agreement. Remember, I've also given you the affiliation contract, and in the affiliation contract, as stated in those clauses I provided you on pages 54 and 53, in my work, employment, termination, promotion, whatever, I am granted full access and treatment equally for all benefits. And part of that is my communications, because every day I am communicating back and forth as a UCSF employee on the public health side only now with city agencies. And so those records are fluid. They are both ways. And the university has to turn over the same thing, which they have, right, of your city employee records if people request them. And so that's the relationship that they don't want to honor, that they have to honor under the contract, which is why it was put under the Sunshine Ordinance, because I'm a contractor working at your site, right? I'm not working, I'm a UCSF employee, but I'm working at your site. I'm embedded with you. So it's fluid. That's why we have all of that information between multiple city agencies. So in the affiliation, I have to be granted my employment right to ascertain my records, whether they're with the Regents or they're with you. It doesn't matter, because I was in a unique position as your contractor. And that's not about the financial piece of it, right? That is about the communication piece of it under the contract. So you're right. It's not UCSF system-wide. It's very specific to my unique work conditions.
No, I'm not stating, I'm not agreeing with that. It's UC.
Yeah, I understand what you're saying.
I'm agreeing that if it's the sobering center is now a department of the Department of Health, then that information's got to come from the Department of Health. Okay, and they need to get that information from whoever is running that sobering center. Okay, that's
to your, yeah. I just think that there's more within the Sunshine Ordinance. I haven't studied it enough, because it says even under 6724E that we're in now, it seems more expansive to me as I scan through.
Yeah, but it's more expansive.
Three I's, all documents exchanged and related to position, including draft contracts, shall be made available for public inspection and copying upon request.
It's just the contract.
I see it saying all documents, and I see it being more expansive than that, including why it was sectioned under Sunshine Ordinance. It's not just in relationship to the contract, but again in relationship to the affiliation agreement. Because in the affiliation agreement, I have to be given that access. I have
Mr.
to.
Malloy,
It 67, and you have both contracts.
6724E is specifically to RFPs and the award of a contract for an RFP. That's all it is. And what the process is for protecting the confidentiality of the RFP process, and to determine when information is available to the public. It does not. There's no requirement in E that the contractor is. That doesn't even discuss it. It's not even in context under E. That's why I was saying I need to do a little more. I would need to do, on behalf of the task force, I think, just a little more a deeper dive, because I'm, and I said I might be confusing it with 12L, because 12L does have that requirement.
To the earlier question that came up, Mr. Wolf and members, relating to other clauses in 67, for example, 67.4, there have been so many closed door meetings and passive meetings and agendas and documents on this particular case and complaint. That also applies, does it not? Separate from the due diligence you're indicating, Mr. Wolf, you need to do around contract.
Well, we can
because those are records I should have access to as well, and I'm not, to our long discussion tonight of texts and emails and metadata, I'm not being provided that either, and I again have that right to request that, both from the UC under CIPRA, and also, and they're not allowing that, and also under the contract as an independent contractor affiliated as part of my right.
Yeah, but we have no jurisdiction over UC directly for CIPRA. That we cannot do. Okay, so so I saw Member Wong and then Member Schmidt. Go ahead.
Yeah, I was just going to point out under the affiliation agreement that the administrative code that's referred to is Chapter 12B, which I don't believe is under Sunshine Ordinance Task Force jurisdiction. Is that correct?
12B?
Yes.
12B and 14B fall underneath the Human Rights Commission, but there may be components of that you would have to ask Cheryl Davis that do apply. I don't know. But it falls underneath the Human Rights Commission.
Yeah.
But you'd have to ask them.
Some of this deals with dives into areas that Sunshine doesn't have jurisdiction in with regards to personnel files. Go ahead, Member Schmidt.
For benefit.
Yeah, I was just going to say I think I'm pretty much ready on this. I don't think I need anything more for my vote.
Okay.
Damn.
All right.
Sorry, losing the picture. Oh, you can still hear me?
Yeah, we can see you too.
Sorry, I stopped there because I love.
Now we can't hear you.
Now you can't. I guess it happens for him before it does us. Okay, so okay, members, what should we do here?
I would move to not find jurisdiction in this case.
Okay, so it's a motion. Is there a second?
I'll second that.
Moved by Member Yankee, second by Member Wong. Let's see if Dean comes back.
I see his picture.
There he is. He's back.
There he is. Okay.
There he is. Okay.
There he is. So Dean, while you were in purgatory there, Member Yankee moved to find no jurisdiction, and it was seconded by Member Wong. So that's where we're at now. We're in discussion of that motion on the floor. You got to unmute yourself.
Thank you for keep bringing me up to speed.
Okay. All right. So is there any discussion or debate on the motion on the floor? Okay. Seeing none, public comment.
Yes, please.
Is this anonymous? Hang on. Is this anonymous?
It's one of the anonymouses, yes.
All right. Go ahead, sir.
So I would urge you to read section 67.29-7C and section 67.32. They may have what Chair Wolf was referring to. And unfortunately, while there is this section 40 in the contract, one, on the side of the complainant, it does say all other records of communications between city and persons or firms seeking contracts. It doesn't say all other communications about those contracts. It's all records of communication. Now, maybe that contract is poorly written, but it does not limit those communications only to a certain topic. It's also written poorly in that it says shall be open. It doesn't say who has to disclose it, which party has to disclose it. Sadly, the part that DPH was supposed to put in this contract is section 41, and that is public access to meetings and records, which says is deleted in consideration of contractor's public entity status. That is what DPH was supposed to put in this contract to require UCSF to be subject to the Sunshine Ordinance in a certain limited way that Chair Wolf has been discussing. They did not do so. Unfortunately, that's a violation by the Department of Public Health and not really of UCSF, at least the way I would see it. But the other side of this is, how can a complainant enforce this contract unless they are a third-party beneficiary of this contract? And I don't see anything like that. In the past, I think you've held that they have to file a complaint against the city department that didn't require all the appropriate things of the other non-city agency party. And of course, this is not legal advice to any party. Thank you very much.
Thank you. Any other public comment? Okay, seeing none. Okay, members. Any other discussion or comment? Okay, so ready for a vote? All right. Please call roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
No.
You got 6 votes for finding no jurisdiction.
Okay, motion passes.
Yep.
Okay. Thank you. Let's move on with our agenda.
Item number 11, continued discussion regarding changes to administrative process and legal memoranda. This was carried over at the request of Chris Highland at the September 2nd hearing.
Okay. You're on mute, Chris.
Not sure I remember that, or maybe I put the motion to continue, but that's about all.
Okay, so I'll tell you what I've been doing around this. I have a meeting tomorrow with the clerk, and I've contacted a couple of supervisors to discuss the matter. Their aides, I contacted their aides to discuss the matter. At the same time, I decided to go through that process first, see if maybe something could be done more administratively than having to go before the Board of Supervisors at a meeting and discuss it, because they'll probably run back to like the Government Oversight Committee to determine what to do about this. But we want to see if we could try to figure out what to do. One of the thrusts here is to determine if there was a cost savings to the city attorney's office budget if this function is not going to happen anymore, as it had been for 20 years. And considering that we are, I don't know, almost 100 dozens, if not almost 100 cases in backlog. You could just imagine how much work it would be to provide legal memos for each one of those, whether they're all duplicative or not, or what have you, that the memos would still have been done. We don't have enough staff to be able to do it. Our current administrator is already a pretty heavy workload. And so I was looking to see what the cost savings might be, that money to be spent on hiring an additional staffer to be able to do those memos. Either like a paralegal would be fine, actually to at least present them in a legal manner so that we have something to go on. Okay, anything else on this? No? Okay, any public comment on this? Seeing none. Okay, let's move to the next item.
We were going to continue the discussion of
yes,
the Andaries matter. So we're not doing item 12 yet. We're going to continue the Andaries discussion.
Oh, right.
Am I correct in that?
No,
No, I substituted a motion for that. We
already voted on that.
Yeah.
we voted on
we
that.
decided that.
All right.
I thought we wanted to continue to the end of the meeting.
Yeah.
No, but
That
then
was-
we had a new motion.
We never voted on that motion, and the new motion superseded. So we've already taken action on that item.
Yeah.
What was our
We voted on a violation that we all felt comfortable with.
The one regarding the lack of annotation for documents that were provided.
That was about 4 hours ago. Yeah.
Yeah.
Well, it is 11 p.m. Okay. Item number 12. We ready for that?
Yes.
Bruce? Okay. Inquiry regarding quorum under Charter Section 4.104. This was an email that was submitted to me by Winship Hillier. He had several questions about that particular charter section, and Chair Wolf suggested that we make that an agenda item and open for discussion.
Can I make a motion to continue that item? If that's
okay. So
No.
there's a motion to continue.
Who wants the second?
when did we get the email from the person?
I'm sorry, what did you say, Fiona?
When did the original email come in?
What's the date of the email?
Oh, it was dated. It should be, it's in the, it was included in item 12. It was included in the packet.
Is that individual at the meeting right now?
He was here at the beginning of the hearing. I don't know that he's here right now. Mr. Hill.
Can I please explain this? I put the item on the agenda not to adjudicate the concern of the complaint. The concern of the complaint that's included in the agenda is just specifically as an example of a question around quorums that happens all the time because people don't know, and actually the people on those bodies don't know whether they are to comply with the charter or with the or not comply with the charter because it's not applicable to them. Okay.
The original letter was submitted a week ago, so I still make a motion to continue this. I think we can certainly let's refresh mind.
I'll second that. Then if it was sent a week ago, I'll second that.
Okay, so it's moved by Member Highland, second by Member Hinsey to continue the item till when?
Next meeting.
Till
November.
Meeting.
Okay.
Shall we take
All
a
right.
vote?
Any public comment on the motion to continue?
Oh, hi. I'd like to make public comment.
Sure. Hey,
Hang on.
Cheryl.
Thanks.
Yep, hang on. Go ahead, sir.
Yes, Chair Wolf, thank you, and thank you, Madam Clerk. My name is Winship Hillier. I'm the one who submitted the email, and I'm a little disappointed that I've stayed up this late, and it's not going to be heard. That's all I wanted to say. Back to you, Chairman Wolf.
Thank you. Any other public comment? Okay, seeing none, let's call the roll. It's substantive.
Member Highland?
Aye.
Motion to continue. Member Highland? Member Hinsey?
Aye.
Member Hinsey, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Can I abstain?
Can't abstain. No, there's no
right.
abstentions. So yes or no. You
no.
can pass. Okay.
Or pass?
Just so you know, you can pass, and then we'll come back. We'll come back to you
Oh,
in case
okay.
more
No.
time to think about it.
You're voting no?
Yes.
Member
Yes,
Yankee?
I'm voting no.
Aye.
Member Yankee, aye. Member LaHood? Member LaHood? Lila?
Thinking, I know.
Yeah, please don't compel them to. They can take time.
No, I just didn't think, I thought maybe I was on remote.
No, I'm here.
Mute
I'm
or
here.
something. Okay.
No.
Member LaHood, no. Chair Wolf?
No.
Chair Wolf, no. 4 yeses and 3 nos.
The
Motion
fails. Okay. So the reason why I brought this up was it's really more of a general. I'm not asking for any action on this tonight unless you feel compelled to do it. It's really just to get it in front of the task force that there has to be some kind of list or very definitive public a statement about a description for different kinds of bodies. Some bodies, the way they are created and the way they're appointed, are not necessarily applicable for this section of the charter. And then there are others that don't know that the way that they're created, that they are required to operate under this section of the charter, and they have been operating in violation. So in order to kind of correct this, I think it's incumbent upon the task force to, this is a very macro, kind of shallow. You don't have to go that deep because all you have to do is just determine whether how they've been appointed or how they've been elected onto those boards or commissions, and whether those boards or commissions or committees of those boards and commissions are applicable to either the provisions in the charter under the executive branch or by the Sunshine Ordinance. It will help our job so much easier because if we can really identify, it'd be like the first question you would ask when it comes to a complaint about a board of commission or a subcommittee or an advisory group, whatever it is, a meeting body, to determine its status. So I just included this one from Mr. Hillier, and he's here, I guess, if you want to ask him any questions with regards to this example, because this was just submitted. It's not necessarily regarding specifically to his complaints. I wanted to bring it up before us because I think it's pertinent. So it's more of a presentation. I know it's late and we're all tired, but I wanted to get this in front of you and that we should take it on as a project for all kinds of boards and committees. I know we've had some issues with the museums and how they have contracts with folks that are providing direct services with them, which is similar somewhat to kind of the UC situation but these other organizations were actual nonprofits that could be applicable. So anyway, it's a longer conversation. I wanted to start the conversation and get it going. We can, if anything, we can assign it to like EOT committee, but it's something we have to think about and should make clear for everyone. Okay, that's all I have for this. Yes,
just very quickly, maybe for people to review in light of future discussions, is you might want to review Attorney General Opinion 10-901. It talks about a quorum for a state board that might have some, relevant legal citations to this issue.
Okay. Maybe if you have the link for that, send it to Cheryl, and then she could send it around, sure. And we'll make it part of this record. But really, the sections of the ordinance you want to read are at the very, very beginning of the ordinance. It's section 67.3, which starts with the definitions of what a policy body is, what a passive meeting body is, and then what meetings are, what kind of meeting, what's the definition of meetings. And really, that's how this is applicable. And then you compare that with section 4.104 of the charter. Because then there are sections, the question is if the Board of Supervisors were to create a meeting body of some sort, well, that's a legislative branch, not the executive branch. And so you have to kind of decide in the charter, is it siloed, boards and commissions for the executive branch, and then you have other meeting bodies for other branches, and do they have the same application? That's really kind of the question before us. One last example is a training that I did for the Code Enforcement Review Committee of the Planning Commission, and it's a fairly large body, and when we started reading the Sunshine Ordinance, we couldn't get past 67.3 because they had just figured out that they weren't an advisory body. They were all appointed by the Planning Commission and thus subject to Sunshine as a policy body. So they had to change their entire operation into to operate as a policy body because of the way that they were created. So things like that show up from time to time. Okay, that's all I have on that. If there's Mr. Hillier, I know you're still here. If there's anything else you want to add to that, I'll allow you a few minutes time for that.
No. Thank you, Mr. Chair.
Yeah.
I'm a bit too tired to think of anything spontaneously at this point. Sorry.
Okay, great. Back to you. Thank you. Okay. Any other public comment?
Yes.
Go ahead.
Let me know when the timer starts.
Go for it.
All right. So I think one action you could actually do here, which would be quite helpful, is yes, to refer the concept or the issue of this general issue to EOTC. For example, you did this with metadata, right? It's not a specific complaint, but the entire issue, you need someone to go dive into it and figure out what the thing is and advise the full task force. So I would suggest that you make that motion and also make as part of that motion, a request for legal opinion from your DCA to basically have an index of the different committees and bodies the city has, and for at least their legal advice on under which classification they fall under, so you have some starting point. And so I do think you can actually make a motion or some action here that you can follow through on, even if it's not related to the specific complaint from the complainant. Thank you.
Okay. Thank you. You know what? I'll take that under advisement. I would think it could actually fall under compliance and amendments. It's a really kind of a compliance issue in a way. But either way, either committee could do it. If folks are open to wanting to make the referral officially, or you can leave it at my call, I'm happy to make the referral. It's really it's project, actually. But I think the task force needs to take it up. You're nodding your head, Member
I think
LaHood.
that sounds like a good idea. And I'm glad we got to hear from Mr. Hillier because he waited a long time.
Okay. All right. So I guess by not hearing any motion, we'll leave it to me to refer it to committee, and I'll do a little write-up to get the ball rolling. Okay? Great. All right. Let's call the next item.
Item number 13, file number 20072 per Board of Supervisors file number 200552, authorizing Sunshine Ordinance Task Force to meet in July 2020 and inclusive of Administrative Chapter 67, but not limited to Administrative Code 6730C as the Sunshine Ordinance. Hearing to consider the impact of emergency orders due to COVID-19, which resulted in temporary suspension of various provisions of the California Public Records Act, Ralph M. Brown Open Meetings Act, San Francisco Sunshine Ordinance, and other related laws and statutes that may apply within the jurisdiction of the Sunshine Ordinance Task Force. Public records requests delayed during the emergency, issues related to lack of meeting postings, lack of access to the meetings during the emergency, planning and standards for future emergencies.
Okay. Is there anything that people want to add to this?
I'll briefly talk about the email I sent to you, Bruce. That's okay?
Yeah, go ahead.
And this, just regarding lack of meeting postings, just through some, going through the websites and everything, I noticed that the Elections Commission hasn't been posting regular meeting minutes online for approximately the last year and a half. And so I'm open to it, or someone else can, but perhaps we can take a real quick motion to authorize one of us to contact the Elections Commission and urge them to post meeting minutes online. I think it's important, especially with the election coming up, that all that get up there.
Well, you're pointing out an actual violation. I would suggest that you, if we're going to do that, that a strong message be sent to them that the task force has noticed that they're in violation. They need to make a correction soon.
Right.
Like very soon. Like we expect a correction within 7 days.
Yeah.
We can't, if we find that there are blatant violations like that, I think it's well within our jurisdiction to take some action on it directly. And I think it's a great example, and it's trivial, but really they should be able to should be doing that. So I'd entertain a motion if somebody wanted to, with regards to that one, to get the ball rolling.
I would move to send a letter to the Elections Commission urging them to post any meeting minutes that have not been posted online within the next week.
And if you don't mind adding in there some language around that we're finding that we're noticing that they are in violation.
And then we're noticing their violation, be sure. And
I have a question. I just want to make sure I'm getting this motion right. Moved by Member Yankee to send a letter to the Elections Commission that they post their what agendas or meeting minutes?
Minutes.
Yeah, I see that. Yeah, meeting minutes online, and what else? You said something else after that.
Yes, and that the task force has taken notice that they are in violation.
And we can put 6729-2 if you'd like.
Right.
I'll go ahead and second that.
Yeah. We want them to correct that within 7 days.
Did you want? I mean, I'm happy to volunteer to draft a letter to send to Cheryl.
Sure.
To get the ball rolling on that. Sure.
That'd be great. Okay, so moved by Member Yankee,
Oh,
second by Member Pinsey.
Yeah.
Public comment.
Yes, please.
Hang on. Go ahead, sir.
I'm in favor of this motion, and if it's necessary, you can cite your authority under SF Administrative Code 67.30 subsection C, which does not require you to receive complaints from people like you do under public records. You have the authority to make referrals to a municipal office with enforcement power under this ordinance or under the CPRA Brown Act whenever you conclude that any person has violated any provisions of this ordinance or the act. So if I were you, I would cite this is what you would do if they do not comply. You don't have to go through all these hearings. You choose to, but you don't have to. Thank you.
And thank you for that reminder. Any other public comment? Okay.
Yeah, I'd also like to comment.
Hold on a second.
The
Hold
elections.
on.
Hang on.
Hold on.
Okay.
Let's get
Go
that
ahead.
clock.
I'm guessing the Elections Commission probably isn't, it's probably the worst offender in this case, but it's not the only offender. The Building Inspection Commission hasn't posted their meeting minutes since June. And I'm sure, if somebody went through that, they could find a ton of other cases where meeting minutes get posted late. And actually more concerning to me is the Small Business Commission. They do this thing where they don't post their agenda until maybe like an hour before. Sometimes they don't even post their agenda until after they have their meeting, which is honestly a lot more frustrating to me than not posting meeting minutes, because at least with meeting minutes, you can complain about it. Eventually, hopefully the meeting minutes will show up. But if the agenda doesn't get posted, I don't even know if there's a meeting going on or not. And there's just all sorts of things going on, like outdated links on websites and other cases where agendas don't get posted in a timely manner. And so yeah, there's a lot of problems with various committees and commissions. That was basically my comment. Thanks.
Thank you. Any other public comment? Okay, seeing none, let's call a roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion to send a letter to the Elections Commission passes.
Okay, thank you. Next item, please.
Item number 14, Administrator's Report, Complaints and Communications. We did get 2 communications from Anonymous. On September 3rd, right after the September 2nd, I want to point this out because it was right after the September 2nd task force meeting where Densha Tedeschi suggested that a more detailed form be provided for people to fill out because it might make their complaints a little more clear to them as well as people who are reading their information. And he provided like a 5-page document, which I included in the packet. So I wanted to point that out because it looked really quite substantial and quite good. I have my whole report here. Does anybody have any questions about anything? I will say, okay, so in the very beginning, as you can see, we have a schedule of committees that are going to take place. The next one being the Complaint Committee on October 20th. We're already starting to look at dates in January 2021. I know it's a little early, but Chair Wolf, I ask that you let me know when you want to have the orientation that we have annually at some point so that I can schedule that.
Right. We'll need to. We're going to definitely do that online, and we'll send out. I'll send out a kind of a maybe a doodle or something, or we'll send out
Agenda.
just not so much an agenda, but we need to figure out when everybody's available to do that. It is an orientation and a kind of an annual retreat for the task force to kind of pick up on issues and concerns that we have, and to develop some goals for the year, and that kind of stuff, and to just orient everybody around the ordinance, the process, how we operate, and then we can talk about optimizing modifications, things like that. So, all right.
No.
And unfortunately, we can't provide any refreshments because we're going to be doing this remotely, but usually we do.
The second item, petitions, complaints submitted. We actually only got one complaint. And then on Friday, I got like 6 new complaints by a variety of people. We're coming down a little bit in the number of complaints that still remain to be heard. We came down by 4. We were able to move them. And then I also included minutes from the last 2 committee meetings, the complaint committee and the compliance and amendments committee. And then we got a whole slew of emails from members of the public, people that are part of cases. We got 322 emails, in addition to the telephone calls that I take all the time, which is fine with me because people call me on my cell phone, so that's fine. I have no problem with that whatsoever.
Okay, great.
Anybody have any questions? I do want to recommend that everybody take a look at Anonymous's suggestion, because I think it's a good one. I think it's well put together. And perhaps we can discuss it at the next task force meeting after everybody's had a chance to read it. Or have you had a chance to read it, or what do you think? Do you want to comment or not? Or
I've not read it, and I think we would all like to read it.
More closely?
Okay. All right. Any questions or comments? All right. Let's open up for public comment. Any public comment on the administrator's report?
Sure, if you allow me.
Hold on.
Go ahead.
No, go ahead.
Yeah, this is anonymous, and this is regarding the thing I've sent you. It's on page 6. If you wish to look at it at some point of item 14, it is licensed to you under Creative Commons 0. So as long as you don't hold me liable, you can do whatever you want. You can tear it apart if you think some parts are useful or not. Do whatever you want. You just can't hold me liable, and there are no warranties.
Okay.
Please do consider it. Thank you.
Thank you. And thank you for using Creative Commons other than copyright. Okay. Any other public comment on the administrative report? Okay. Thank you very much, Cheryl, and for all the work that you're doing. We really appreciate it. Okay, let's call the next item.
Item number 15, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
The floor is yours, folks.
Anybody got anything to say?
I just want to say thanks for all sticking through it. This was a long one. It's never like this.
No.
Yeah.
Yeah, just the collection of cases today, it just turned out that way. So we're getting kind of backlogged. So getting some of the more challenging cases, sometimes they come in bunches, and this is where it happens. This is why trying to create some form of precedent is really important, because as these complex cases begin to come along, we can fall back on precedent, and it makes it easier to make a quicker kind of decision. You have a better understanding of it. Part of this also is the lack of ability to be able to do like a global search of all our previous decisions. And that's something that we've been struggling with for, since the invention of the internet. We are still awaiting patiently for the clerk's office to finish their work on a system and that we might be able to piggyback on. But I think in the meantime, we need to do something. All our orders of determination, which are decisions, they are online, on our website in PDF format. And I think there might be some kind of database where we can have it search all of them, and we could develop like some search terms and stuff. So, those of us who are tech savvy that know what to look for in these kinds of things, if you come up with any good examples or solutions, as I like to call them, send them up. We'll try them out, and then we'll bring it up in the IT committee and see if we can implement something in the meantime. That's open source, doesn't cost us anything, and it's really just a search, just a big search. That's it. So, and we all know what some of the search terms are already. So, all right. Anything else? Nope. Public comment?
I have a quick question, actually.
Sure.
I was just wondering if there's any movement on filling the other seats of the task force.
Yes. So the rules committee is either I think it's the rules chair. I think we're still reviewing the applicants' applications.
Victor should be able to comment on that. Victor's here. He could probably tell you. Victor?
I haven't heard anything from the chair regarding a date of hearing. It would be best to remind Chair Ronan's office, just so that they a little bit of pressure on them to move forward.
Yeah. The last time I had it for the current appointments, the last time we did speak about that when I spoke to Supervisor Ronan's aide about that. So they know that we need it done soon. They got very clear on, who's in what seat. They weren't quite sure how all that worked. So I kind of worked that through with them, and they're ready to go. They just need to schedule it. So hopefully soon. I don't really want to do the orientation until that's done, because then we'll have the full complement of the task force and, figure out who's here, who's not, that kind of thing. So we'll try to hurry that up along. If you do have items that you want to be covered in the orientation, please do forward them to Cheryl, and she'll get them to me, and then we'll make that happen. Okay. All right, great. Any public comment on this section? Anything that was discussed? Yes? Public comment? No? Okay. All right, let's move to the next item.
Item number 16, adjournment.
Is there a motion to adjourn? No, you want to stick around here till midnight?
I'll move to adjourn.
Move to my member Yankee. Is there a second?
Seconded.
That one of the newbies?
Member Wong.
Okay, good. There you go.
Member Wong, second. Okay. Welcome, everybody. Thank you, and have a good night.
I have the meeting ending at 11:29.
Thank you.
And Dean, that is not a record.
Okay. That's all right.
All right.
Thank you for warning me.
I tried. Good night.
All right.
Good
Thank
night.
you. Good night.